Audio test for the essay interpreters. Are you able to hear me? Are you able to hear me from the floor? Audio testing for the SI. Can you hear me? Okay, so testing, audio testing for the SI channel. Okay, testing again for the essay translator 3. Are you able to hear me?
Ready, able and willing, everyone here? Yep. Housekeeping issues. Council, anything?
I just want to report on the fact that the parties have made very good progress. I need to just fine tune a few details with respect to the program for Friday afternoon. We will report on that, I believe, at the beginning of the afternoon session.
And is the tribunal going to be pleased?
We are doing all we can to avoid the opposite.
Well, I'm very glad to hear that, and I thank council for their cooperative spirit. But no other housekeeping matters.
One small housekeeping matter, just to avoid any surprises. We have the rule in PO1, I believe it is, that witnesses are able to comment on developments which followed their last written submission. So as a result, our experts, our Serbian law experts, will comment on the two decisions rendered with respect to Dunavska 23, which were both rendered after the filing of their last report. They have, I don't know, 5-6 slides on these two decisions in their opening presentation.
And just to be sure, all of the documents that they're going to be commenting on are already in the record, presumably.
There is the documents, yes, and there are a few rules of Serbian law which are not in the record already. We will make an application. These are the rules of the Code of Civil Procedure of Serbia.
Thank you. I think it would be appropriate for you to make the application sooner rather than later, so that respondents have an opportunity to comment and we have an opportunity to decide rather than just on the spot. I do recall that there was another application that you were going to make, but presumably you've decided.
This is just a timing. All these applications will be filed today. The one for CPC provisions will be done before the experts appear this afternoon.
Right.
The remaining ones will be done probably after we end this day.
Okay, you might just, in making your application, because it'll simply ease the passage of things, have consultations with respondents' counsel. Because if you can make the application and say this has been agreed, and then respondent can just confirm that, that will make our lives a little bit easier. If it's a contested application, obviously it's going to require us to deliberate on that. So,
understood.
Respondent, anything?
If I may, I was just about to suggest perhaps the same thing. I mean, if there are 4 or 5 new slides, I mean, and for I understand later today, it might make sense if you can share them with us now. We can take a look and see whether there's actually anything in there that we want to object to, and we can take a look. I'm saying that without, of course, reserving all of our rights and not committing to anything, but I think it might help.
I don't think there were any admissions that were called upon you to make, but I think that would be helpful if this is new material rather than just do it in the mouth of the proceedings. If you can share them in advance, that would be helpful.
We will do so during the morning session.
So, and then let me then just say in response to what we've heard from you both, perhaps at the start of the session after lunch, before we hear from, depending on the timing on the witnesses, then we will have perhaps a little longer housekeeping discussion, so we can talk about Friday afternoon. Also, just to put you both on notice that at the end of tomorrow's proceedings, or perhaps during the course of tomorrow's proceedings, I would like to ask of both parties whether there are any issues of process arising out of this hearing that you wish to raise with us, so that there is an opportunity while the hearing is still ongoing to address those. In due course, no doubt, while we may be able to satisfy both parties with our award, the likelihood is that one or other side may be less than satisfied, but I want to make sure that there are no procedural gripes about the hearing. So I'll ask you about that tomorrow, and if there are sensible things to raise with us that we might reasonably address either in Friday's session or in the post hearings, then that's something. So I think then, without more ado, we have Mr. Ioannidis. And I think, have we received now? We received the presentation. And the examination. Mr. Ioannidis.
Good morning.
Good morning. Welcome. You've been sitting in the room. You know the drill. We're very happy to have you here. I think your testimony is the other half of the testimony that we heard yesterday. So we're looking forward to being further illuminated. You should have the expert witness attestation in front of you. If you could read that into the record, please.
Yes. I solemnly declare upon my honor and conscience that my statement will be in accordance with my sincere belief.
Thank you very much. I am going to hand you over to counsel just to take you through the formalities, and then over to claimants for cross-examination.
Thank you. Good morning, Mr. Ioannidis.
Good morning.
Could you just confirm for us that all of your 3 opinions that you filed in these proceedings are in front of you? And that the signatures are yours?
Confirmed.
Thank you.
There are no update issues. Do you want to ask whether there are any updates?
I wanted to ask, but I'm also aware that the expert will provide corrections in the presentation at the very beginning.
Okay. Thank you very much, Mr. Ioannidis. Over to you.
Thank you so much. Perhaps before I proceed with the substance of my presentation, I will give a brief overview of my qualifications. I'm a practicing advocate in Cyprus for 23 years. I hold a BA in law from the University of Cambridge. I've also been called to the bar by the Honorable Society of the Middle Temple. I'm a founding partner of the law firm of Hadjianastasiou Ioannidis LLC in Nicosia, Cyprus. The substance of my practice is corporate law and M&A. Over the years, I have advised clients on establishing, restructuring, winding up of corporate structures in Cyprus. And I have been advising company officers, corporate administrators, and trustees on their ongoing responsibilities. I was on the board of the Cyprus Securities and Exchange Commission. I chaired the Company Law Working Party of EU Council during Cypriot presidency back in 2012. I have been an active member of and chairman for a term of the Company Law, Tax Planning and Capital Markets Commission of the Cyprus Bar Association. I have lectured company law for a period of 17 years as lecturer and examiner of the Legal Council, which is the body responsible for licensing lawyers in Cyprus. I have also advised the government, have been advising the government for over 10 years for revisions and drafts of several legislative instruments. And I have also sat on steering committees of the Cypriot government on company law reform. Perhaps if we can look at the next slide, I have made some minor updates to some typographical errors that I found in my reports. I don't know if you want me to read them or taken as read. They're minor or not important.
I think we can take them as read unless there are any that need explanation.
Nothing to add.
Thank you.
Also, maybe this is a good point to state for the record something that's been brought to my attention during my preparation for this presentation. It has been brought to my attention that it appears that the Articles of Association of Kalemegdan Investments Limited were settled by my business partner, Gaston Hadjianastasiou. I have made inquiries on this matter. It seems that, firstly, let me state that to the best of my knowledge and belief, Kalemegdan Investments Limited or its principals have never been our firm's clients. It seems that back in 2012, we supported HLB Limited, or what HLB as Avxendio as it was back then, with company corporations, because only lawyers may incorporate companies in Cyprus. And it appears that we had been asked to draft the articles of the particular company. There's no records left in my office of that matter, given the passage of time and our company's document retention policies. Thank you.
And I assume from what you say that you had no hand in that process.
No hand whatsoever.
Is this the first time that that this issue is being drawn to the attention of the other side, or has this been notified to them previously?
I think, as far as I know, there was some document brought in the latest witness statement of Mr. Broshko that made this apparent. I don't know if it's been brought.
If I may clarify, Mr. President?
Yes, please.
This is a fact that's visible in document C708. So that's a claimant's document filed to the record. And in the course of preparation, the expert has reviewed these documents and came to the attention of that fact. So I believe the fact was known to the respondent.
And so let me just confirm that the fact was known and that you are not taking any formal objection or any point on this issue.
This point is the first point
In
of my
cross-examination.
cross-examination.
Okay, well, we'll leave it to cross-examination. Then you are on notice of the question you will get.
Thank you.
Please continue with your.
Okay,
with your
so going now to the substance of the presentation, as was discussed also yesterday, the respective legal opinions of both sides, experts on Cyprus law, covered two main areas. Firstly, the meaning of the term seat as used in the Cyprus-Serbia BIT, if this term was to be interpreted under Cyprus law. And secondly, whether certain documents, specifically 2 trust deeds and a letter of instructions, are by themselves or viewed together with certain additional evidence sufficient to establish the existence of a trust of the shares of Kalemegdan Investments Limited for the benefit of Coropi Limited. I think we are in agreement with my learned colleague, Mr. Georgiadis, that Cypriot law doesn't have a settled or a specific meaning of the term seat or edra, as the word is in Greek. And therefore, the definition and meaning of the term edra will depend on the instrument and in the context in which the term seat is found. Mr. Georgiadis has argued that seat, as used in the treaty, refers to a company's registered office. In my opinions, I have disagreed, and I consider that the term refers to a company's residence, that is, the place where the company is managed and controlled from. Mr. Georgiadis suggests that in the company's law, so as a first argument, he suggests that in the company's law, the 2 terms are used interchangeably. The term seat and registered office are used interchangeably. The second argument is that Cyprus is a common law jurisdiction which applies the incorporation test in establishing the seat of the company. As regards the interchangeable use, in my view, the term registered office or εγγεγραμμένο γραφείο is a separate, defined, well understood, and consistently used legal term under the company's law. I do not consider that the term is used interchangeably or having the same meaning as registered office, either in the company's law or in case law or otherwise. I consider that the examples used by Mr. Georgiadis do not support his conclusion and do not, in fact, use the 2 terms interchangeably. If I may go over some of the examples that have been raised by Mr. Georgiadis. The first one is section 354K of the company's law. During his cross-examination yesterday, Mr. Georgiadis suggested this is the best example that he can suggest. I consider that this is not helpful to Mr. Georgiadis' argument. The particular section refers to the redomiciliation or reincorporation of a Cypriot company somewhere else in another jurisdiction. This is done not by a mere transfer, but deregistration and reincorporation in the other jurisdiction. Therefore, the reference in point C that Mr. Georgiadis makes to establish the edra of the company in the particular approved seat or jurisdiction does not refer to a Cypriot company's registered office, but something, a place relating to a foreign company. Perhaps tellingly, the admittedly unofficial translation of the Cypriot Law Commissioner of the company law refers to the specific term, not as seat, but as head office. The Second example, and this is again something that was discussed yesterday, is the special provision of the companies law that was inserted for the first time in 1999, referring to certain exemptions of Cypriot companies that had some connection with the Turkish occupied area of Cyprus at the time of the the Turkish invasion in 1974. Mr. Georgiadis suggests that the reference there to ICSID is, and this is the first time that the term has been inserted in the company's law, means a registered office. I disagree. I set out a number of reasons in my opinions. Some of them are firstly that, as I said, the term registered office is known, well-defined, consistently used. There's no reason why the term ICSID should have been used instead. Secondly, in reading the word in context, what we are looking for is some sort of economic activity in the north and not just presence. So seat or place or business or whole of the property in the north, something that was really affected by the invasion and made the company effectively dormant, something that wouldn't apply to a mere registered office. And thirdly, the particular section, as well as the forms that support the section, the statutory forms, require evidence to be furnished to the Register of Companies. The Register of Companies, as your tribunal has already been made aware of, already has information on the registered office of the company and at any given time. So there would be no need for further notification or confirmation of the particular fact. The third example that was raised also in Mr. Georgiadis' cross-examination yesterday was the list of compulsory publicity information in section 365B of the company's law. In the particular section, which are basically things that need to be notified by a company to the Register of Companies so that they are publicly available. Mr. Georgiadis referred to point K, which is iota alpha in the Greek original, as a transfer of any seat, and he suggested that this is used interchangeably with registered office, whilst it appears that the immediately preceding point, point iota or J, refers to the details of the registered office of the company and any change thereof. In my mind, this is a clear indication that these are separate and independent terms. Similarly, in his opinion, Mr. Georgiadis suggested that the interchangeable use appears also in court judgments, in court decisions. And he refers to two cases, amongst others, a number of cases, but two specific cases is Omas and the Sartas case, which I set out in the slides here. If we may jump the next two slides. If we, okay, so this is the Sartas case. In both these cases, if we may go to the previous case, to the previous slide, yes. In both these cases, in my view, the wording of the judgments clearly show that these are two separate terms. In Omas, which is a VAT case, the court at first instance found that the meaning of seat in the original, in the statutory text meant the registered office, and this was challenged on appeal, and the Court of Appeal noted that the reference to seat does not merely refer to its registered office, to its, to its registered seat. It is a rendering of the English term seat in its wider sense, referring to the place of carrying on business. And similarly, in this Artas case, which is a case of local jurisdiction, which district in Cyprus, which court had jurisdiction in this case, and the plaintiff needed to show that the defendant resided or carried on business in the particular district, and no evidence was presented of either of those facts. The court said that in relation to the seat of the company, no evidence was provided in relation to the seat of the company and or its registered office. Again, treating the two terms as separate and different terms. In addition to the interchangeability argument that the terms are interchangeable, Mr. Georgiadis also refers to the so-called incorporation theory. He suggests that Cyprus is a common law jurisdiction which applies the incorporation test in establishing the seat of the company. We are in agreement with Mr. Georgiadis that Cyprus is indeed an incorporation theory jurisdiction, a common law jurisdiction applying incorporation theory. But we disagree that seat, where the test is looking for seat, and that a registered office has anything to do with it. The place, what we're looking for is the place, the country of incorporation, in order to determine the proper law of the company, the so-called lex societatis, the applicable law of the company. Mr. Georgiadis brings forth two authorities in support of his argument. One is a paper by Professor Alexandropoulou in European Company Law. And that extract says, according to the theory of incorporation, the applicable law is the law of the state where the company is incorporated and provided for in its articles of association. No reference to seat, no reference to registered office. He also relies on the EU Commission study for the law applicable to companies. And again, the relevant extract there, which I set out in my opinion, is that the incorporation theory refers to the place of incorporation, the country under whose laws the corporation was created. No reference to seat, no reference to registered office. From the perspective of common law, from Cyprus law perspective, the so-called incorporation theories test is referred to as the concept of domicile. I set out a reference to the textbook of J. Collier on the conflict of laws, which says that the personal law of the company is that of its domicile, which means the law of the place of its incorporation. I am mindful that in a previous arbitration in the MERA judgment, MERA Investment Fund Limited against the Republic of Serbia, the tribunal, on the basis of expert evidence provided by my late colleague, Mr. Alekos Markidis, indeed concluded that seat in the treaty refers to a registered office under Cypriot law. Looking at the text of the judgment, the following is the reasoning of the tribunal. The tribunal said Mr. Alekos Markidis goes on to propose that instead Cypriot law adopts the so-called incorporation approach to determining a company's lex societatis, and that as a result, a company seated in Cyprus is one that is incorporated and maintains a registered office in the Republic. I know that the tribunal does not refer to any Cypriot or other authority on which Mr. Markidis relied on. This is a position expressly relied by my learned colleague, Mr. Georgiadis. I respectfully to the tribunal in that case and to my late colleague, I disagree with this conclusion. As I said, the authorities do not support that the incorporation theory, looked at from a Cypriot law perspective, looks for seat or mentions registered office. Mr. Georgiadis also relies on two EU legal instruments, the Brussels recast regulation and also the insolvency regulation. Both these, if we may proceed, both these regulations are, in my opinion, not of assistance to my learned friend's arguments. I set out a number of points on that, in my opinion. Firstly, the Brussels recast regulations does not refer to merely seat, but it refers to statutory seat. That's a qualifier. Secondly, both documents have a specific purpose to make sure that there is a jurisdiction to commence proceedings. They are jurisdictional provisions. Both documents offer a range of options, not just a single place. The Brussels recast regulation, there is clear evidence, which I refer to my opinion, both from the textbook of Dicey and Morris, but also from the ICSID case of the House of Lords, if I'm not mistaken, in the UK, where it says that the concept of domicile is an autonomous concept, which should not be confused with the common law concept of domicile. So when the recast Brussels regulation refers to domicile, it refers to it only for the purposes of jurisdiction, and it's an autonomous jurisdictional concept and not the concept of domicile, which I have referred to earlier on. And in the insolvency regulation, I have noted that the registered office is only presumed to be the center of a company's main interest in the absence of evidence to the contrary, and such presumption will be displaced on evidence of management and control being elsewhere. So if seat doesn't mean registered office, what does it mean? I note that in my view, it doesn't mean registered office. As I said, the registered office is a well-known, certain and defined term, and it's not used. I consider that it means the reference to seat, it refers to a company's residence, that is the place where the central management and control actually abides. The concept of residence is one of the two common law private international attributes of corporations. The first one, which I referred to, is the domicile, and the second one is residence. You can see this particular rule from the Dicey and Morris authoritative textbook, setting out the two rules in sequence. First, the domicile of a corporation is the country under whose laws it is incorporated. And secondly, a corporation is resident in the country where its management and control is exercised. The concept of a company's residence was preliminarily developed in tax-related cases in England. The key authority is De Beers, where the court there said that the head and seat and directing powers of the affairs of the appellant company were at the office in London, from whence the chief operations of the company were in fact controlled, managed and directed. And the authority has been adopted in Cyprus, both in tax cases, but also in other matters such as exchange control, capital exchange control legislation. I have also noted that the company's residence is frequently referred to as the actual seat of the company. Mr. Georgiadis places emphasis on that for most of Kalemegdan's and Coropi's existence, the majority of directors were resident in Cyprus, and that meetings of directors took place in Cyprus, and concludes that according to Cyprus law, it is the directors of a company that exercise its management and control, not its shareholders. I have noted in my opinion that the fact alone that the directors of a company reside in Cyprus, or that board meetings take place in Cyprus, are not by themselves conclusive of the fact that the company is effectively managed in Cyprus. Case law provides that the place of a company's management and control is a pure question of fact to be determined, not according to the construction of this or that regulation or bylaw, but upon a scrutiny of the course of business of the company. And I also refer to the last state case, where the court there said there is no assumption that central management control must be found where the directors meet, and it is entirely a question of fact where it is found. This as regards the seat part of the opinions. I turn now to the trust question. I have considered the documents provided together with subsequent evidence submitted in witness statements. I think on the basic law, we are in agreement with Mr. Georgiadis that under Cyprus law, no formalities are required to create a trust. That a trust, in order to be found, needs to satisfy the three certainties. Certainty of intention, that there was an intention to create the trust. Secondly, the certainty of subject matter, and thirdly, the certainty of objects. And we are also in agreement that if a title to property is in the name of only one person, there is a presumption that that person also holds the entire beneficial title, the entire beneficial interest in the property, unless there is evidence to the contrary. As I noted, I looked at the letter of instructions and concluded that it is not helpful, as it does not clearly specify exactly what it is that Coropi is the alleged beneficiary of. It does not identify the basis of which Coropi, as alleged, is a beneficiary of any asset. And it is no way acknowledged by the actual shareholder of Kalemegdan share, Mr. Jura Obradovic at the time. I also noted the provisions of Regulation 12 of Kalemegdan's Articles of Association, which, in my view, do not allow the company to recognize the existence of a trust. To clarify, I'm not suggesting that this provision invalidates a trust if there is a trust. It merely is of no concern to the company and is not binding on the company. I have concluded, therefore, that the letter of instruction is not binding on Kalemegdan's directors and that it is not sufficient to establish that Coropi is beneficially interested in Kalemegdan or any shares in Kalemegdan. Mr. Georgiadis and I seem to agree on this point, saying that and Mr. Georgiadis confirms that the letter of instructions assessed on its own would not satisfy the evidential burden and that the letter of instruction was not intended to create a trust. Turning now to the two trust deeds. Again, I expressed the view that the trust deeds do not themselves create a beneficial interest in favor of Coropi. And I have set out a number of points.
You should say, I'm listening, I'm just making notes, so you don't need to stop if
It's,
you see
it's
what I'm
okay.
looking at.
All right, thank you. Firstly, I noted that there is no clear and equivocal declaration of any trust by the legal owner of the shares. In fact, in the document, it is only Coropi that makes any positive declaration. Secondly, Mr. Jura Obradovic, even though he is a signatory to this deeds, does not express in any words or in any clear and positive way his agreement to any of the declarations made by Coropi. Thirdly, the trust deeds themselves assume that there is an alleged beneficial interest from before, but it is unclear as to when and under what conditions. And I note also that although Coropi is described as the grantor in the particular deeds, it is not clear what exactly is it granting. It is not the legal interest and it is not the beneficial interest. So that is also unclear. Mr. Georgiadis seems to share some of my concerns, noting that there is some ambiguity as to where the beneficial interest in the initial issued share capital vested before the date of the first trust deed, and that if each piece of evidence is viewed in isolation, it is unlikely to rebut the presumption in respect of the period between 23rd March and 26th of April 2012. Mr. Georgiadis seems, however, to conclude that on the evidence of Mr. Broshko and Mr. Rand, that the evidence of Mr. Broshko and Mr. Brandt appear to satisfy the evidential burden that the Kalemegdan shares were held by Mr. Obradovic on trust for Coropi. I have considered the witness statements of Mr. Broshko and Mr. Rand, and I do not think they clarify a lot of the issues that I have identified. One of my concerns is that there is no clear declaration of trust by Mr. Obradovic, and the absence of such a declaration has not been remedied or satisfied by the said witness statements. And Mr. Georgiadis suggests as a fallback position that if there's no express trust and there is a constructive trust established from that date, I have noted in my opinion that constructive trusts are trusts that arise by operation of law, regardless of the party's intentions. There is no clear and all-embracing definition of what is a constructive trust. It may be imposed when a person holds property in circumstances where in equity and in good conscience it should be held or enjoyed by another. I have found no real argumentation or authority presented by Mr. Georgiadis on why a constructive trust should be imposed in the circumstances. And secondly, and equally importantly, why any constructive trust should be to the benefit of Coropi, who didn't previously own any beneficial interest in the shares of the Serbian companies and does not appear to have significantly made any contribution or acted in its detriment in any way. I have also brought to the attention of the tribunal the audited financial statements of Coropi for the financial years of 2012 and 2013, which are relevant, I understand, to the facts at hand, which do not seem to recognize any investments. The report of the board of directors for both financial years states that the principal activity of the company is to act as a holding company. However, during the year, the company remained dormant. It is my conclusion that on the basis of the letter of instructions and the trust deeds, there is no clear evidence that an express trust was created, and further, the evidence of Mr. Broshko and Mr. Rand do not appear to justify the creation of a constructive trust in favor of Coropi. And thank you. That brings an end to my presentation. Thank you for your patience.
Thank you very much indeed. That was very timely to the minute. Let me hand you over to our Claimants Counsel.
Thank you. Good morning, Mr. Ioannidis.
Good morning.
My name is Rostislav Pekas. We met yesterday. I am counsel for the claimants, and I will be asking you a few questions about your 3 expert reports and the presentation. And as I foreshadowed in my answer to Mr. Chairman, we will start by exploring the issue that you mentioned at the beginning of your presentation. And for these purposes, I would ask that document R132 is shown to you. Okay, so this document is, well, let's scroll through the document. This document is the Memorandum and Articles of Association of Kalemegdan Investments Limited. Incorporated, this is left blank. We have a partial translation which focuses only on Regulation 12. Then we, however, also have the translation of the signature page. And here what we can see here is I hereby certify that the above Memorandum and Articles of Association of the company have been drafted by me, signed Gaston Hadjianastasiou, advocate. So Could you please tell me, Mr. Ioannidis, when did you see this document first?
I saw this document when I submitted it in evidence. I believe it was in support of my first opinion, but I might be wrong.
Well, I would suggest to you that you must have seen it before you submitted it in
In
evidence, right?
preparation for my opinion, yes.
So how did the document come into your possession?
I would assume that if we can go to the, can you go to the Greek document? Go a little bit down. Yes. Can you go down to see if there is? I would assume that we asked for a copy of the documents from the Register of Companies.
Did you review the document thoroughly?
I reviewed the substantive clauses of the documents for the purposes that I was looking at it for.
Do I take from your answer that you are suggesting you did not review the signature page?
If the question is whether I noticed at the time that this was signed by Mr. Gaston Hadjianastasiou, I did not. I did not notice it.
Mhm.
If I may, I think the stamp I was looking for was the one right at the bottom. It says that a true copy was provided by the company's registrar on the 26th of September 2023.
Did you review the accuracy of the English translation of the document that was provided in this arbitration?
I can't remember. Perhaps I did.
You know, this is don't you find it curious that if you scroll back to the translation, the translation is a total of 2 pages, and quite frankly, 2 half pages. So it did not come to your attention that this was signed by your partner even when reviewing the English translation?
To be honest, it did not. If I had checked the translation at the time, I think the translation is also repeated in my opinion. I was considering the accuracy of the particular text rather than any other parts of the translation. I did not.
And so who handled the translation? Who prepared the translation?
Colleagues from my office. I would not know who.
And these colleagues from, when you say colleagues from my office, you mean the law firm where Mr. Gaston Hadjianastasiou is still a partner? Correct?
Yes, that's correct.
And these colleagues did not bring it to your attention that, look, this document was signed by...
It was not brought to my attention, no.
Mm-hmm. Were you a partner at this law firm also in March, excuse me, and April 2012?
I was, yes.
Did you derive financial benefit from the services that your law firm provided in connection with Kalemegdan?
I would expect that I did.
On the basis of your inquiries, what was the extent of your work for Kalemegdan?
As I said, I tried to make inquiries. We have no records. And so I talked to Mr. Hadjianastasiou to see if he could recall. He told me that at the time, we did support HLB, the accounting firm, with a registration from time to time of companies for their clients. The role of our work was purely agreeing on the draft of the template standard term of the Articles of Association and Memorandum, and executing those for the purposes of company incorporation.
When you state but if you look at what Mr. Hagi Anastasiou certifies here, let's scroll down to the second page. He certifies that the above memorandum and articles of association of the company have been drafted by him, correct?
That's correct.
So it's not only that he provided the template, but he drafted the actual articles, correct?
Let me clarify. What he told me is that a template memorandum of articles had been agreed between him and the particular accounting firm, and on that, on the basis of that template, the new registrations were done.
I'm not sure I understand the word template, because for me, template is something which needs to be filled in for it to make an actual document.
That's correct.
But here in what he certifies, he says that I hereby certify that the above memorandum and articles of association, so not the template of the above memorandum and articles of association, have been drafted by me, correct?
That's correct.
So did he draft the actual memorandum and articles of association or not?
In terms of practice, what I understand happened or was happening at the time is that the accounting firm prepared the documents on the basis of the draft which had previously been agreed. By filling in the name of the company, the details of the subscribers, this was presented to my colleague who had drafted the original memorandum and article template. He reviewed it and he executed it.
Okay, but by executing it, as you put it, he certified that actually he drafted, or he took responsibility, if I may put it in these words, for drafting the entire document, regardless of who inserted specific provisions.
That's correct.
Okay. And are you certain that this was the involvement of Mr. Hagi Anastasiou or your law firm with Kalemegdan?
As I said, I'm making this statement to the best of my knowledge and belief. It is based on the inquiries that I made with Mr. Hagi Anastasiou. Looking through our office records, unfortunately, we do not have any records dating from back then, given that it's 12 years ago, 13 almost years ago.
Do you have any records with respect to the extraordinary general meeting of Kalemegdan, which was held in April 2012?
No records.
Can you certify that your firm, or can you confirm that your firm was not involved in the preparation of the minutes from that extraordinary general meeting in any way?
As far as I know, not.
Did you ask that question specifically from Mr. Hagi Anastasiou?
I asked Mr. Hagi Anastasiou what was the extent of our involvement, and this is what I received.
Mm-hmm. Do you know a lady called Natasha Ioannidou?
I believe I do.
Who is she?
She used to work for HLB ICSID many years ago. I don't know if she's still there.
Mm-hmm. Is she related to you in any way?
Not as far as I know.
Okay. When did you stop working for HLP?
I do not know.
So,
and when you say stopped working for HLB, in what?
Well, okay. So I understand that your testimony is you became involved with Kalemegdan through your work for HLB. Correct?
That's correct.
Okay. Because you said at the time we were supporting HLB. Yes. From that, I deduced that you don't work for them anymore, but maybe that was incorrect. Yeah. So my first question is your law firm still working for HLB?
What I can confirm is that for many, many years, I do not think that we support HLB in any type of corporate registration of corporate matters. Other advice that we might be giving from time to time, I would consider that would be a privileged.
So when was the last time you provided did this type of services to HLB?
I really can't tell. If I may, the main relationship that we had with HLB was through the then partner, Mr. Kostas Avxendiou. Mr. Avxendiou has retired several years ago, 6-7 years ago. And although we still have a good relationship with the remaining partners and we know them, we don't have as close a relationship as we did in the past.
May I just sort of interject for a moment with Council's leave? Mr. Ioannidis, I think it'd probably be safe to say that if your law firm was providing advice, that the content of the advice would be subject to privilege, but the fact of advice, I don't think would be subject to privilege. So perhaps just repeating Council's question, can you say whether your law firm has been providing advice?
We have been providing advice over the years. I cannot say for sure what is the last engagement we had. I would expect some years ago. Not currently.
May we take it from that, to the best of your knowledge and belief, HLB is not one of your ongoing corporate clients?
As far as I remember, yes.
Thank you.
Thank you. Does your firm maintain a system for conflict check purposes?
Yes, we do.
And so when you do work like the one you did for Kalemegdan, how would that be recorded in the conflict check system?
How would that be recorded in?
The conflict check system that you maintain.
Yes, okay, so I will tell you in the specific case, a number of names involved in these proceedings were given to us by counsel.
No, I apologize, sorry. I meant with respect, how would you enter into your conflict check system?
Yes.
Your work that you provided for Kalemegdan back in 2012. I will come to your conflict check.
Mr. President, if I may interrupt, because I believe that the question refers to the fact that expert worked for Kalemegdan, whereas the expert clarified that the work was provided for HLB.
I didn't understand it that way. I understood the question to say when the instructions came in to Mr. Ioannidis, he would, in the normal course of events as a founding partner of his law firm, have undertaken a conflicts check to see whether there were any conflicts of interest. And I understood the question to be, what is the process of checking conflicts of interest? That's what I understood the question.
I apologize. I've been proved wrong. My question was not clear. I will rephrase my question. When your firm got the assignment which led to the drafting of the articles of association we have on screen in front of you, how would that assignment be recorded in your conflict check system?
Okay, so sorry, are we talking about the current account engagement or a previous engagement?
No, the one which led to the drafting of this.
All right, so we at the time had a project file on an online system, which since we have changed, unfortunately, and but we have kept most of the information. All the documents were filed in that system, but it was a single project file for the benefit having as client the accounting firm of Avxendiou. So searches for conflicts would go to the file and also look at the context of documents filed in the system. So the documents themselves are OCR indexed and they're searchable. As I noted, however, and as I found out through my search, We have no documents since then because closed files after 10 years are deleted. So we do not have any record of that service there. And that's why it could not have been picked up in conflict checks.
And so when your lawyers draft the articles of association of a specific company on the basis of an assignment coming from HBL or another service provider, the name of that company is not recorded in the system other than through the OCR?
Not as a specific engagement. It was a general engagement for the registration of companies with HLP.
So you do not consider that even though your relationship on a commercial basis is with HBL, the company is a beneficiary of your services?
I would think no. Our engagement was with ICSID. The company did not exist at the time that our services were provided.
The company did not. So, okay. So when did the company come into existence?
After its incorporation.
Would you agree with me that this is a very formalistic distinction?
Excuse me?
Would you agree with me that this is a very formalistic distinction?
You asked me if the company was the beneficiary of our services, and my response was the company did not exist at the time of that our services were given. So if I may elaborate, if I were to sue the company for fees, I would lose. There is case precedent on that. So
no, but okay. Now in I'll give you the reference. So, but before I go there, so basically you say that in your on your system, documents are deleted after 10 years. Do I recall that?
After 10 years, after the service.
So when did you perform your conflict check in connection now with this assignment?
It would have been 2023, September, October, August. I'm not sure when I was engaged.
So your conflict check basically can go only 10 years back from then. So September 2013, correct? Did it raise any red flag in your eyes that you were? Did it raise any red flag in your eyes that, or on your mind, that you were opining about matters occurring in March and April 2012, even though your conflict check system does not cover that period?
Our conflict check system covers all the period from our incorporation, from the start. We hold records of all our clients. So if Kalemegdan had been our client even in 2010 or 8, we would have found it in the system. The fact that we never treated Kalemegdan as a client, it wasn't something that we could have picked up. I don't think any red flags. Let me also suggest that at the time, dozens of companies were being registered in Cyprus every week by our office, and we never treated these companies as being our clients. We only treated the associate, the accounting firm or corporate services firm as our client rather than what ended up being a company.
Would you agree with me, Mr. Ioannidis, that a conflict may arise not only with respect to clients, a conflict of interest, I mean,
Can you elaborate, please?
Yes, well, for example, I'm just giving you an example. Under my home regulation, I would have a conflict of interest if I am to advise on the same matter, regardless of who my client with respect to that matter was at any given point in time. What is important is the matter, not who my client was.
The main duty of relating to conflict are to clients, or perhaps receiving confidential information in relation to client's business, or even a potential client's business.
But isn't it that you need to obtain? So look, I can tell you what my conflicts partners has drilled me. If I provide services with respect to, if I am to provide services with respect to a matter on which I worked for a different entity, for a different client, I need to obtain that first client's waiver. If I don't, I have a conflict of interest and I cannot work on it. Are you subject to a similar rule?
Can you repeat that, please?
Yes, if I work on a matter
Yes.
for a client,
Yes.
and then 5 years later,
Yeah.
I am asked to opine on that matter or work on that matter for, and my client is no longer the client from 5 years ago, I am able to take such an assignment only if I provide a written waiver from my historical client who agrees for me to work on that matter for some other entity.
I confirm that conflict applies not only to current clients, but also former clients.
No, but my question is, are you subject to a rule similar to mine, which would basically require you to obtain a waiver from the historical client before undertaking work on the matter for someone else?
For clients and former clients.
Yeah, so both parties need to be informed. Yeah, correct.
May I just perhaps at least assist in clarifying for my own purposes? Mr. Ioannidis, I mean, my understanding of conflicts of interests, insofar as, for example, they might apply to me, is that there are at least two forms of conflict of interest. There's client conflict and there's issue conflict.
Mm-hmm.
So if, regardless of the clients, you are steeped in a particular matter because you have advised in another context, you would be duty bound at the very least to declare your issue involvement. And I understand the question to be going to, in your jurisdiction, in your practice, under Cypriot law, is there issue conflict quite apart from client conflict?
I can't remember whether our ethics rules go into that much detail.
Okay, so had you noticed that Mr. Hagi Anastasiou drafted the Articles of Association at the time that you were preparing your expert report? What would have been the proper course of action for you?
To be honest with you, I do not consider, I would not have considered that there is a conflict, given that either than signing an agreed set of corporate documents for corporate for the company incorporation, Mr. Hagi Anastasiou had no other involvement in receiving instructions or involved in any other way in the particular company.
So you believe that drafting the Articles of Association of a company does not create an issue conflict with respect to you opining on the content of these Articles of Association and their interpretation?
I think the matter of interpretation of the articles as they stand is It's an objective exercise rather than has to do with
My question is different. My question is whether or not you are conflicted out from conducting that objective exercise.
I do not think that there is a conflict.
Okay. You stated several times, sir, that that was the only involvement of Mr. Hadji Anastasiou. I haven't asked my question, yes.
Yes.
But we have also seen that you have no records, or at the time you had no records from earlier than September 2013. So how can you be certain that Mr. Hadji Anastasiou's recollection is accurate? Because yours, and I don't say that to imply that Mr. Hadji Anastasiou did not provide the information to the best of his belief, but I assume that there must be hundreds, if not thousands, of companies for which he has done something similar to this. So how can you be certain without being able to conduct a conflict check with respect to other than the name of the client, for the period March, April 2012, of the extent of your involvement with, or your firm's involvement with Kalemegdan?
Because the particular file was only used for a particular purpose, for registering companies for HLB ICSID.
And did your firm make available any drafts of the minutes of the extraordinary general meeting of Kalemegdan held in April 2013, which could be where your firm's involvement could be seen, for example, from metadata of the document?
Can you repeat that?
Yes. Has your firm provided any drafts of the minutes of the extraordinary general meeting of Kalemegdan held in April 2012?
So after its incorporation?
Yes.
As far as I know, not. The particular file was only used for company incorporation.
Yes, but files from that period
Do not exist.
do not exist anymore.
That's correct.
So when you say as far as I know, that means without having had an opportunity to review my firm's files from that time period, correct?
That's correct. As far to the best of my knowledge, that's correct.
Okay. Mr. Chairman, we just reserve our right to make further submissions on this important point.
Well, I have one just further question for the expert, if I may, on this, and then just an observation to you, Counsel. Ioannidis, just a question, and forgive me if, as I was making my notes, I did not catch that this question was asked and answered already. When whoever it was who walked in the door to your law firm and requested that work be undertaken on the Articles of Association and Memorandum of Association, do you have any idea who that was?
Sorry, whoever
So
did
what I'm trying to establish is whether any of the putative officers of Kalemegdan, once it had been incorporated, whether they would have been the ones who walked through the door of your law firm and said, we would like you to assist in the drawing up. So Mr. Obradovic or anyone else on the conflicts check, the company did not walk through the door. It was an individual.
No, the only contact that we ever had was with HLB administrators.
Thank you very much. That's what I was assuming. Counsel, can I just make an observation? I mean, you of course have entirely reserved your rights, and we will hear you in due course. I am assuming, but you can correct me on this, but I'm assuming that your submissions in due course are going to be two issues of credibility and weight. They are not going to be two issues of challenge, because were there going to be a challenge, that would have been brought a long time ago.
Well,
I just want to make sure that we are not going to
No,
hear
I
this
understand,
witness
yeah,
and then you're going to
yeah.
try and get us to unhear the witness.
No, we will not try to
Okay,
do that, no.
thank you very much.
So, you know, that issue actually is connected to where I was going to go right now. If I may put it that way, where is your Declaration of Independence, sir?
I think it's in paragraph 5.5 of the first witness statement.
Thank you.
That's on page 10.
Yes, so that was precisely my point, because and there's a reason why I use the word independence, because the word independence does not appear in 5.5, correct? So if we can,
That's
yeah.
correct.
So you're only stating that you know of no conflict of interest, whether in relation to the parties to the arbitration onto their respective legal representatives, correct?
As far as 5.5 goes, the text is there.
You may want to have a look at 5.2 as well, and there's space between those.
Yes,
provisions.
yes.
Yes, so in 5.2, you refer to impartiality, correct?
That's correct.
But again, you do not refer to independence.
I used text that was suggested to me, most likely. So I'm not sure what the requirement had to be in terms of disclosing independence.
So isn't the Declaration of Independence a declaration of your own understanding of the relationship you must have with respect to the matter on which you are supposed to opine?
Let me clarify my statement. I used the text that I understood had to be included and was accurate when I drew it up. I didn't turn my mind towards independent. I drew my mind towards conflicts of interest, and I sincerely stated at the time that I knew that there were no conflict of interest.
I'm sorry, I was trying to see because
You may also wish to look at the concluding declaration. That's paragraph 9 on page 26. I solemnly declare upon my honor and conscience that my statements in this legal opinion are made in accordance with my sincere belief. That's obviously also going to be relevant to that construction.
Yeah. Okay. So your understanding is that you owe your duties to the tribunal and that you are to answer in accordance with your sincere belief.
That's correct.
Now, in your previous answer, you stated, and it's not well on the transcript, so that's why I'm just asking, because it states when I drew it up, I didn't, and then there's a missing transcript, conflict of interest, and I sincerely stated at the time that I knew that there were no conflicts of interest. So maybe to give you an opportunity to clarify that for the transcript, that was in answer to my question, isn't the Declaration of Independence a declaration of your own understanding of the relationship you must have with respect to the matter on which you are supposed to opine? So maybe just repeat your answer so that we have it clear on the record. When
you say my Declaration of Independence, you mean the statement I made of non-conflict?
Yes. So first of all, do you consider yourself to be independent?
I do.
Yeah. So what is your definition of independence?
I have no relationship with either of the parties.
So that's clear.
Mr. Bekash, I think we have the point, and I'm conscious that this has been now addressed for nearly 40 minutes. You'll make your submissions. Of course, it's your time, and feel free to continue in this vein if you'd like to, but we have the point. You can move on to the substance.
Thank you. So now I would kindly ask you to go to paragraph 8.4 of your second expert report. So there, just to make it clear, you accept that Cyprus is an incorporation theory jurisdiction, correct?
I do, yes.
And that means that under Cypriot law, the place of incorporation determines the proper law of a company, correct?
The place of incorporation determines the proper law of the company. That's correct.
And then in paragraph 8.5, you state, so there that that there is another theory, which is called the real seat theory, where the real seat determines the applicable law, correct?
Yes, I understand other jurisdictions apply the real seat theory in order to determine the applicable law of the company.
And if we go to 8.13, no, we'll go there in a second. It's 8.13 in your first witness statement.
Yes.
You do
Sorry, the first statement.
first, yes, sorry, that was confused me as well. Excuse me.
Yes.
And then at the end, you say that Greece, being a real seat theory state, has a different concept of the term seat under its legal regime in comparison to Cyprus, an incorporation theory jurisdiction, correct?
That's correct. I understand Greece has a civil law system.
Yeah. And so you do accept Mr. Georgiadis's argument that since both Cyprus and Greece use the same language, which is the Greek language, for two different legal systems, sometimes the same Greek word may have a different meaning in Greece and in Cyprus.
Yes, I accept that sometimes the same words can have a different meaning in Cyprus than in Greece.
And you also accept, just as a matter of fact, that Greece became a member of the European Union earlier than Cyprus, correct?
I do, yes.
And therefore, you would accept that the, let's say, settled Greek translations of terms used in EU legislation would be heavily influenced by the Greek legal system.
I do, yes.
And now, do you know, just out of curiosity, or did you inquire whether Serbia is a real seat theory or incorporation theory jurisdiction?
I did not.
So you did not deem that relevant for the purposes of your interpretation of the term seat as used in the bilateral investment treaty between Serbia and Cyprus?
I did not. I was only looking at the Cypriot law aspects.
So now I could take you to the specific provisions, but I believe you will agree with me that the term registered office is a well-defined term under Cypriot law, correct?
That's correct.
And every company incorporated in Cyprus must, from the date of its incorporation, maintain a registered office in the Republic, correct?
Recently, yes.
When you say recently, that means since when?
In the past, the obligation was to establish the registered office within 14 days from incorporation, but a few years ago this changed. I'm not entirely sure when.
Mm-hmm. And then, but there is no question, okay, there was this difference with respect to the start date of the obligation, but from that moment on, a company must maintain a registered office in Cyprus.
That's correct.
And a company which wishes to be deregistered in Cyprus and move somewhere else must also deregister its registered office in Cyprus, correct?
Can you repeat that?
Yeah, if a company wishes to move out of Cyprus,
Yes.
it must deregister its registered office in Cyprus, correct?
It must transfer its corporate registration from Cyprus to another state. That includes all aspects of its corporate existence.
Yeah, so can, including the registered office, correct?
Once a company is reincorporated somewhere else, then it will no longer have an obligation to maintain a registered office in Cyprus.
Okay.
Otherwise, it is entirely deregistered. The company is entirely deregistered from the register of the company's registrar.
Yeah. Can a company registered, let's say in Greece, have a registered office in Cyprus?
Can a company registered in Greece have, no, it will have a place of business in Cyprus, a branch, not a registered office.
Yeah, and when I say registered, we all are in agreement that that means registered in the registrar of companies in Cyprus, correct?
When you
With
say
respect to Cyprus.
registered in relation to the company or registered in relation to the office?
No, what I mean is when we were saying that a company incorporated in Cyprus must maintain a registered office, that means an office registered with the registrar of companies in Cyprus.
As I note in my opinion, there is a dual obligation. One, to maintain an office, to have an office in Cyprus, which is a substantive requirement. And secondly, to notify the registrar of company of the location of that registered office.
And an office is registered when the registrar receives that information and makes an according inscription in the company's registry.
It is called a registered office.
I'm not sure. So what is it?
So the term is registered office, and it refers to the office of the company which has a specific functions. The location of the registered office is notified to the register of companies.
Can there be a registered office which is not notified?
Presumably.
But how is the registered office then registered if it's not registered?
Let me give you an example. Once a company changes its registered office and notifies the registrar of the change, the previous registered office continues to the previous address of the registered office continues to be considered as a registered office for a month.
Is that the only example which comes to my mind of a situation where the registered office may be somewhere else than what was notified to the registrar?
The general obligation is to notify the registrar of the place of the registered office.
Mm-hmm. Now, I also believe that we can agree that the term seat is not defined in the Cyprus Companies Law, correct?
That's correct.
And then, and therefore, the term seat, according to your own opinion, does not have a settled or specific meaning in Cypriot law. And your opinion is that its definition in any specific instrument ultimately depends on context.
That's correct.
And so it follows from that the meaning of the term seat will vary depending on the context in which it is used, correct?
That's
and
correct.
you may refer to Article 832 of your first report.
That's correct.
And in fact, you explained there I may have the reference wrong, but
If you could repeat, it's 822 of my first or second opinion.
first?
Third,
I think it's at 8:32.
8:30.
Yeah.
Thank you.
That's not clear that that's the correct reference.
No, sorry, I don't have the right reference. Give me a second. Oh, maybe you'll be able to answer out of your memory. I recall reading in your opinion that they are. Yeah, so it's 8:12. Sorry, there was a typo in my
Of the first opinion,
of the
right?
first report. Yes,
Yes,
where you state that there are approximately 130 laws and more than 150 regulations, both in force and repealed, which use the word EDRA with various meanings. Correct?
that's correct.
And then, so we could say that really the number of various contexts and therefore definitions of the word EDRA is very high.
Yes,
And then in paragraph 813 of your report, you further state that additional uncertainty is created by looking at the dictionary definition of the word seat. And then you go on to explain how the, again, Greek and Cypriot definitions may be different, correct?
that's what I'm referring to in 8:30.
Yeah. So in this big variety of contexts, from this wide variety of contexts, you try to interpret the term seat in the specific context of the treaty between Serbia and Cyprus, correct?
Yes,
And this is what you explain in paragraph 820. Again, of your first report,
yes,
where you say, for the purposes of this legal opinion, I will apply a contextual approach to the interpretation of the term seat, having in mind the object and purpose of the relevant text. So this this one sentence, rings a bell to a public international law lawyer. And are you interpreting the term seat under the rules of interpretation set out in the Vienna Convention on the Law of Treaties, or under interpretation rules proper to Cypriot law?
I'm interpreting the term seat as if it were in a Cypriot statute, so under Cypriot rules of interpretation.
Where do you set out the Cypriot rules of interpretation in your expert report?
I did not.
You state here that you have in mind the object and purpose of the relevant text.
Mhm.
Where do you set out your understanding of the object and purpose of the relevant text?
I looked at the relevant text of the treaty and also considered the preamble of the treaty.
No, I mean, where in your opinion do you say what the object and purpose of the relevant text is in your opinion?
I'm not sure. I might not have.
Okay, so now, would you be fair to say that in your interpretation of the word seat, you rely mainly on the concept of residence, which was developed in tax treaty or legislation and core decisions.
Yes, as I noted also in my opening presentation, the particular term is one of the two private international law attributes of corporations under common law. And it was predominantly developed in tax-related cases.
Yeah. So this is actually what you state in paragraph 8.24 of your first report, correct?
That's correct.
The term residence is not used in the bilateral investment treaty that you are interpreting in accordance with the Cypriot rules of interpretation, correct?
No, it is not.
Could we please have a look at the treaty, which I believe is C007?
7A.
7A, right, the corrected translation. And if we look at the preamble that you reviewed, does it say anything about taxes?
It does not.
Mhm. And then if we scroll down, so let's just look for where taxes may be mentioned in this treaty. So we can scroll down to the substantive provisions. Further down to the most favored nation clause. And here, if we look at clause, so we are in Article 3, paragraph 3, we can see the treatment granted under paragraphs 1 and 2 of this article shall not be construed so as to oblige one contracting party to extend to the investors of the other contracting party and their investments the benefit of any treatment, preference, or privilege resulting from. And now if we go to letter B, we say any international agreement or arrangement relating wholly or mainly to taxation or any domestic legislation relating wholly or mainly to taxation. Can you see that, sir?
Yes, I do.
So wouldn't this suggest to you that this treaty actually sets out specific exemptions with respect to taxes, in the sense that certain standards of protection are specifically excluded with respect to taxation matters?
My reference to residence, rather the reference that the concept of residence was developed predominantly in tax cases, does not did not imply that residence is purely a tax-related concept. It is a concept used more widely, and in other matters in which economic activity is of relevance.
Mm-hmm. But now, for example, if we look at the case law that you use to show your definition, your proposed definition of the term seat, would you agree with me that the case law actually is predominantly relating to tax matters?
I do agree. I also referred to a Cypriot court decision in which the term residence, as developed in De Beers, was discussed in the case of exchange control legislation.
But now, if you look, for example, at your third expert report, and you may wish to refer to paragraph 5.8.
Sorry, which paragraph again?
5.8 of your, no, sorry, second.
Mhm.
No,
Yes,
no, it's. No, it's your third opinion actually, but I now notice that it states second. Yeah, sorry, I just noted it right now on the top of the page. You left second legal opinion, so sorry, that's what confused me.
Which one are
Yeah,
we looking
But it's
at?
the third one. 5.8,
sorry, 5.8,
yes.
in which opinion?
In the third, the header states
Yeah.
second, but that's a mistake. And there in 5.8,
I'm confused. Is it the one up on the screen?
yes, it's the one up.
Okay, thank you.
Yeah, okay. And here you refer to the English Court of Appeal in its judgment, Development Securities PLC and others versus Revenue and Customs Commissioners from 2021. And you state that the English Court of Appeal has recently considered the case law concerning the central management and control of a company and has summarized the principles as follows, correct?
Yes.
So that would be done for tax purposes.
Yes, in this case, the point that I was making was that Mr. Georgiadis suggested that even if seat did mean residence in the sense that management and control should have exist, then this was satisfied by the mere presence of the directors of Kalemegdan in Cyprus. And I just wanted to point out that, at least for tax purposes, management and control was defined in a wider way. There was no presumption that, or rather the fact that directors resided or deliberated in a country was not conclusive of the question of management and control. Rather, it was a wider fact-finding exercise.
Mm-hmm. Well, you qualified your answer by referring to tax purposes, correct?
I refer, sorry.
No, because
yes, I referred to a tax case which discussed the concept of central management and control.
Yes, and the tax case discussed the concept for the purposes of a tax dispute, correct?
Yes, although this is in the context of determining a company's residence.
And then if we go just to the following paragraph in your third legal opinion, you refer to another tax case, Lear State BV versus the Commissioners for Her Majesty's Revenue and Customs, correct?
That's correct. As I already mentioned, the concept of residence and management and control is predominantly discussed in tax-related cases.
Yeah. And you have submitted no evidence to suggest that the sometimes fine points of determinations made by tax, by courts deciding tax matters are then accepted as they are by courts which opine on the definition of residence for other purposes.
I lost you. Could you repeat the question from the beginning, please?
Mm-hmm.
Apologies.
Yeah. Have you provided any evidence which would show that the interpretations of the term residence in tax matters is then accepted and used by courts opining on the definition of residence in other than tax matters?
Yes, I did. I presented a case, a Cypriot case, on exchange control matters.
When is that case from?
Several years ago. I'm not sure of the exact date right now. I need to.
Yeah, does that case refer to, for example, the Court of Appeal judgment in Development Securities PLC that you mentioned in
No,
Article
no, it does.
5.8?
It does not. It refers to the De Beers case.
Yeah, so we just do not know if in the context of exchange control rules, Cypriot courts would, follow the jurisprudence that keeps developing in the United Kingdom with respect to tax matters, correct?
I would say that the concept of central management and control is a concept tied with the concept of residence. So if one is looking to determine residence for whatever purpose, the central management and control test would be applied by the court, and I see no reason why it would not be.
Okay, we are scheduled to have a break at 11. I think it's appropriate to break now.
Thanks. Before we do, I'd just like to raise a point with the witness, and counsel may wish to reflect on the point. Mr. Ioannidis, as we had yesterday with Mr. Georgiades, we now have from you this reference to a number of English court decisions. I mean, for this tribunal, English law is a fact. It's not law, even though I and perhaps others are qualified in the United Kingdom. I'd just like to be sure the basis on which you are testifying on these English court decisions, because you haven't said, unless I've missed it somewhere, you haven't said that these English court decisions have been followed by any Cypriot decisions. You are just giving us the reference to the English court decisions. But you perhaps, and I forgive me because I have in mind that you are a member of Middle Temple, but I think you are also called to the bar in England. Is that correct?
Just called, yes.
Just called. So you're not practicing there, but yes. You are not testifying here as an expert in English law.
No, I'm not.
So can you tell us whether these English court decisions have been followed, adopted by Cypriot court decisions?
Okay, I can respond as follows. Firstly, and I note this in my first opinion in paragraph 6.2. Cyprus, being a common law jurisdiction, adopts the common law and doctrines of equity unless some express provision has been made subsequently in statute. So the practice of Cypriot courts is to adopt or consider as persuasive judgments of the English courts. They are not binding in Cyprus, but they are generally accepted unless there is a reason otherwise.
Yes, my point, I think, is a more forensic point, and that is that I accept entirely that the Cypriot courts may look to English court decisions for guidance. You are referring us to a number of English court decisions. De Beers, I think, goes back to 1906. As with all of these things, and we see this certainly in the personal sphere, I'm less familiar with the corporate sphere, the law on domicile is changing from government to government as they wish to raise taxes. So I think the import of the question that was put to you by a claimant's counsel, and certainly it's a question that I'm putting to you, is to what extent can we simply, as a tribunal that addresses English law as a matter of fact, we are not being given expert evidence on English law, to what extent can we take these English court decisions that you are putting before us and say, yep, this is bankable, this is what Cypriot law is? I, for one, do not feel comfortable about making that leap. So perhaps you could assist me.
Yes. Two points on that question, sir. The 1906 case, the De Beers case, I have actually mentioned that this was adopted by the Cypriot courts, specifically regarding that. On the more general side of the question, my response would be that if there was some statute that actually changed the reason or the basis for some interpretation, I should, me or Mr. Georgiadis should present it and say the government or the legislator changed the course of this. Otherwise, if we're basing ourselves in general common law, then there is no reason to depart from the English common law cases.
No, I do understand that there's no reason to depart from the English common law cases. I'm just not resolved in my own mind that the brief references to a handful of English law cases is sufficient for us to take comfort on what English law is.
Yes, it is true that we have not expanded on the general matters of English law, but I see no reason why the specific extracts that we did refer to would not be adopted by Cypriot courts.
Thank you. Councillor, before we break, I don't know whether there's anything in this exchange that you would like to pick up? No. Well, then let's take a break, and I propose that we reconvene at 11:30. And Mr. Ioannidis, you know the drill. You can't speak to anyone, including yourself. Thank you.
Thank you.
Okay, do we have everyone who needs to be here? Are we waiting for Mr. Keller? Do we start without him?
We would be happy to start without him.
Okay, let's just give it a minute or so. Anne-Marie, you ready? Okay, let's make a start.
Okay. Just to follow up a little bit on the tax issues, and then we will move away. Mr. Ioannidis, are you aware of the fact that both Coropi and Kalemegdan were filing their tax returns in Cyprus?
I was not aware. I saw some reference to that in my colleague's opinion.
Mm-hmm.
Or in some witness statement. I can't recall where.
And I take from your answer that you also are not aware of any instances of either the Cypriot tax authorities claiming that they should not file them in Cyprus, but somewhere else, or of the authorities of another state claiming that they should file their tax returns in that other state, correct?
If you're asking me factually, if I have any information, no, I don't.
Would such information have been helpful for your analysis whether the Cypriot claimants have their residence in Cyprus?
It would not. I did not consider any facts or come to any conclusions on this matter, but merely stated my view of the law.
So you do not try to apply the law to the facts of this case, in your opinion, correct?
No, I did not.
Yes. So now let's explore a little bit the meaning of seed in one provision, which sort of caught my attention because you put it also into your presentation. And this is the provision of Article 354K of the Companies Law, and we may address it from your slide. You help me to find the appropriate.
I don't have a copy.
Oh, you
of
don't
my
have it anymore. Okay.
presentation here.
I believe that it is slide 18. No, sorry. It's not slide 18. That slide doesn't appear to have a number. This slide. Our seat and registered office used interchangeably. It would be 8. The number doesn't appear on the printout, but it's slide 8.
I think they're on the bottom.
Yeah. Yeah.
Just a little bit, so.
Yeah, okay, maybe it's
Oh,
a
perhaps
printer issue on my
perhaps
copy.
they start on that page 9. Oddly enough.
I was really unlucky. Okay, so that is the provision. You referred to that also during your opening statement.
That's correct.
And so this is a provision which relates to application for the registrar's consent for the continuation of the company outside the Republic, correct?
That's correct.
And I believe you explained that this is a provision which comes into play when a Cypriot company wishes to continue its existence in another jurisdiction, correct?
That's correct.
Yeah, and there is a list of documents which need to be submitted for the company to be deregistered in Cyprus, correct?
Yes, that's right.
Yeah, and so this letter C is one of the documents which need to be provided to the registrar in order to effectuate the deregistration, correct?
It's part of the information.
Yeah, okay. Well, it says that the application shall be accompanied by a statement signed by at least 2 directors. So there has to be a statement providing the date on which it is proposed to establish. And now comes the question, correct? So we are on the same page. Yeah?
We are.
So the directors of such company, which is moving away from Cyprus, are requested to provide certain information. And you, in the original, the expression is EDRA, which is translated as the head office in what I understand is the unofficial translation by the law commissioner, correct?
That's correct.
So first of all, do you agree with this translation of EDRA as head office in this context?
Can you repeat that, sorry?
Yeah, do you agree with the translation of EDRA as the head office in the context of that provision?
If I agree, if it's the correct translation?
Yes.
Either words could be used. I mean, the translation could have also been SID.
Mm-hmm. Yeah. Could the translation also have been registered office?
I think not.
Okay, so just one, I'm trying to see how this would work. So let's assume that we have a company which transfers from Cyprus to another incorporation theory country, like Malta, for example.
It wouldn't work within Europe because it's a different process. But let's say UK, if it works
Yes.
there, I don't know.
If I might say, unfortunately, yes. Or let's say Canada. Yeah. You state that this can be translated as seed, but not as the registered office. So a company moving from Cyprus to Canada would have then its registered office in Canada, correct?
Presumably, I'm not familiar with Canadian law, but if Canadian law provides for a registered office, then presumably.
It would not have necessarily its seat in Canada, would it?
Again, I wouldn't know, presumably.
Yeah. So then, if the term,
sorry to interrupt. When you say its seat, again, it's questionable what you are referring to having its seat in. It's a matter of interpretation. I don't know the Canadian legal regime. If the Canadian legal regime provides for registered office, I assume that they would be establishing a registered office in Canada.
well, would you suggest that if we use the word seat in this translation, the term seat would have the same meaning as the one you propose the term seat has in the BIT?
No, I do not think that that's the wording here.
Okay, so here the seat would also encompass a registered office in the case that the company is moved to a jurisdiction which provides for registered office.
My point here is that this term does not correspond to a Cypriot company's concept, and therefore it would ultimately depend on what the other jurisdictions requires. And this is why a more general term is used.
Okay, so here EDRA is used in the meaning which can be registered office, it can be seat. What else can it be?
It could be headquarters.
Headquarters.
Depending.
Mm-hmm. So here EDRA has a very broad meaning, correct?
Ultimately depending on the foreign jurisdiction's regime.
And the meaning here could be registered office as well, but not only.
Not registered office as understood under Cypriot law, if it would be a matter for a foreign regime's requirements.
But it could encompass the foreign equivalent of Cypriot registered office, correct?
Presumably.
Is there any register for seats maintained in Cyprus?
No.
But there is obviously a register of registered offices, correct?
Yes. There is not a separate register of registered offices. There is a register of companies. And one of the requirements there is the registered office.
But there is no requirement to register the seat of the company.
Again, depending on the meaning of seat.
Okay, so if the meaning of seat is the same as registered office, then the seat has to be registered, correct?
The registered office needs to be registered.
Yeah, exactly. But if the two are equivalent, then we necessarily come to
I
an
am
equivalent
suggesting
outcome.
that they are not.
Okay. So no, because you said that depending on what seat means, it has to be registered or not. So could you give me an example of when the seat has to be registered if it does not mean registered office?
Okay, for example, a foreign company maintaining a seat abroad, establishing a place of business in Cyprus, would need to notify its foreign seat to the Cypriot company's registry. It doesn't mean that that company has a registered office abroad. It has the equivalent, a concept that their originating law provides for.
And would a Cypriot company have to register its seat if seat means something else than registered office?
A Cypriot company would need to notify if it reincorporates somewhere else.
But as long as and we saw that one of the consequences of reincorporation is that the Cypriot company no longer, or originally Cypriot company, no longer has a registered office in Cyprus.
Correct. But if it reincorporates, it first needs to notify and then proceed with
Yeah,
reincorporation.
yeah, we have just seen the provision. Actually, we see it still. But then would it be fair to say that a Cypriot company that has a registered office in Cyprus still in no circumstances needs to register its seat, correct?
If it is a foreign company,
No, I said Cypriot company.
a Cypriot company, yes. The requirement is to notify the registered office.
So now let's look at specifically at the issue of the control and management. And we may look, for example, at paragraph 5.7 of your third report. And you state there, the place of a company's management and control is a pure question of fact to be determined, not according to the construction of this or that regulation or bylaw, but upon a scrutiny of the course of business and trading. Do you agree with that proposition?
That's correct, yes.
But you have not conducted this factual analysis with respect to Kalemegdan and Coropi, have you?
I have not.
Sorry, I didn't.
I have not.
But you would agree with me that as a matter of law, what matters is the facts of management and control, and not necessarily if someone has a right to control but does not exercise that right.
I'm not sure if I follow the question. I would say it is a matter of fact. It is a matter of looking to the facts to determine whether indeed where was management control actually exercised.
No, but look, I can give you an example. I may have a company in Cyprus, which has, and it's a hypothetical example, which has Cypriot directors, and I may have a right to direct the actions of the Cypriot directors. And then I just let the managers manage the company. I don't exercise, I have the right to tell them, do this, do that, but I just do not tell them, do this, do that. Would you agree with me that under the proposition that you agree with, and which is set out in paragraph 5.7 of your third opinion, What matters is the fact that the directors are managing the company independently because of lack of instructions coming from my part, and not the fact that I have a legal right to give these instructions, but I don't use that right.
I would repeat that it is a matter of looking at all the evidence, at all the facts, including the way that the directors actually exercise their powers.
Yes, but so in the hypothetical I've given you, and you know, this is a hypothetical. I have the right to direct their actions.
I
For
would
10
have-
years, I don't issue any
I would have many
instructions.
questions to the hypothetical. Where does this right derive of? Is it on important matters? Have important matters come up and the directors took decisions or not? It is a very general hypothesis, and it's
No.
difficult to reply.
Well, no, my hypothetical on the last point, at least I can satisfy you. I have issued no instructions whatsoever.
Sorry?
In my hypothetical,
Yes?
I have issued no instructions. In a given period of time, I have not issued any instructions.
I would repeat that it is a matter of whether directors took important decisions independently without any external interference would be a relevant fact.
And okay, so let's say there were no important decisions to be made during that time period. There were only, I don't want to disqualify them, but let's say regular decisions such as filing tax returns, and otherwise it, you know, nothing much was happening for 10 years. And all of these decisions were taken by the management of the company or the directors of the company, to be more specific, without any instructions coming from me.
You are asking me, sir, to be a fact finder, and I find this a bit difficult given my position. I have tried to avoid
No, I
making
respectfully,
findings of facts in my.
I respectfully disagree. I'm giving you a hypothetical to see how the law operates. I'm trying
Yes.
to explore the practical meaning of the legal rule that you agree with and set out in Article 5.7. So I'm giving you a hypothetical, and I appreciate that you need additional information. That's why I'm trying to provide that information. So I have a company for 10 years. I have a legal right to direct or issue instructions. I don't issue any instruction during the 10 years. And the only decisions made during these 10 years are filing of tax returns and financial statements.
Again, I think my previous answer covers it in the fact that it would be a relevant fact to be taken into consideration when considering all the facts of the case.
Okay, right.
Just a quick question from me, Mr. Ioannidis. In 5.7, the quotation there is reference to the De Beers decision in 1906.
Yes.
And you said a moment ago, and forgive me for not having this in the forefront of my mind, but that you have said somewhere in your witness statements that the De Beers judgment has been adopted and reflected in Cypriot law. Could you just point us to the case or cases in which that has been?
Yes, if you would give me a minute, but I would like to clarify that the De Beers has been adopted on Cyprus law on the test for residence, that management and control, not the details.
Okay, well,
the particular details.
Then my question to you is a slightly different one. This quotation, which says management and control is a pure question of fact, is that reflected in Cypriot judicial decision?
Yes, it is.
Could you give me the judgment, please?
I don't have any.
So you haven't addressed that in your witness statement?
I haven't addressed it, no.
Okay, thank you very
Yes.
much. But it's your expert testimony that it has been, but you haven't addressed it and you don't
Yes,
have any
the
citation.
courts in Cyprus would consider all the facts of the case.
Thank you very much.
Yes.
Mr. Ioannidis, do you also opine or not on the question whether the Cypriot claimants have their registered office in Cyprus?
I did not.
So let's now move to the trust issues. So in your first report, paragraph 7.4, you explained that trust under Cyprus law can be both express and implied, correct?
Expressed, implied, or resulting.
Yeah. And in paragraph 7.5.
Excuse me,
Yeah, sorry.
sorry, can I clarify? Express, implied, resulting, or constructive.
Yeah. And then in paragraph 7.5, and we may put that, yeah, we have it on the screen. You confirm that no formalities are required to create a trust, correct?
That's correct.
Is there any authority on record to suggest that the creation of a trust over shares in a company is dependent on the company recognizing the trust?
No.
And in fact, I believe you do address that point in your opinion in connection with Article 12 of the Articles of Association that we have seen on the screen,
Yeah,
correct?
I mentioned this also in my introduction, that whether a company recognizes or not a trust relationship is of no, that does not affect the existence or not of the alleged trust.
Nice. So now, please go to document C319. Because just for context, I understand you were not asked to opine on whether Kalemegdan and Coropi have their seat in Cyprus or whether they have their registered office in Cyprus. There you did not look at the application of the law to the facts, but you were asked to look at the application of the law to the facts of the trust relationship with respect to the shares in Kalemegdan, correct?
Yes, initially to interpret the particular documents or try to.
Yeah, okay, so with respect to the trust issue, you did look at the
Yes.
specifics of facts of this case. With respect to the seat registered office, you did not, correct?
That's correct.
Okay, so what we have here is an internal letter of instructions dated 26 March 2012, which was from Coropi Holdings Limited as the beneficiary to measures Michaelides, Sarantis, and Vrachas in Kalemegdan, correct?
What's the question?
No, just to confirm that.
Yeah, it
this is
appears
the-
this addressed to these three individuals, yes.
Yes, and it states that it relates to Kalemegdan Investments Limited, the company, and that it states that by this letter it is certified that the directors should always obtain instructions, directions, and written consent from Coropi Holdings Limited, the beneficiary, for the implementation of administration and fiduciary services, correct?
That's what it says.
Yeah. Now, what we see here is signatures on the bottom of the page, and then if we scroll down further down, we see that each of the three directors to which this letter was addressed signed the document. So the directors showed their acceptance of the letter, correct?
It says there, we have read the above letter and accept the above terms and conditions set out there.
Mhm. Yeah. So that letter was sent at the time your partner was providing services to HLB with respect to Kalemegdan. Did you ask your partner whether he has any knowledge about this document?
I did not, and as I said, the services were provided to HLP pre-existed the incorporation of the company.
Well, sir, to the best of your knowledge.
To the
correct?
best of my knowledge,
Yeah.
yes.
And the best of your knowledge means without you having had the benefit to look into the file with anything predating September 2013, correct?
That's correct, but yes.
We can see that there is no signature by Mr. Obradovic, correct?
Correct.
Do you know whether Mr. Obradovic was a director of Coropi at the time?
I cannot remember, to be honest.
I represent to you that he was.
Okay.
So as a director of Coropi, which, and if we go up, we see that this is a letter which is sent by Coropi. Is it reasonable to assume that he was aware of this letter?
Perhaps, I cannot be certain.
And are you aware that Mr. Rand was also a director of Coropi at the time?
I think so. I can't remember exact timings. I would look at it to refresh, but if you say so, I have no reason to doubt it.
So again, is it reasonable to assume that Mr. Rand was aware of this letter at the time it was sent?
Again, I wouldn't know.
Yeah. Well, have you reviewed the witness statement of Mr. Rand submitted in this arbitration?
I did.
And he does address this letter, doesn't he?
Please remind me. I'm sure that he does. I can't remember exactly what he says.
Yeah, no, it's not matter.
Okay.
It doesn't matter what he says specifically, but he does speak.
Yeah,
about it,
I may have no reason to doubt that.
Yeah, exactly. And you agree that as a director of Coropi, there's no reason to doubt the veracity of his recollection because he was
I have
involved.
no reason to doubt it, but I don't have any other information.
I see. So now let's look at document C066. And we see, this is a trust deed made on the 26th day of April 2012 between Coropi and Mr. Obradovic, correct?
Yes.
And here we see that whereas the grantor for consideration given is beneficially interested and entitled to 4,000 fully paid up shares, etc., the grantor is entitled to have the shares registered, correct?
That's what it says, yes.
And then if we go further down, we see that the grantor hereby declares and directs that the trustee shall hold the shares upon the following trusts. And then there is a list of trusts and rules which the trustee is supposed to follow, correct?
This is, yes, it is a declaration made by the so-called grantor.
Mm-hmm.
It is, yes, there's no word of agreement. It just says, I declare. If you go up,
Yeah.
the grantor hereby declares and directs.
Yeah. That the trustee shall hold the shares upon the following trusts, correct?
Correct.
Yeah, and the grantor is who?
It says that it's Coropi.
Yeah. So that suggests that Coropi believed at the time that it was beneficially interested in the shares, correct?
It appears that Coropi believed so. What my concern here is I would expect to see this document where the grantor or a settlor would transfer property under certain conditions. I cannot see what kind of property is being transferred here, and why is Coropi referred to as a grantor or alternatively a settlor, given that there does not seem to be a transfer of any kind of property, either legal title or beneficial title.
Well, the reference here is made to 4,000 fully paid up shares, correct?
Yes.
So look, we can always discuss whether a specific wording would have been better or worse. And as lawyers, we know that the easiest argument to make is to say, oh, if the party would have meant that, that party would have stated something else. It's very difficult to rebut such arguments. But would you agree with me that if we look at this document in its entirety, this word clause, whereas clause A identifies the shares, correct?
I agree that the shares are clearly identified.
And then if we look at what is stated in under 1, the grantor hereby declares and directs that the trustee shall hold the shares upon the following trusts, correct?
That's what it says.
Yes. So, and I'm a civil law lawyer, but to my mind, this sets out the intention of the parties, doesn't it?
As I said, we need to have clear, unequivocal words by the person that is to hold the shares. I would have expected, and I have submitted certain precedents that are usually used. I would have expected the trustee, the legal owner of the shares, to have made a declaration, not the other way around, not the beneficiary to declare.
Mm-hmm. But then if we look at, there's several signatures on the document.
Yes.
Have you looked into the issue whether these signatures are Mr. Obradovich's or whose signatures
I
these are?
understand that one of the signature appears to be Mr. Obradovich's signature.
Council, would it help if, the way that you characterized this a moment ago is that this reflects the intention of the parties. Would it assist your question if it was put to the expert whether this reflects the agreement of the signatories?
Mm-hmm. Yeah, thank you. Thank you. So would you also agree, as Mr. President suggested, that this document reflects the agreement of the parties?
Again, it seems that there is no clear confirmation by Mr. Obradovich that he agrees with the contents of this letter, albeit I acknowledge that his signature is there. I'm looking for words of agreement, and I'm having trouble finding them.
Well, so is it, is it required for a contract or a trust to use the specific word agree?
Okay, two separate questions. Specific verbs are not needed, but some words denoting agreement should, in my view, exist.
Let me try and assist, because I don't want us to prolong issues which might be swept away a little bit more easily. If you have a look at this document, just above the whereas clause, just below the whereas clauses, on the first page, it says, now this deed made in pursuance and in consideration of the above witnesses as follows. And then if you go to the end of it, just before the signatures, it says, in witness whereof we, that is the two signatory parties, have hereunto set our respective signatures. Does that imply agreement?
It could, but not necessarily.
Okay, thank you.
Well, I believe that your testimony was that under Cyprus law, trust can be created also tacitly.
Sorry?
Trust can be created tacitly without.
Without, it could be an oral.
Yeah. So then there is no words, right? If a trust is created tacitly, by definition, there will be no words used. Otherwise, it would not be tacit, correct?
So when you're talking about implied trust, it could be implied from words or contact of the parties.
Well, that concludes my cross-examination, Mr. Chairman.
Thank you very much. Any redirect?
Thank you.
No
No.
redirect.
No, redirect. Thank you.
Okay, I have quite a number of questions, but let me look to my colleagues first. Okay, let me start off there. Yeah. Needis, thank you very much for your testimony. Don't assume don't read anything into my questions other than an attempt to clarify issues. Let's just start, because this is where we've sort of ended on your cross-examination, with the internal letter of instruction, which is C319. I think it's still there. And it's just a small question. I mean, this document is dated 26th of March, 2012. We've got the trust deed, which we've just been looking at, which is dated 26th of April. So a month later. In the event that the tribunal were to conclude that a trust did come into being and came into being on the 26th of April, would the letter of instruction of a month earlier effectively be read into, or be capable of being read into, the declarations that followed in the trust deed, because it was part of all of the circumstances. It was evidence of the content of the trust.
Let me take a step back. And the question is, for me, and my question would have been, do we have evidence that any trust was created prior to the trust deeds?
No, I want you to make an assumption, because I'm giving you the proposition that if the tribunal were to decide that there was a trust, but that it came into being on the 26th of April, I'm trying to establish whether the antecedent internal letter of instruction of a month prior to that would be relevant to the terms of the trust as they are laid out in the trust deed. In other words, could it be read into it as part of an implied term?
And the question is, or rather the assumption is that the trust that came into with the trust deeds at the time of the trust deeds was to the benefit of Coropi, because that's another question.
This is what I'm asking you to opine on, because the trust deed of the 26th of April is a trust deed between Coropi and Mr. Obradovich. The letter of instruction is slightly different. So I'm just trying to establish, because you've said, express or implied, resulting, constructive. One's going to look at all of the evidence in order to decide what the terms of the trust are. I'm just wondering whether you have a view as an expert giving testimony on the issue of trusts, whether the internal letter of instruction of the 26th of March is relevant to the terms and scope of the trust that was established on the 26th of April?
In my view, it shows Coropi's point of view, Coropi's understanding potentially, but not the legal owner, Mr. Obradovic. It is not issued by him, as far as I know. I don't have any information that he was aware of it. I understand that the council suggests otherwise. So I would say it shows Coropi's state of mind, but not the legal owners.
Okay, thank you very much. Let's go back really to the beginning part of your testimony. Do you understand the word incorporation to connote the place where the registered office is? So in other words, because we don't find the word registered office, but we do find the term incorporation. And I'd like to establish whether your evidence is to us that, at least as a matter of Cypriot law, insofar as it may have a view on this, when we read incorporation, we can read that to mean the place of the registered office.
No, I do not. In my view, incorporation is the establishment of the company in the sense of the giving life, so-called, to a new legal person. And this is done by the issuance of the certificate of incorporation of the Registrar of Companies.
Okay, but that certificate of incorporation, so that may be in your evidence different from the place of the registered office.
The certificate of incorporation makes no mention of registered office. A mere certificate of incorporation has a date, the name of the company, and a registration number.
Could you have a certificate of incorporation or a company incorporated in Cyprus, which had its registered office, for example, in London?
No. The company would have an administrative obligation to have a registered office in Cyprus.
So it follows that the registered office is if you like, a formality of the place of incorporation.
Yes, as I mentioned, in the past, and I can try and find the dates here, it wasn't even a requirement at the time of incorporation. The requirement only came up after incorporation. So the company needed to establish a registered office 14 days after it was incorporated, which makes sense because the company needs to exist in order to acquire. But subsequently, for convenience reasons, and the reason is that always, as a matter of practice, the relevant form was submitted at the time of incorporation, this was brought earlier. And it is a requirement that this notification be made.
I understand that, and I understand that incorporation, I think, as you testified, is relevant to the applicable law. And of course, the company cannot establish a registered office until it comes into existence. So the registered office must be, the establishment of the registered office must be a consequence of incorporation. But that notwithstanding, there is a nexus between incorporation and registered office, whereas your evidence is that there is no nexus between registered office and seat. Those are two separate things.
Between registered office and seat. Yes, what I'm saying is that we are talking about two different arguments. Whether seat.
Sorry,
yes.
Mr. Ioannidis, I'm not trying to sort of explore
yes.
the detail of Cypriot law on this, the issue that the tribunal is faced with, or one of the issues that the tribunal is faced with, is that in the BIT, there is reference to incorporation and there is reference to seat. There isn't a reference to registered office.
Correct.
And I'm just trying to locate the concept of registered office within the two terms that are used in the treaty.
Yes.
So my question is, when we read incorporation, because there is a requirement to establish a registered office, is it fair for us, reasonable for us to read incorporation together with the consequence that a registered office must be established?
You couldn't have a company without having an obligation to maintain a registered office in
Perfect.
Cyprus.
Thank you. In what circumstance would a juridical person come into being under Cypriot law? Would a juridical person come into being in circumstances in which that juridical person was incorporated and had its registered office in Cyprus?
To have a person under the Cypriot law.
A juridical person, not a natural person.
Yes, and I'm talking about the company's law now.
Yes.
You could have a Cypriot company created in two ways. One, by the incorporation process that we have discussed, three ways actually. The two are similar. So one, the incorporation ab initio that we have discussed. The other two is the reincorporation, or when we're talking about EU companies, conversion of a foreign legal person into Cyprus. Once that reincorporation or redomiciliation or conversion take place, for all intents and purposes, that person is a newly incorporated, is an incorporated person under the company's law, continuing its legal existence under the company's law, and has a similar obligation to maintain its legal, its registered office in Cyprus.
But so I'm understanding from your answer that a juridical person for purposes of Cypriot law would come into being when a company was incorporated or reincorporated in Cyprus.
That's correct.
Right. Would that juridical person incorporated in Cyprus and having its registered office in Cyprus have the Cypriot nationality as a matter of the nationality of the juridical person?
I understand that the concept of domicile and nationality are very closely related concepts. And as with domicile, the mere consideration is incorporation.
I understand, but my question was not so much with regards to domicile, because while there may be some kind of an association between domicile and nationality, I think you said, that's not the point I was inquiring about. If you have a company incorporated in Cyprus, having its registered office in Cyprus, would, as a matter of Cypriot law, that company be regarded as a company having the nationality of Cyprus?
Yes.
Thank you. Just an observation to Council. You will, of course, appreciate that I'm inquiring about the interpretation of Article 25 of the ICSID Convention. We would like your submissions on that point in due course. I asked Mr. Georgiadis yesterday whether he was familiar with the Barcelona traction case. You were in the room. Are you familiar with the Barcelona traction case?
I am not.
Okay. We will have it in the record and we will have submissions from Council. This is jumping around because, forgive me, I'm going to go back to the trust issue. It's just in the order of the notes that I've made. Without a trust deed, Are there typically evidential challenges in identifying the three certainties that you've referred to?
I would expect yes.
And in that evidential process, anything that appeared to be relevant or material could be taken into account and weighed in the balance.
To establish an express trust, yes.
To establish, I suppose, but it may not only be an express trust, an implied trust. If we don't have a trust deed, it may be an express trust, it may be an implied trust, but we don't have a document in which the certainties are laid down.
Yes, in the express trust, we would be looking for words. We would be looking for such or to unequivocal statements. But even if made orally, we would need evidence to conclude that.
So if the issue of whether there was a trust arose before tax authorities or for reasons of probate or for any other reasons or before a court, one would expect to see all the relevant facts and circumstances marshaled and then weighed in the balance. And one would look at where the directors were located and where the decisions were made and all sorts of things of that. One would look at all of the relevant.
All of the relevant facts. I'm not sure whether the directors are a relevant issue here, but whether there is a trust, all the relevant facts would be looked at. But I would place, a court would place emphasis on the evidence of relating to the actual legal owner. Not just assertions by the third parties claiming something, but rather by the legal owners.
Now, a constructive trust, as I understand it, and I think we've had testimony both from you and from Mr. Georgiadis on this, a constructive trust arises by operation of law, but it arises by operation of law by reference to the circumstances. So it's not going to arise by operation of law if both parties were to say, we don't believe there was a trust.
Yes, it would be a creation by, it would be established by operation of law, that's correct. And what a court would look at would be, and this is the examples given by Mr. Georgiadis, a common intention of the parties. And in Mr. Georgiadis' discussion of the common intention trust, there needs to be evidence of substantial contribution or change of position of the other side.
So my point is, if we don't have, as it were, a dispositive finding of a common intention of the parties, because let's say we're not before a court, there's no litigation of the matter. So we don't have an express trust. And the question is whether there is a constructive trust, but there hasn't been an administrative finding by the tax authorities or the probate authorities or the courts. I'm just wondering whether the absence of a crystallized finding of a constructive trust would preclude a putative constructive trustee from believing that he was acting as a trustee because that was what was in his mind. So it's not found by the court, but if we had a witness, if we had Mr. Obradovich in front of us, we'd say to him, Mr. Obradovich, leaving aside the question of whether there was a piece of paper or other evidence, did you believe you were acting as a trustee? Could he have said, yes, I believed I was acting as a trustee. That's the way I comported myself. That's the basis on which I took the decisions and so
on. I'm not entirely clear of the question. I have to be honest with you. The question is whether the position or the frame mind of the alleged constructive trustee be relevant in the fact-finding under exercise?
So let me explain it a little bit further, and apologies for my lack of clarity. The tribunal may be very reluctant to put its finger on the scale and say there was a constructive trust, because we don't have a sense of the hinterland of other issues that we may open up by making a decision which effectively would be a finding of fact as a matter of Cypriot law. We may feel much more comfortable about saying that on the evidence that there is in the record, we conclude that Mr. Obradović believed he was acting as a trustee with respect to the shares that he held, because we've got the trust deed subsequently and so on. So the question is simply, until we have, as a matter of the local applicable law, a finding that there is a constructive trust, could a trustee, I'm putting this in quotation marks, consider that he was acting as a trustee?
Conceptually, I'm still having trouble, but my understanding is a constructive trust arises by operation of law, and there needs to be some sort of finding that there is a constructive trust. I'm not sure that other than an expressed or implied trust, a constructive trust can be created otherwise.
Okay, thank you. I won't pursue that. You were not asked, were you, Mr. Ioannidis, to address any issue of the interpretation of the BIT, were you?
What kind of issue? No,
well, the reference to incorporation and seat are found in Article 1.3b of the BIT.
No.
You were just asked to address the issues of Cypriot law as to the meaning of seat and the...
That's accurate, yes.
Thank you. Going back to my question about the evidential challenges, no, actually, I'll leave it. That's the end of my questions. Thank you.
So I'm a little bit confused about this discussion of trust, because you've used the term implied trust.
Council has used it, yes.
Council has used it, or someone's used it. My understanding is that an implied trust is a trust that is arises by operation of law. So there are two types of implied trust. There's a resulting trust and there's a constructive trust. Do you have a different view? Or?
Should I just say you have used the word implied trust because it's in 7.4 of your first opinion?
Yes, that's correct. The discussion in our opinions never arose regarding the operations of whether a trust can be implied. The discussions that arose were expressed trusts or constructive trust, and that was the level of the analysis. And to be honest with you, because this didn't arise in the Mr. Georgiadis's opinions, I didn't research the matter to the degree that I would have otherwise.
Okay, but so far as you're aware under Cypriot law, are you saying that there's not only is there trusts implied by, imposed by law, such as resulting trust and a constructive trust. There's obviously the express trust, which requires some sort of express declaration. Are you saying there's another category of trust which is implied factually?
I would say that an implied trust is related to the express trust in the sense that it may be implied by the words used by the parties rather than the written documentation.
Okay.
Just to follow up on that, just again to tick the box. In 7.4, you've said trusts often classified as express or implied, resulting or constructive.
Sorry, in 7.4?
7.4 of your first
yes,
statement, you've said
yes.
trusts are often classified as express or implied, resulting or constructive. Would you regard a protective trust as a constructive trust, or is a protective trust a different category of trust?
A protective trust in the sense of, can you elaborate?
There may be by imposition, for example, of the courts in certain circumstances to protect perhaps someone who did not have mental capacity. There may be an imposition of a trust. Now that doesn't seem to be express or implied or resulting or constructive. Is that another category? Are there other categories that may be relevant?
Perhaps what you're referring to is the statutory trust. So you appoint somebody to be a trustee on the basis of some statute. I would say that would be an express trust created on the basis of some authorizing statute.
Okay. As I say, while I'm an English lawyer, I'm not a trust lawyer. I had understood that as a matter of trust law, there was a concept of protective trust, but it doesn't have a bearing on the case, so we'll leave it.
Yes. So just to understand the question and make sure I'm answering correctly. For example, for the benefit of an underage person, the court makes an order for a protective trust. This is what you're saying.
Maybe I'm just wondering whether, this goes to Professor Douglas's question, whether there are any other categories of trust and what we are to understand by an implied trust. But as I say, I don't think that it turns on the circumstance or goes to the circumstance of this case. So let's leave the question.
And could we turn to, this is a completely different point, paragraph 12, subsection 11 of your second report.
Of the which report, sorry?
I think it's your second report. Hang on. Yes, it is. So it's paragraph 12.11.
Mm-hmm.
And you say here, go back to it again. A final point on this matter, which may be of relevance to the tribunal. The bit I'm struggling with is how it may be relevant. If you remember, and I put this question to your colleague yesterday, if you scroll down, you'll see the whole context. You refer to these, the filings that were made in relation to the contribution. And you point out that they're expressed to have been made in cash rather than being in kind. In circumstances where they were clearly supposed to be made in kind. And the first thing I want to ask you is whether or not, and just go through, scroll up again, the capital increase, which is C342, and it was pointed out by my colleague yesterday that may have been the contract for the sale of shares that would be the relevant thing to register here. Is that correct? Is that the allotment that could have been registered on the register of companies?
Sorry, you mentioned 342?
Yeah, C342. It's the last document that's mentioned in your list of exhibits there.
Yes. Yes.
So that's the document that should have been register?
Yes, this is the inconsistency that I have identified. What I noted is when there is an allotment of shares in kind, a contract needs to be submitted, and also the form needs to identify that the allotment was made for contribution in kind and not cash. A particular filing seemed to suggest that the allotment was made in cash.
So what's the significance of that? I speculated yesterday based on Article 51 of the company's law that you referred to, that it's about the payment of stamp duty.
The reason behind, I think it's twofold. One is the payment of stamp duty. I think the other reason that it is important is because it affects shareholder rights. Generally, directors allotting shares in kind, non-cash consideration, need to make sure that the assets that have been acquired by the company have been properly valued and have a proper value equating the shares that are being issued.
That was my next question, actually. So would an independent valuation be required in relation to the shares that are being contributed in kind?
The company's law requires independent valuation for allotment of public companies. There is no express statutory provision for the allotment of shares against contribution in kind by private companies, but it is within the general obligations of the directors to make sure that the proper valuation has been done.
So it's part of the sort of fiduciary duty of a
Exactly.
director to assure him or herself that the shares that have been contributed are of appropriate value.
Correct. It's part of the general obligations of the directors to act in the best interest of the company as a whole.
I see. Thank you. That's all.
I have one question, which is respect to the C66, which is the trust deed. And I want to come back to the discussion that you have
Yes.
with council. Somehow the chair also interjected there. And if I recollect well, you said that you don't see an agreement here. You don't see an agreement. And I want to understand a bit better why, because I'm not it's not that I'm not only an expert on trust deed, I'm also an English lawyer. So I have two reasons why I'm not qualified to opine on trust deed. But looking at the trust deed has two parties, as I said, right? Coropi, which is the grantor, and Mr. Dura Obradovic, which is the trustee. So Mr. Obradovic recognized himself as the trustee. Then is the discussion that it follows in the whereas that these shares of Kalemegdan that are beneficially, in which the grantor is beneficially interested, so we recognize a beneficial, both parties recognize there is a beneficial interest, will continue registered under the name of the trustee, right? So the trustee will hold this share as trustee for the beneficiary. Both parties of the document which signed us are saying this. You know? And then there is some declarations, right, about how what their declaration by the grantor about how the share has to be maintained or hold. And then it says that that are subject at the end, it says subject as aforesaid to hold the said shares in trust for the grantor absolutely, and has a number of obligations, and that this will come to an end when the shares for any reason, will not be registered in the name of the trustee again. And then the parties, there are two witnesses, and then the parties sign this. So I was wondering, you know, without being, as I said, an expert, how that I need to understand this document, cannot consider that all these declarations, all these recognitions put in there by both parties, one that accepts and declares that a trustee and there is a grantor, has no legal meaning as an agreement. What else would have to be there for me to understand that the people signed this document, understood which is in the document? I'm a little, you know, have some little difficulties
All right.
on not giving or saying that this document cannot count for an agreement and understanding a recognition of the situation, wherever you want to put it, in legal terms, and therefore the legal value of the document is not recognized.
Okay. My initial instructions were to interpret whether this document created a trust. The document consisted of an express trust. And my finding was that because of the reasons that I mentioned, it seems to imply that there was a pre-existing trust. The grantor, which is Coropi, is not actually granting anything. And there is no positive declaration by the legal owner himself. I mean, Mr. Obradovic doesn't say, I hold these shares on trust, gives some doubt on the whether this constitutes an express trust. It creates many questions rather than solves them. As a question of whether this is a binding agreement, again, there are no clear words. I do acknowledge that Mr. Obradovic signs this, but I don't see any clear words of agreement on his behalf. As far as the preamble is concerned, it is a statement of some background facts without it being a binding part of this agreement. I mean,
let me perhaps just follow up on that and try to assist. And I think, Mr. Ioannidis, the observation that you've just made, which perhaps you made it earlier, but you certainly crystallized it very helpfully now, where you said that having had a look at this document, and if one was just looking at it in the abstract, it appears to you that it implies that there was a pre-existing trust rather than actually creating a trust. And I understand you to be saying that you would have expected to see perhaps a different formulation of whereas clause A, which might have read, the trustee avers or affirms that that Coropi or the grantor is beneficially interested. In other words, you would have expected to see an affirmation from the trustee rather than an affirmation from the beneficially entitled person. Is that correct?
yes, and this is something that I actually mentioned in my first opinion.
You do. So the two points that I took away from your testimony about why you were cautious about saying this created a trust and evidences agreement is because you would have expected to see a document that creates a trust containing some kind of an affirmation on the part of the trustee, but you are also perhaps leaving open the possibility that Mr. Obradovic signed his name for some reason other than agreement.
What I'm missing is words of agreement.
Okay.
The what?
Words
Words
in agreement or of
in
agreement.
agreement. I
The
agree.
the word agreement is not in the document. That's
Yes. So
I'm a bit puzzled now because that you can have a contract that doesn't create a trust, but is still a contract. So why can't this be a contract, a binding agreement, even if, in your opinion, it doesn't create a trust? It's perfectly possible, isn't it?
A contract as to what?
Well, whatever it says in the text, but you can have a contract that operates in personam between the two parties without it creating a trust. A trust has other proprietary consequences, you know, but there's nothing stopping this document from existing as a contract, even if it doesn't create a trust.
If we are talking in general terms, you can have a contract creating in personam obligations, irrespective of whether or not that contract creates a trust.
So I'm not sure why you're insisting that this can't be an agreement. It is an agreement that two parties have signed.
Yeah, I didn't say it's not an agreement. What I'm missing is an agreement creating a trust. Yes.
So two separate things.
Yes.
Well, just to, again, as I said, I'm not an expert, I'm not here, and I said, but the document said this deed of trust is made on the date. So my understanding, and coming from, you know, when people do a document, whatever is an agreement, what I understand is that this trust is made on the date. They are making a trust. So it would be difficult for me to understand what other agreement I'm making, that the agreement that they say they're making. That's a comment that I have to you. I would like you to comment on that. And then in letter B, and my understanding is that Mr. Obradovic that is signing this text, he's recognizing himself as the trustee. Instructions are given to him. That's what I'm saying. And then in letter B, it says that the shares will continue to be registered in the name of the trustee, who will receive an agreed remuneration for acting as herein, which I understand as trustee, right? Provided, and who has accepted to do so, right? And he signed this document. So, well, it may be my, that I see that there is, but you tell me who said that acting to do so, you understand that refer to something, expected to do so is something different than to be trustee, or the fact that they call it the deed of trust is made in this day, they are saying something, but they are doing other thing. I don't know. That's why I said I was a bit puzzled, you know.
Yeah. The question that was put to me is whether this document creates a trust. And my response was, it does not appear to create a trust. It presupposes the existence of a trust. I don't know when the trust was created, by whom it was created, how it was created, and what the terms of that trust had been created. And if it was not properly created, whether there was another constructive trust to the benefit of somebody else, and whether the grantor indeed had a right to claim that it was a beneficial owner. All these matters were unclear to me, and this is what I testified.
Okay, so if Mr. Obradovic for some reason would have decided not to follow what is in here and take this to a court, your testimony is that you take this to a court in Cyprus, it will not be enforceable as a trust.
It could be evidence of a general contact, but not itself creating a trust.
My question, so it will not be obliged to follow the instructions pursuant to this document.
What I'm saying is this document does not seem to create the trust.
I
Yes.
think this is as far as we
Yes.
can go.
Thank you.
Council, any redirect?
If I may, just one point of clarification, Mr. President. So maybe it would be helpful, Mr. Ioannidis, if we could go back to slide 32 of your opening presentation, and if I can maybe ask. Thank you. Slide 32. And that relates to the last exchange you had with the members of the tribunal. Could you maybe explain a bit more the issue that you take with the trust deed and the fact that Mr. Obradovic is not the grantor, but Coropi is? And in light of point A that we just looked at in the trust deed. So that I think that would be.
So an express trust is created by one of two ways. One,
Is your microphone on?
sorry. An express trust is created in one of two ways. One, the legal owner of an asset declares himself unequivocally as trustee for somebody else. And I also gave, in my opinion, a template or a usual form where you have a document saying, I, who hold these shares, declare myself to be trustee for the benefit of so-and-so. The second way is through the transfer of property by a previous owner to a new owner to hold as trustee, setting the terms of that trust in the document. In these circumstances, you have a settlor or otherwise a grantor transferring an asset to the trustee to hold on trust. In this document that we have in front of us, Coropi is called the grantor, but is not in reality transferring anything to Mr. Obradovic, to the trustee, to the alleged trustee, because the shares are already in his name and the beneficial ownership is not being transferred to him in any way. So what I'm saying, there's an inconsistency in the terminology used and the concept of the creation of this trust.
So you say here that for my understanding that because Mr. Obradovic is not named as the settlor or the grantor, and point A refers to a beneficial ownership of Coropi, there is some inconsistency and it is not clear when the trust was formed or if it was formed.
That's right.
Thank you.
Thank you. That was a helpful clarification. I think, Mr. Ioannidis, thank you very much. That brings your testimony to an end in good time for lunch, so you're not going to be sequestered.
Thank you so much.
We very much appreciate your assistance, and you are excused from your responsibilities as expert witness here.
Thank you.
Before we break, Council, I would like to, in the spirit of, again, adding to our list of questions, identify a number of issues arising both from Mr. Georgiadis' testimony and Mr. Ioannidis' testimony that it would be helpful for you to address. Before doing so, let me just go over one or two points of directional clarification that we've already addressed, but just to make sure that we do have it absolutely correct. I think I asked the question yesterday or the day before whether it was Exhibit 7 or 7A, which was the authoritative text of the treaty, and I think the response that I got was that it was 7A, which on its format looks as if it was the authentic text. Could I just have from both counsel on the record a clear affirmation that the tribunal should be looking at Exhibit C7A rather than C7?
We confirm the tribunal should be looking at C7A.
Confirmed.
Okay, thank you very much. That's very helpful. It wasn't amongst our written list of questions, but I have a recollection that it was one of the points that we addressed and will be evident in the transcript. But if not, just let me clarify and make a request on the part of the tribunal. Could you please put the Greek and Serbian texts of the BIT into the record. As a question, we do not need expert evidence on this because you will be able to address this on the basis of submissions, just to invite submissions on whether the Greek or the Serbian texts of the BIT assist in the interpretation of the English text, which in the event of dispute is the authoritative text. And just to provide a little bit of further specificity, and there will be all sorts of issues that you may wish to address. But insofar as we are currently talking about the interpretation of Article 1.3b, Article 1.3b in relation to incorporation and seat has, for example, a comma in the text, which is not found in 7, and that's just before the reference to seat. So my question at this point, or my invitation at this point, is to invite you to address to us whether in your submission the Greek and Serbian texts assist in the interpretation inter alia of Article 1.3b of the English text. Is that clear enough? Yeah,
Very clear.
okay. Could the parties in your closing submissions point us to evidence in the record which goes to the locus of the management and control of Kalemegdan and Coropi? So that is a factual matter. We would like to know where in the record, and this is, I imagine, going to be something that the claimant will want to affirm and the respondent will wish to resist, but it would be helpful to know where in the record there is evidence that goes to the locus, the place of the management and control of two Cypriot companies. Is that any questions you have on that? No?
This is clear.
Understood. Okay. Last point, and this, let me preface this by saying I'm here reflecting a point that I think certainly but the tribunal more widely considers to be quite important and would wish to hear your submissions on. The evidence that we've heard from Mr. Georgiadis and Mr. Ioannidis goes, at least on the question of seat, goes to a point that is subsequent to a predicate point. And the predicate point is, what is the meaning of Article 1.3b of the treaty? And it is only once we have got to the meaning of 1.3b of the treaty that, if at all, the issue of Cypriot law arises. Now, the parties have addressed this, but this issue arose in a later stage of the pleading. It wasn't addressed in the notice of arbitration, which simply makes an affirmation of jurisdiction ratione personae. It wasn't addressed in the memorial, which simply makes that affirmation. So the parties only begin to join argument on this particular issue of the interpretation and Article 31 of the Vienna Convention, I think from the point of the counter memorial up and through. I think we would like to hear the parties on Friday on the interpretation of Article 1.3b on the treaty point. This is our controlling document. And subsequent to that, we invite the parties to address us very specifically. Don't beat around the bush on this, please. We'd like you to address us very specifically on why Cypriot law is relevant. There is agreement amongst the experts, across the two experts, that seat or siège social may mean something akin to domicile. The two experts disagree as to whether, as a matter of Cypriot law, seat and registered office or seat and incorporation are the same thing, but there seems to be agreement that as a matter of an abstract appreciation of the term seat, that it connotes something akin to domicile, effective management on control. Now, we have to decide, the tribunal has to decide what the treaty means. We don't necessarily have to decide, unless you advise us that we do, what Cypriot law means. We can simply decide what the treaty means. So please tell us why this erudite and expert evidence that we've heard on Cypriot law, why it is relevant to our decision. Okay, I think with that, we're on time, or even slightly ahead of time. 2 minutes ahead of time. Let's take a break. Oh, sorry, you've got...
I don't want to jinx our progress on the timetable, but we had an exchange earlier this morning about the new slides new material. And I think my colleague, Ms. Mihai, wanted to address it and also give the feedback that our colleagues from the other side have asked for as soon as possible.
Yes, thank you.
Is this something that you want to do in front of the tribunal, or do you want to do with the two?
I think that it would be good because we are having a lunch break, and then after we will have examination of experts, and that is actually a related topic. So I'm not sure that the tribunal will have enough time to decide after the lunch and before examination of the witnesses about that topic.
Sure, please go ahead then.
So yes, Clemens addressed respondent during the break, requesting our agreement with the introduction into the record of some articles of Serbian Code of Civil Procedure, and also some minutes of preliminary hearing held in the court proceedings related to Dunavska 23. And they also wanted Serbia's agreement that these new exhibits are addressed in the presentation slides and during cross-examination of Professor Živković and Mr. Milošević related to court decisions rendered by Serbian courts in relation to Dunavska 23. And we have considered claimant's request, and we have to object and disagree with it, as well as to claimant's suggestion that their experts should address these new exhibits and new arguments during their cross-examination. I will only briefly explain why we disagree so that the tribunal can...
Let me stop you before you explain why, because the claimant has not made an application yet. Because I invited claimant's counsel to consult with respondent's counsel about whether there was an agreement which would then assist the tribunal in the decision. Before I think we hear your objection, I think we would like to hear the claimant's application.
That's fair enough.
Okay, so the question is, Mr. Perkash, whether you want to make that application now orally, to which respondent will then respond, and the tribunal will then reflect on that, whether you would like to go away and think about that for sort of half an hour, and then we can reconvene for 5 minutes for you to make the application orally, whether you'd like to make the application in writing. It's your application to make, so please advise.
Yeah, thank you. I believe in the interest of time, I'm ready to make the application orally right now.
Okay.
I refer to procedural order number 1, I believe, which says that it is possible to introduce during the direct examination of a witness information relating to developments which occurred after the submission of the last opportunity to submit a written expert report or witness statement in the procedure. The last opportunity, so first of all, the issues we want to comment on relate to the merits of the case. The last opportunity our expert had to submit an expert report in connection with the merits of the case was February 2024, the filing of our rejoinder, reply. Then we had two court decisions issued with respect to the dispute over ownership rights regarding Dunavska 23. These decisions were put into the record by respondent in connection with the filing of their rejoinder. Our experts therefore did not have an opportunity to comment on these two documents. Also, in light of the tribunal's question, which I believe was raised on Friday already during the opening statements, with respect to the course of action that the parties expect the tribunal to take with respect to the court decisions, we intend to avail ourselves of the possibility to have the experts comment on these new developments, because we believe we are straight in the provision of the procedural order, which allows them, just like any other witness, to comment on developments which followed the last opportunity they had to submit a written expert report. Since, in principle, the direct examination of experts is limited to the formal issue of authenticating their signature, we believe that the more appropriate format for them to make submissions on the issue is to include the issue in their opening presentation, and therefore they prepared the 5 or 6 slides that we forwarded to the other party this morning. On these slides, they refer to certain provisions of the Serbian Code of Civil Procedure. I believe that the admission of these provisions into the record of this arbitration should not be problematic. This is Serbian law, which is very well known to Serbia. They also propose to submit the minutes of a preliminary hearing which was held in the litigation regarding ownership rights to Dunavska 23. This preliminary hearing was held prior to the submission of their second report, but the relevance of that hearing obviously was not known at that time, because the minutes of that hearing are relevant only for their assessment of the decisions issued in that court procedure. And the decisions, and by that I mean the decision on the merits, which which decided the matter before the court of the first instance, and then which occurred in March 2024, and then an appellate decision which was rendered in July 2024. All that occurred only after the submission of the second expert report of our two Serbian law witnesses, and that they could not have reasonably anticipated, obviously, the need to refer to the minutes of the court procedure. I would only add to that point that the court procedure involved the city of Belgrade as the counterparty, and also the state attorney office, which is the same entity representing Serbia in this arbitration. Therefore, again, the minutes of the preparatory session of the court, which our experts seek to introduce, are well known to Serbia, which participated in the procedure. Thank you.
Thank you very much. Mihaj.
Yes, of course, maybe we should start from the procedural order that my colleague mentioned.
Could you come close to the microphone? We can't hear you.
Sorry. In Article 20.2 6 of Procedure Order Number 1, it is stated that neither party shall be permitted to submit additional responsive documents after the filing of its respective last written submission unless the tribunal determines that special circumstances exist based on a written request followed by observation from the other party. And indeed, in this case, this rule from the procedure order could have been followed as it was written. And why? First, both decisions, first instance and the second instance decision, related to the Dunavska 23 were written months ago, and the claimants, of course, received it. Serbia exhibited both of these decisions with its written submissions. First instance decision was submitted with Serbia's rejoinder, while the second instance submission was submitted with Serbia's last submission related to jurisdiction filed in November. And after these two Serbia submission, claimants also submitted another submissions, though related to the jurisdiction. But however, having both of these decisions on the record, claimants had enough opportunity to follow the procedure order and request that it also address the first and second instance decision related to the Dunavska clause in its jurisdiction submission or in separate submission, of course, and to present additional expert report related to that. So we do not think that it is, we think that actually that this is indeed unfair surprise at the day when the examination of Serbia's experts should start. However, if claimant's request is accepted, then of course, Serbia should be allowed to respond in any way it deems necessary, including submitting new evidences and new expert reports. Thank you.
Thank you very much. And you have helpfully reminded us all of 20.6. I mean, 20.6.2, of course, says that if the tribunal grants an application for submission of additional responsive document, the tribunal shall ensure that the other party is afforded sufficient opportunity to make its observations concerning such a document. So we understand that. Let me, Ms. Mihaj, just ask you a number of clarificatory questions. And I understand that you are making 2 points of objection, one which is formal, the other which is substantive. The formal one is you saying this is out of time, it's a surprise, they should have made their application when they got the documents. And the second is you are making the observation that it is prejudicial because this is the first that you are hearing of it. We do have paragraph 22.10.2 of the first procedural order, which provides that factual and expert witness statements shall stand as examination in chief, etc. There may be a brief examination which can include addressing matters which have arisen after that witness statement was signed, direct examination. So I think that is the provision that that claimants are relying upon. Let me ask you, Ms. Mihaj, do you consider these recent court decisions relevant?
More than relevant, and we do not object that claimants expert address those decisions. Of course not, they are on the record, and we agree with that. But we disagree that they address these court decisions from the perspective of these new evidences, exhibits that the claimants are requesting are introduced in the files, and from the perspective of the new arguments, of course.
And insofar, and it sounds from this that it is likely that you would cross-examine. It is likely that you would cross-examine the witnesses on exactly this if you say that they are more than relevant. And I'm just wondering where this leaves the tribunal when the witness says, yes, this is my response to you, and this is evidenced in all sorts of documents, but the documents are not on the record. And we then come to paragraph 20.7 of procedural order number 1, which says that the tribunal may call upon the parties to produce documents or other evidence in accordance with the arbitration rule. And we, of course, the tribunal could, of course, then direct that all that other evidence is introduced. So I'm just wondering whether the two parties could not reach an agreement on it sounds as if this is dancing on the head of a pin. If these documents are relevant, then the tribunal is going to want to see the documents. The question is when they come in and whether you have an opportunity to address them. Yes. So my colleague says, could you give us some indication of what's the volume of this new material that's being proposed? Is it 1 page, 2 pages, 700 pages? What are we talking about?
3 pages.
So it's 3 pages. Do you think, Ms. Mihaj, that if you, I don't know whether you've been provided with the 3 pages, you have the 3 pages.
Yeah, we have, but it's not a question of 3 pages.
It's the question of.
Is the question of the allegation claimants and their experts are attempting to made from these 3 pages.
I see.
So in order to prepare for examination related to these 3 pages, we'll have to also look to some other documents that are not in the files.
Okay, thank you very much. I think that will.
That is of course something that I assume today from this point of view, but I will of course have to see in more detail the argumentation and the documentation, related documentation.
Okay, then I think the tribunal will need to discuss this, and we will give you our decision as quickly as we can, and unless and until we say that the documents are admitted, the documents are not admitted, and we will then take it from there. But we will come back to you as quickly as possible.
Just a quick question. I just want to understand what are we documents we're talking about? You said were 3. I understood there were legal provisions.
So yes, the legal provisions of the Serbian Code of Civil Procedure, and then minutes of a preparatory hearing, I believe it is called under Serbian law, which were held in the court procedure leading to the 2 decisions. Yes, this is the documents, and I would like to say that the suggestion that we somehow should have responded to that issue earlier is not correct, because it's quite common that there are issues that arise in the rejoinder with respect to the merits of the case, and they are then addressed by the experts at the hearing.
Thank you very much.
I'm sorry, just one clarification. Slides are 3 pages, but documentation I thought was much more.
I will give the floor to Mr. Pustai with your permission, because he handled the correspondence while I was cross-examining Mr. Ioannidis.
How many pages are the actual documents, or are the slides effectively the representation of the documents?
Right, so I do apologize. I did miscalculate, so it's not 3 pages, it's 5 pages.
7 pages, I would say. 5 pages with the submission and.
And I'm
just a
talking
second,
about documents,
but-
new documents.
Let me stop you there. Our decision is not going to turn on whether it's 3, 5, or 7 pages. Let's leave it at that, and we will give you our decision shortly. Thank you very much. We will reconvene, let's say at 2:30, just to allow us to deliberate, and we will try and make up the lost time. Thank you very much.
I mean, nothing changed since what we set up yesterday. And everything was tested. Audio recorders, video recorders, in-room interpretation with the headsets. All of that was good yesterday when we tested that before we left here. Well,
Yeah, 2 of them.
we put 2 mics.
There are 2 mics and waters and stuff like that. Okay, so the recording is on. We have more people in the room.
Draft recording is on. It's
Yeah,
not-
I think one of the issue is that the speaker is here in the legs of these people
Yeah,
and they are kicking it. And sometimes if we have like, flicker on the presentation, it's just because of that. And this morning I reassured that all the HTML tables are plugged in as it should. Oh my God, why he needs,
What the heck?
he go to take this, why? No, the English one. Or he is Serbian also, he doesn't understand.
See what judges decided on it was 3 pages, now it's 7 pages. Interpretation, I'll get more of it. But today there's only one person listening on interpretation.
But then they took 2 of those for this side, I don't know why. They will be on English.
Secretary said only one person.
Yeah, but look at them.
So that guy has it. The 4th guy
Yeah,
at the end.
that was for who, but this guy also asked him.
Oh, the one at the end.
Yeah.
Sometimes what they do, and I've seen judges.
Sorry, tribunal is just downloading the documents that have just been sent, and then we're going to deal with the housekeeping issues before we come to the witnesses.
She's off.
Bear with us for a second. Okay, is everybody ready? Yep. With apologies to the witnesses, we'll come to the experts. We'll come to you in just a moment. There's some issues just to address. First of all, before we broke for the lunch break, an application was made by claimants to introduce some new documents into the record, which are relevant to the expert evidence that we're about to hear from Professor Zivkovic and Mr. Milosevic. Although not expressed in this precise term, claimants' counsel relied implicitly on paragraph 22.10.2 of procedural order number 1, which provides inter alia that a party who has presented the witness may briefly examine the witness for purposes of asking introductory questions, including about any corrections to be made to the witness statement and of addressing matters which have arisen after that witness's written statement was signed in direct examination. And the new documents, in summary, go to, but are not themselves, because these judicial decisions are already on the record, but go to judicial decisions that were handed down after the witness statements were prepared. The parties, on the direction of the tribunal, having consulted in advance, sought to reach agreement on the admission of those documents, but failed to do so. And respondents' counsel resisted the introduction of the documents by reference to paragraph 20.1 point 6 of procedural order number 1, which provides that neither party shall be permitted to submit additional or responsive documents after the filing of its respective last written submission, unless the tribunal determines that special circumstances exist based on a reasoned written request followed by observations from the other party. And then there is 20.6.2. If the tribunal grants such an application for submission of additional or responsive document, the tribunal shall ensure that the other party is afforded sufficient opportunity to make its observations concerning such a document. And then I drew to the party's attention that there is also provision 20.7, which in procedural order number 1, which provides that the tribunal may call upon the parties to produce documents or other evidence in accordance with ICSID arbitration rule 34.2. And in response to the tribunal's inquiry, respondents' counsel indicated that there was both the formal point that this was a late application that should have been made in writing earlier on, but also that respondents would be prejudiced not by reference to a lack of familiarity with the judicial decisions, but rather by reference to the new documents that would be introduced, because respondents would have to undertake their own independent inquiries associated with the new documents, and further that they may wish to introduce further evidence, new exhibits, which would be responsive to the new documents which the claimants sought to introduce. Now, the tribunal deliberated on this matter, and at the start of the lunch break, thereby affording the parties an hour or so to reflect on the tribunal's decision. The tribunal gave its decision and directions to the parties, and what I say now is simply to summarize that for the record. So we've got that in the transcript, and the tribunal concluded that there were rights and equities on both sides of the equation, because presumptively an expert is entitled to address matters that have arisen subsequent to the filing of the expert report. But as regards new evidence, it is also fair and accurate that there shall be no reopening of the evidential records, save on the basis of special circumstances. Counsel for the respondents, in response to the 2 questions from the tribunal, did affirm that these decisions handed down recently were absolutely relevant, and indeed that there would be likely cross-examination. So the tribunal has concluded that insofar as documents are relevant, we would want to see them. And the decision that we therefore issued was that the new documents should be introduced into the record, and they have been introduced into the record. We note the risk of prejudice to respondents, and respondents will be given an opportunity after the close of this hearing, but in good time before the filing of any post-hearing submissions, to introduce any responsive evidence to the documents that claimants have just introduced, and then both parties will have an opportunity to address the new evidence in their post-hearing submissions. So that is the tribunal's ruling, and that's the basis on which we are going into the witness testimony. Now, we had, so closing that issue, we had anticipated that in the housekeeping this morning that we would address the issue of the parties, we hope, agreement on the conduct of Friday afternoon's session. I propose that we don't do that now, that we give the experts an opportunity to make their presentations and proceed with their examination, and that we deal with this at the end of today. I would, though, like to deal with it at the end of today so that we are all clear what is going to be happening on Friday. So unless there are any other more pressing housekeeping issues that either party would like to raise, we'll move to the expert evidence. Mr. Prakash, anything from you?
Thank you.
Not to the witnesses, to me. Are
Oh,
there any
sorry. Oh.
housekeeping issues? You haven't sworn the witnesses.
Yeah,
in yet.
yeah. I was surprised a little bit. No, since we will discuss the program for Friday only at the end, no housekeeping issues.
Okay. From respondent, any housekeeping issues? Who's got the microphone for respondent? Any housekeeping issues? No? Okay. You have to tell me to whom I'm going to be turning on
No, we don't have
respondent side.
any housekeeping
Okay.
issues. Thank you.
The musical chairs creates uncertainty for the chair. So, Professor Zivkovic and Mr. Milosevic, welcome. We very much look forward to your testimony. You will have an opportunity to make your presentation in just a brief moment. You should have the expert witness attestation in front of you. And if you could both read that into the record, please.
Okay, I will be first.
Could you give your name when you're reading it in so that we could
I'm
just...
Milosevic. I solemnly declare upon my honor and conscience that my statement will be in accordance with my sincere belief.
Thank you very much.
My name is Miloš Živković. I solemnly declare upon my honor and conscience that my statement will be in accordance with my sincere belief.
Thank you very much. You will have a presentation of up to 30 minutes with the use of demonstratives and exhibits which we have received. Let me pass you to Claimants Counsel just to take you through the formalities.
Good afternoon, Professor Živković and Dr. Milosevic. It would be helpful if you can switch your...
Yes, good afternoon. Thank you.
Do you recall submitting 2 expert reports in this arbitration?
Yes.
Could you please go to the last page of each of the reports and confirm that there is your signature there?
I'm confirming.
I'm confirming.
Thank you very much. Is there anything you would like to change in your reports?
No, there is not.
No.
Thank you very much.
Before I hand the microphone to Respondents Counsel, can I just check with the court reporter that you are able to identify which expert is speaking? Right. Yes. Thank you very much. So, Mr. Jeric, is it you who's going to be conducting the cross-examination, or no?
No,
It's you.
Mr. President,
Okay.
it will be me, yes.
Okay, there we are, Ms. Mihaj. I should have known because you were making your objections earlier on. Over to you. Sorry. Excuse me. Excuse me. That rather
I will
short.
gladly skip the presentation.
Yes. My apologies. Over to the experts to make your presentation.
Thank you very much, Mr. President. Go to the first slide. My name is Miloš Živković. I'm a full professor of civil and property law at the University of Belgrade School of Law. On the first slide, you can see some of my references. I've been a full professor at the School of Law. I've been visiting professor at the School of Civil Engineering, and I've been in practice through working as an off-counsel in Živković Samardžić law firm in Belgrade for over 20 years. And also I've been participating in a number of projects which had to do with construction permitting, conversion and legal regime of construction land, etc. in Serbia. Next slide, please.
Thank you, Mr. President.
May I just stop you for just one moment? And this is, sorry, a question to the Tribunal Secretary. I don't think that I have the presentation in electronic form. I've got an exhibit. Has that been sent? It has been sent. Okay, I will find it. Please carry on.
Thank you.
Thank you, Mr. President, members of the tribunal. My name is Miloš Milošević. I am Serbian attorney at law with 30 years of the legal practice. For the last 14 years, I've been attorney at law. Before that, I was second instance judge in the civil law department of the District Court of Belgrade, which was second instance court for 9 municipal courts of Belgrade, and which was directly below the Supreme Court of Serbia in criminal, civil, and administrative matters. Before that, I was first instance litigation judge in 4th Municipal Court of Belgrade, and during that period, I was also the president of case law department, which role was to analyze, collect, and distribute case law collected from the higher courts in regular ruling in the court. Before that, I was advisor in the Supreme Court Serbia, and before that, I was expert associate in the Commercial Court of Belgrade. And that's all.
So to summarize our presentation, first we'll speak about Obnova's buildings in premises at Dunavska 17 to 19th Street. Then we'll explain that Obnova has the right to use over the land at the same address. Then we'll address the issue of the land at the nearby address at Dunavska 23 in Belgrade. And subsequently, we'll speak about the rights that Obnova has on buildings in Dunavska 23. The next part of the presentation will be about the expropriation that was caused by the adoption of the detailed regulation plan for the bus loop, which we use the abbreviation DRP. And lastly, we'll speak about that as a result, Obnova has a right to compensation under Serbian law. Next slide, please. So we'll start with Obnova's right to its buildings at Dunavska 17 to 19. The first slide is an overview of the historical evolution of the rights to buildings. In order to save time, this is included in the presentation for your reference, but I won't go through this slide in details. But there you will see the changes of since the 40s until the 21st century, the changes of rights over buildings in Serbian property law. Next slide, please. Now we start with the overview of Obnova's rights to buildings in Dunavska 17 to 19. Basically, Obnova acquired the right of some 15 buildings on that land plot number 47 by constructing the land plots in their late 40s and early 50s. Basically, the ground for the acquisition of the rights that Obnova has over the buildings, it has changed in the meantime, was the fact that it constructed the buildings. So basically, we stress that the fact that Obnova did not have the building permits for all of these buildings, as well as the fact that it has not been registered as the owner of these buildings, does not impede our conclusion that it indeed acquired the rights of first the right of use, which subsequently, as we will present to you, was turned into ownership after the privatization of the company. Next slide, please. So basically, the next slide is about the transformation. So the right of use, which Obnova acquired when it was socially owned by construction, was subsequent to privatization transformed into the ownership right over the buildings. Next slide, please. Now, some of these buildings built at that address in Dunavska 17 to 19 have building permits, or don't have building permits and occupancy permits. However, the point is that since it was disputed by the expert of the respondent, all of these permits were given for the construction of new buildings. So that's the buildings that Obnova constructed in the late 40s and early 50s in Dunavska 17 to 19 were from the very beginning constructed by Obnova. Next slide, please. Now, this slide is about the issue of whether the permits, the building permits were temporary or not. It is our strong belief that the permits were not temporary. And the basic reason for that is that the Serbian law did not allow for temporary building permits before 1997. Other than that, the reference, which is undisputably in some of those permits, the reference to temporary use and the reference to the obligation to demolish is basically a reference to a lease agreement, 1953 lease agreement, or rather title to the land which enables Obnova to construct these buildings. This title to the land was a civil law instrument, and this obligation to demolish basically was the obligation of civil law, and in our view, it could not survive the termination of the contract in which it was contained. And that contract ceased to exist at latest in 1961. Next slide, please. Now, it's important to stress that even if Obnova's permits were temporary, which they were not because they couldn't be, that wouldn't impede the rights of Obnova on the buildings. Because nothing in Serbian law prevents one from being the owner of a building built according to the temporary license. For example, now you have this ready-mix concrete now under current legislation after 2009. You have a whole list of objects, of constructions that are made according to the temporary licenses. And some of those can be traded. They are sold, they are purchased, and it's very difficult for me to imagine how that would be possible if you don't recognize the ownership over that. So therefore, we think that as far as buildings of Obnova are concerned, that actually the issue of whether the building permits were temporary or permanent is irrelevant in respect to the rights of Obnova on those buildings. Next slide, please. Now, Obnova's buildings are permanent. Legal status of a building as permanent or temporary does not depend on the building permit. The building permit is an act adopted within the administrative law. It has been confirmed by the case law which we cited in the reports and which you can see on the slide, that basically what's decisive whether a building is permanent or not is the nature of the building. Of course, the nature of the building is not our job to assess it. It's to somebody, for other experts to assess whether it's a permanent or non-permanent building. But in any case, what we stress is that Obnova's buildings were not temporary, and the fact that they're not temporary is evidenced by the fact that they're registered in the real estate cadastre. And there is a authority of Supreme Court of Serbia saying that if it is a temporary object, it cannot be registered in the cadastre. Apart from that, the land in Dunavska 47 is in all of the urban plans of Belgrade deemed as a developed construction land, which means that the objects which are constructed there are permanent. Next slide, please. Now, there is a fact that it's indisputed that Belgrade is registered as the owner of the city of Belgrade is registered as the owner of those buildings. What we have explained in the report is the fact that given the fact that Serbian law recognizes unregistered ownership, this manifestly wrong registration of the city of Belgrade does not impede and did not impede the rights of Obnova. Obnova was still the owner because Obnova was the one who constructed the buildings, and Belgrade didn't have any, how should I put it, any grounds whatsoever to be registered as the owner. Next slide, please. Now there are two decisions of Serbian court, the first and the second instance decision passed by Serbian courts in proceedings initiated by Obnova for the declaration of ownership, for the recognition of ownership of Obnova over the buildings. We have discussed it in our reports because the first one was passed in September 2022 and the second one in December 23. The first instance court first examined whether the conditions for acquisition by usucapio or acquisitive prescription were fulfilled, irrespective of the fact that they were not really pleaded, that that type of acquisition was not pleaded by Obnova. Then it concluded that objects of Obnova are temporary structures that can only become permanent through legalization. Then it did take into account that structures are registered in the real estate cadastre. However, it connected that fact with the good faith in the sense of acquisition through usucapio, and didn't consider the fact that that the buildings were registered in connection to the fact that it claimed that the buildings are temporary, which is an obvious contradiction. Next slide, please. The Court of Appeal acknowledged that Obnova constructed indeed the buildings in the 40s and the 50s, but concluded that it has not acquired ownership because these buildings were temporary. That decision is self-contradictory because it also says that City of Belgrade is the owner of the buildings. So if the buildings are temporary and you cannot acquire the ownership of the buildings, how come that Belgrade is registered as the owner of the buildings? There is something wrong with or at least in my view, in that decision, that sense. And then from this incorrect conclusion, it says the temporariness of the objects, of the structures, that Obnova acted in bad faith. It knew that the structures were temporary and thus it couldn't own the structures. Next slide, please. Now we turn to the rights that Obnova has to land at Dunavska. First here, the first slide, like with the building, you have the historical evolution of rights to construction land. I will not go into this side in detail, so it's there for your reference, but next slide, please. Now, basically, given the fact that Obnova had the right of use of buildings, which was acquired by construction, in 1965, when the legislation changed in then socialist Yugoslavia, it acquired the permanent right of use as the, not owner, but the bearer of the right of use of buildings. So basically its right on the land is directly related to its right in the buildings. It's strange, but it is a feature of then socialist Yugoslavian property law. This right, this permanent right of use, is basically a right that prevails over other types of right of use that might exist on the same land, because it's an ipso iure right, which is based directly on the law. And however, privatization of Obnova in 2003 did not change the nature of the rights of Obnova to land, because the Constitution of Serbia did not allow private ownership over land. So as opposed to the buildings which were transferred to private ownership, the land remained in the regime of, next slide, please, in the regime of the right of use. That has changed in 2009. First, in 2006, new constitution was passed. The monopoly of state or social ownership over construction land was given up. And this law provided for the possibility of the so-called conversion, so transformation of the right of use of land to the ownership right of land. Basically, there are two things that we want to emphasize here in the presentation. The registration of the right of use in the cadastre was a procedural step and not a condition for acquiring that right. And the fact that Obnova was not registered as the bearer of the right of use of land does not preclude it from acquiring that right ipso iure. And lastly, this right to convert right of use to ownership was basically once the land was declared for public purpose by the detailed regulation plan, that right simply ceased to exist. Next slide, please. Now we will turn to the other plot in Dunavska 23, and we'll start in this plot. We'll start with the land and not with the buildings. Obnova did acquire the right of use over the land in Dunavska 23 by acquisitive prescription, by usucapio. In Serbian law, you need, for usucapio, you need 20 years of bona fide undisturbed possession. And from what we have concluded in our reports, given the documents that were presented to us, there was at least 20 years of undisturbed possession of Obnova over that land. I stress that under Serbian law, good faith is presumed, rebuttably presumed, but we are not aware of any objections that anybody made to Obnova. And this last bullet is, it is strange. This is admittedly a speculation, but basically it is hard to imagine that Obnova used the land without any title whatsoever. There must have been some sort of title, but we didn't see it. So there must have been some sort of consent. Next slide, please. Now, the same thing as with the plot at Dunavska 17 to 19. After privatization, the right of use of land remained. In 2009, when the law on planning and construction enabled conversion, Obnova acquired the right to conversion, and it lost the right to conversion when the detailed regulation plan was passed because it designated the land to the public purpose, which made the conversion impossible. Next slide, please. And now we end with the rights of Obnova to buildings in Dunavska 23. Next slide, please. These buildings were constructed by Obnova when it was a socially owned company. As a result, by the effect of construction, Obnova acquired the right of use, this time the different type, the right of use as an emanation of social ownership on these buildings. And these buildings have been, similarly to the buildings at Dunavska 17 to 19, they have been, upon privatization, turned into, that right of use was turned into the ownership right of those buildings. Next slide, please. Now I will, there are these two new decisions, decisions that were passed after we have submitted our second report. So I kindly ask my colleague, Mr. Milošević, to take over.
Thank you. If you allow me, I will try to be as brief as possible. So after second expert report of Živković and Milošević were submitted, the respondent provided us with two judgments of Serbian courts. They are marked here as R160 and R227, where the courts rejected as unfounded Obnova's claim for declaration of ownership on premises in Dunavska 23. I have assessed these judgments, and just to be brief, and I will explain, I hold that the courts made a grave procedural error when implementing burden of proof rule on undisputed facts against Obnova. And I will explain that. First, the courts in these judgments concluded that Obnova failed to provide evidence basically on three facts. The first is that it constructed the premises. The second is that it is in possession of premises. And third one is that it acted in good faith. This was with implementation of burden of proof rule. However, the minutes from preparatory hearing demonstrate that the court did not establish these facts as contested facts. So there is neither of these facts was not contested or disputed in the preliminary phase of the proceeding. And we can go to another slide. I will explain a little deeper why is that important. Serbian civil procedure is strictly adversary procedure, so it is not sufficient just to broadly contest the claim. it is required to address specific factual allegations. And I will not read, you can see listed particular provisions here which are important for this assessment. And the most important one is the Article 230, which is third bullet point, which provides the mandatory rule that all facts that are not explicitly contested are deemed undisputed. And what we can see from the minutes that I mentioned, that these particular facts, which was the base for the judgments, were not contested. And we can go to another. Just for your convenience, I've tried to make schematics to make this easier to understand. Just briefly, we have two paths depending.
May I just stop you just to observe for the record, but also for my colleagues, that this is, I think, C739, which has just been introduced into the record, the Code on Civil Procedure. So we've got the documents available.
Thank you, Mr. President. So we will see two paths. One is to the left, the other one is to the right. The one which is shown to the left, it will happen when the facts are contested. And if we have contested factual allegations, then we will go to the proceeding of taking the evidence, then evaluation of the evidence, and that is where the burden of proof rule can be applied if needed. The result of that will be established facts. But we have also another path, which is shown to the right side. If the parties does not expressly contest specific fact, that fact shall be deemed undisputed and shall be considered as established fact. So we do not go through burden of proof in that case. That would be all. I will just try to save some time. If there would be any questions, I will be happy to answer, of course.
Now there is one more issue that I'm going to address in this presentation, and this is the issue of Obnova and the alleged lease agreements, and the Obnova as a lessee of the premises, both buildings and land on both addresses at 17 to 19 and 23. Next slide, please. Now, Professor Jotanovic, in his expert report, he relies on 11 service agreements, which he called lease agreements in respect of these two premises, buildings and land. In our view, we do not consider these agreements to be lease agreements in the first place. They are not called lease agreements, and they appear to be some sort of service agreements. Next slide, please. And also, the other problem that we have with these allegedly lease agreements are the fact that we were not there. This sketch, which shows the subject matter of the agreement, are missing. We don't have them. So basically, it is we couldn't conclude whether these agreements, these service agreements, refer to Obnova's land, the Dunavska 17 to 19 and 23, or to some other land. So this is where we had simply a problem to identify the subject matter of this agreement. Next slide, please. Now, in respect of Dunavska 17 to 19, first of all, we want to point out that Obnova has been leasing out these premises at 17 to 19. And that basically we have been provided with agreements from 2006 to 2022, which directly state that Obnova is the owner of these premises. And some of these are signed by the same person who signed the alleged lease agreements from the report of our esteemed colleague, Professor Jotanovic. And that would be very inconsistent then that the same person signs two agreements in which he claims that he's the owner, and the other one he claims that he's the lessee. But most importantly, even if these agreements were lease agreements, and even if these agreements actually referred to Dunavska 17 to 19. In our view, that's irrelevant. Why? Because in 1965, Obnova acquired the right of use and not the right to use these premises, this land, by operation of law, ipso jure. So therefore, it simply acquired the right of use, in our view, in 1965. So even if it did lease out or lease its own land, so to put it, it wouldn't change the fact that it has the right to use. Next slide, please. Now, the similar thing relates to the premises, to the land at Dunavska 23. First, out of the 11 agreements, it seems that 5 agreements could be somehow connected with Dunavska 23, but our problem is that there are other provisions in all 5 of these agreements which are inconsistent, which appears not to be related with the Dunavska 23, either the different land plot or some or mentioning of the railway which don't exist at that plot, etc. However, again, even if the agreements that were relied by Professor Jovanovic were lease agreements, and even if they actually referred to Dunavska 23, it is clear that between 1968 and 2000, there were no such agreements. And after 20 years, the acquisition via usucapio also functions by operation of law. So after 20 years of possession, you become the owner or the bearer of the right to use in this case. And afterwards, even if you lease it in error or however, it doesn't change the fact that you have acquired the right of use. And in our view, somewhere in 1988, because in 1968 there is a first proof that they took possession, Obnova acquired the right of use by acquisitive prescription. Next slide, please. Now, also, this goes to the buildings of Obnova at both addresses. Next slide, please. And Professor Jovanovic also argues that Obnova leased its own buildings on both addresses, when we couldn't find any of these alleged lease agreements that referred to the buildings. There is one of them which refers to infrastructural objects, but it's really very vague and cannot be connected to any concrete building that exists at the 2 addresses. And even if these agreements actually did refer to the buildings of Obnova, which is highly unlikely because Obnova constructed these buildings, it's their buildings. This would not affect our conclusion that Obnova is the owner of the buildings. Why? Because by the act of construction, it acquired the right of use, and by privatization, this right of use was transformed into right of ownership. And I can lease my own flat if I want to. Basically, this is the logic behind it. Next slide, please. Now I'm turning to my colleague, Mr. Milošević.
Thank you. I'll try to speed it up as much as possible. We can go to first slide. Yes, there will be just a few points to make short summary. So Serbian law knows the main safeguard against expropriation in Serbian law is the Article 58 of the Constitution, which provides that the right of ownership can be taken or limited for public purposes against payment of compensation, which cannot be lower of the market price. What is important to note is that this provision applies directly on the grounds of the Article 18 of the Constitution, which means there is no need for any laws or bylaws in order to courts and every other body to implement it directly. There is this almost the same provision which is provided in law on expropriation, which regulates the expropriation of the immovable assets. And at the same time, law on expropriation also provides specific procedure which should be commenced when doing so. Can we go to another slide, please? Thank you. But also there are some situations where immovable assets are expropriated without commencing the proper procedure. We call them de facto expropriation, and The entities whose real estate is expropriated in this manner had two options. One is to negotiate compensation. The other one is to initiate litigation proceeding. Can we go to another slide, please? Yes. Reasoning decision that designates land for public use also represents de facto expropriation, and we have provided case law on that manner. I will just remind you on Article 58 of the Constitution, which says not only when it is taken, but also when it is limited. And reasoning decision is something that limits ownership, and that is why it triggers also compensation in de facto expropriation proceedings. So please, yes. Therefore, we concluded that obnova has a right for compensation under Serbian law, and that adoption on 2013 DRP falls within definition of de facto expropriation, which is also recognized and provided by Serbian courts, and that it is entitled to compensation to the amount of market value of expropriated licenses. Next slide, please. Yes. There is also some case law which was provided by respondent. I will just briefly comment on this. It is R107. I have assessed this court decision is decision of administrative court, which is related to formal expropriation proceeding. We hold that this decision does not exclude compensation for unregistered ownership. And actually this decision deals, main part of this decision is insufficient evidence on matter of ownership. Actually, the court didn't say that unregistered owner does not have a right to compensation. It said it is not certain whether the subject is the owner because there was not sufficient evidence. And you will see the last bullet point, we have provided also the opposite case law. That's the legal opinion of Civil Department of Supreme Court of Serbia, which confirms that even the illegal objects can be expropriated. Can we go further, please? So we have concluded that obnova has a right for compensation, also regardless that the buildings and the right of use over the land are not registered. And we find that that does not limit obnova's right in any way. The other thing that is important is that this claim cannot be time barred, and we have provided also case law on that in that regards, which is listed here. And last slide, the obnova requested compensation as it submitted a request simultaneously for several authorities, which are mentioned here. One of them was LDA, or Land Directorate. The only authority who responded was the LDA, and it rejected the request for compensation as unfounded. We found that their reason was incorrect and unsubstantiated, and the LDA had the authority to agree. I have to just make this point that LDA did not act in this regard as the administrative body, but it was acting as the authority who was entitled to decide on compensation and to agree and to negotiate compensation. That was our conclusion. So I will, as we have a lot of time passed, I just don't want
Thank
to.
you very much for your
Thank you very much.
Thank you very much for that. Before I hand you to Respondents' Counsel for cross-examination, I just note that the presentation went marginally over the 30 minutes, and I will be fair and equal to Professor Jatanovic and give him a couple more minutes when it comes to his testimony. So, Ms. Mihaj, it's over to you.
Thank you, Mr. President. Professor Živković, Mr. Milošević, thank you for being today here with us. For the record, my name is Senka Mihaj. I'm counsel for the respondent, and I will ask you some questions related to your expert reports. So at the start, I would appreciate if we could first determine is there and what are the topics that we could agree on? And what are the topics that we disagree about? And hopefully that would save us some time. I'll wait.
The technology really be nice.
We can agree that we need the technology to work. Yeah, is there a technician around? It looks as if it's a loose connection somewhere because it's spluttering. Yeah. Can we just make sure that a technician is coming down to assist us? There is life in the machine. See, all it needs is the presence of the expert, the technician.
Yeah.
Was it a loose connection with the respondent's computer? Is that what it was?
I'm sorry, Mr. President.
No, I was just wondering whether this was just a loose connection plugging it into a new computer terminal that's causing this to splutter.
But we still have some interruptions. I can start because I don't need any documentation during this first
Please go
couple of
ahead.
questions.
Sure.
So,
and can you talk close to the microphone so that we
yes,
can? Thank you.
I'll do my best. Thank you. Professor Živković, Mr. Milošević, would you agree that before 1997, construction permits were also issued for objects that were temporary because of the existence of an obligation to demolish them at a certain time or at the request of a competent authority?
Well, actually, no.
No. Okay. And would you agree that when the construction permit allows construction of a temporary object, materials used for construction of an object is irrelevant for its legal status as permanent or temporary?
No.
And would you agree that temporary objects are considered movable property?
Yes.
And would you agree that the constructor of a temporary building does not have the ownership right over the object as an immovable thing, but only the ownership right over the material from which the object is constructed?
No. I mean, could you repeat the question? I'm sorry.
Would you agree that the constructor of a temporary building does not have the ownership right over the object as an immovable thing, but only the ownership right over the material from which the object is constructed? No. Okay. And would you agree that in 1948 was adopted the first regulation that introduced construction permits as the condition for legal construction?
I don't know whether it was the first one, but there was the one in 1948, which was relevant for the case. That was the basis of the permits issued.
Would you agree that before 1948, it was allowed to construct buildings without obtaining construction permits?
I think yes. I mean, before the war, by all means.
And would you agree that as of 1948, the status of the object as permanent or temporary depends on the content of the construction permits?
No,
And would you agree that when it comes to the objects constructed after 1948, the material from which the objects were constructed and their duration are irrelevant for determining the status of the building as temporary or permanent?
it is difficult to answer. It depends. The answer is actually no, but it depends on it doesn't depend on the material. It depends on the way the material is used.
Okay. And would you agree that the construction of illegal building cannot lead to acquisition of the ownership rights over the land unless they are legalized?
Yes,
And would you agree that illegally constructed buildings without necessary permits have to be removed unless they are legalized?
on the normative level, yes, but there are 2 million of these objects in Serbia. So I would like to see who would remove the 2 million objects.
But legislation says, yes, it has to be removed.
The legislation says that there is a procedure for removing the illegal objects. Let's put it that way. It should be initiated and then there should be a proper procedure. And then at the end, it could lead to the object being demolished or removed, whatever you like.
And would you agree that all laws regulating legalization of illegal built objects require that the applicant provide proof of ownership over the land and the object or the object?
They needed, it wouldn't be a proof of ownership because the ownership of the land didn't exist in Serbian law until 2009, couldn't exist. But ownership, you need to have some sort of title of the land and the proof that you constructed the building. If you don't have the title of the land, the proper title of the land, then you can have an improper title, but some sort of document indicating that you have the right to the land.
So would you agree then that you would have to have proper title over the land, which is right of use over the land or the ownership right?
In order to what? In order to legalize the object.
Yes, constructed on that land.
No, no, because you can have some other document indicating that you have some sort of right which is not perfect. When you say that you have to have a proper right of use of the land, there is like tens of thousands of people who don't have the proper right of use of the land, and some of them managed to legalize their objects because the contracts were null and void, but they have some sort of documents indicating some sort of right over the land.
And I would be surprised if you disagree now, but would you agree that the cadastre sometimes makes mistakes in registration?
Yes, it made an obvious mistake by registering Belgrade as the owner of all those buildings to begin with. It's in my report.
And would you agree, though, I think that you already confirmed that during your presentation, but would you agree that a person cannot acquire the ownership right over the temporary buildings?
No.
No? Thank you. Can you now see your first expert report? And that is paragraph 129. And you state there that you have not been provided with any documents showing the source of Obnova's rights to build this building in Dunavska 1719 before 1953. Can you?
Yes.
Can you tell me what was the source of Obnova's right to build its building at Dunavska 1719 after 1953? Was it the lease agreement from 1953?
What was the source?
Of Obnova's rights to build its buildings
Yes,
at Dunavska
yes,
after
that
that?
was
After
that.
it was,
After 53, that
it was
that
lease agreement from 1953. That is C7 for the record. And can we see, please, on the screen C141? That is approval of the Commission for Communal Affairs issued to Obnova in August 1949. That was prior Obnova obtained its first construction permit. And that approval states, I quote, "Commission agrees with your request to erect the necessary canopy on the land leased to you." I need R141.
You say R141 because the previous reference was C141.
No, that was only the document that I mentioned, but I want R141 at the screen. So you can see this document approves Obnova to erect the necessary canopy on the land leased to Obnova. So would it be fair to conclude that the source of Obnova's right to build these buildings at Dunavska 1719 before 1953 was also lease agreement? And that the lease was the ground for issuing construction
I
permit to
didn't
Obnova in
see that lease agreement. Whether or not it
49.
existed, most probably did, maybe it didn't, maybe it was an oral agreement. I mean, 1949 is 1949. It's like
Okay.
1 year after Tito and Stalin broke up.
Can we now move to paragraph 129 of your first report also? And you state that it is not uncommon that the source of one's right was
Which
not
paragraph?
129, first report. The same paragraph. You state, can you please read that paragraph?
The paragraph 129.
Yes, that's right.
We have not been provided with any documents showing the source of Obnova's right to build its buildings at Dunavska 17 to 19 before 1953. However, the fact that the source of that right was not properly documented would not have been uncommon at the time. As explained in section 2A1AII above, the state took control over a vast majority of enterprises as well as all construction land immediately after the Second World War. As a result, all industrial development since the Second World War was directed by the state. The state's directions were sufficient to allow for development on state-owned land, and there did not need to be, and often was not, any subsequent civil law title to release such development.
Thank you. And then in the next para, 130, you state that after 1953, it became more common for socially owned enterprises to acquire proper civil law titles to the construction land assigned to them by the state. And then in the next para, you say that civil law agreements concluded between socially owned enterprises and the state were only pro forma documents that would often were not followed by the parties. And finally, in the subsequent para 132, you explained that Obnova also concluded such a pro forma agreement in 1953 for Dunavska 1719. But I'm struggling to understand why the state didn't just render the decision by which it grants Obnova the right of use over the land in Dunavska 1719 instead of concluded as you state pro forma lease agreement that was not followed in practice.
I don't know why the state didn't do it. I actually don't know.
We can move on para 134 of the first report. where you state that it seems that the 1953 lease agreement was not followed by either party. And I quote, most importantly, we have not seen any evidence of any rent paid. But would you say that it is unusual that there is no evidence of rent payments that occurred decades ago, or in this case, 7 decades ago? Would it be unusual?
I don't know what's usual. I mean, this is the first contract that is 70 years old that I have encountered in my.
And you would expect that there is a proof that 70 years ago, Obnova paid some rent?
Sometimes there is, sometimes there isn't. I don't know, what do you want? I don't understand. I mean, there could be, if they paid, there could be evidence, or the evidence could be lost.
And can we now go please to your second report?
Before we leave that, just a question. I'm interested in the formulation of that last sentence of paragraph 134, where you say, we also have not seen any evidence of Serbia ever trying to collect any rent from Obnova. Is that the right way round of framing it? I mean, I might have sort of expected that you would have said, we also have not seen any evidence of Obnova paying rent. But the way that you have put it suggests that there is some kind of responsibility on the part of Serbia to collect the rent.
If you see the previous sentence, we started with, we didn't see Obnova paying the rent.
So you just
we don't see
juxtapose
that they paid the rent. So if they didn't pay, you would expect some sort of procedure for collection. This is the.
So you're just joining the dots.
Yes.
Thank you.
Okay, your second report, please.
Excuse me.
Para 132. In that paragraph, you're referring to agreements submitted by Mr. Jotanovic, for which Serbia claims that are lease agreements related to premises in Dunavska Street. And in this paragraph, you state that you cannot conclude that the agreement submitted by Professor Jotanovic relates to Obnova's premises, as opposed to other warehouse space that Obnova may have been renting in the port or the area between the port and its current premises. However, now today, during your presentation, it seems to me that you have changed your mind and that now you are claiming that these agreements do not regulate lease at all. And in your second report, you actually were implying something else. It also can be concluded from the paragraph of your report that
I
that I
cannot
have just
conclude it
read.
from this paragraph. I'm sorry. I don't see the contradiction. Here
But have
we
you-
speak about the subject matter of the contracts and not of its legal nature.
But you
Whether
are,
it's-
yes, that's correct. But you are implying that the subject matter of the contract is not release of Dunavska 17, 19, and 23 that the subject matter of these arbitration proceedings, but you are saying that these agreements may have related to some other warehouse space that Obnova may have been renting in the port or the area between. So it seems to me that it is clear.
To be clear.
Suggestion that these agreements relates to some kind of lease, to some lease. And did you ever mention in your report, in your second report, where did you state that lease agreements are not lease agreements at all?
Okay, let's start from the beginning. Subject matter of the agreement is real property. Legal nature of the agreement is service agreement or lease agreement. These are two different things. Its legal nature of the agreement is whether the agreement is lease or service agreement. Subject matter of the agreement, whether it's parcel A, parcel B, or parcel C. Here we say, and you have it in our presentation, there are two different slides. One slide speaks about the fact that these agreements appear not to be lease agreements because of the way they are worded, because of the name of the agreement. And also you have the analysis also here that shows that it is at no point clear whether these agreements have subject matter which are restricted to Dunavska 17 to 19 or Dunavska 23, land or buildings.
I understand, Professor, but what I'm putting to you is that while analyzing these agreements in your second report, and that was the first time, as I understand, that you saw these agreements, you never stated that these are not at all agreements that regulate some lease, but you were stating that these agreements relate to some other premises, and that is not the same. Not only in this para that I already read, 132, but also, for example, in para 134 and somewhere else as well.
We have
So
used in the past.
I would expect that if you consider that these are not lease agreements at all, that you would explain that in your report, and not that you would explain that they might relate to some other property that Obnova may have been renting. I'm quoting what you have said in the report. Would you say that you have changed your mind, same as claimants did on
No.
Friday when we had our opening statements?
I wouldn't. We discussed it. I will go through the report.
Okay.
We even used the lease agreement for one of the agreements that was given by Professor Jotanovic, 1983 lease agreement in the second report. But this reference to the lease agreement was the reference for the sake of understanding, not for the sake of determining its legal nature. It is very clear from our report that what we are saying is, okay, this part that you are now, that you have directed me to speaks about the subject matter of the agreements, but
Thank you, Professor Živković.
Yeah.
We can now move on to the subject that you have analyzed in your second report, and that is the subject of the agreement. Can we go back, please, to 1953 lease agreement? Can we have it on the screen, 1953, C7? And as you can see on the screen, it states that the municipality of Stari Grad leases out to Otpad, which is Obnova, part of Cadastre Parcel number 47. There it designates certain surface, and it says that it is in Dunavska 1719. You can see that on the screen. So if we go back to first report in para 132, you stated that pursuant to the lease agreement, to 1953 lease agreement, Obnova leased from the municipality Stari Grad land plot 47 at Dunavska 1719. Is that correct?
in which 100?
First report, 132 paragraph.
132. Yes.
So this lease agreement, as I understand, relates to what claimants now call Obnova's land in Dunavska 1719.
In 1953, yes.
Yes, in 1953, that's right. Can we now go to C? This is C160, and this is a lease agreement from 1962. Can you please see that article on the screen? Yes. So we designated also cadastral lots and the surface area. So we designated as cadastral lots 47, 49, and 50. And there is also some surface area designated in this agreement. And in we have to go back to your first report in paragraph 138. You state that the 1962 lease agreement stipulated that Pristanište Beograd leased obnova land at Dunavska 1719. Is that correct understanding?
Yes.
Thank you. Let us now turn to 1965 agreement that is exhibited as R9. It is also exhibited as RJ5, but R9. And from its article 1, we see that it refers to the open warehousing area on the cadastral plots 47, 49, and 50. And it also designated some certain surface area. Can we now go to page 44 of your second report? There is a chart. That is page 48 of PDF documents. And there you doubt that the agreement from 1965 relates to so-called Obnova's land at Dunavska 1719. And I'm struggling to understand that. Why? Because if I may finish, sorry. Because the 1962 agreement and the agreement from 1965 contain the exact same reference to land plots and the exact same surface area. And so I'm struggling to understand, how do you conclude that the former agreement relates to Obnova's land, but the later does not? If we can see again, agreement from 62 and agreement from 65. So this is agreement from 62. You can see that it relates to cadastral lots 47, 49, and 50, and the surface area. Okay, and can we go now back to R9? That is agreement from 65. Can we go up just to see that it is indeed the agreement? We have to go, sorry, down because it is bad. The Serbian version, please. Yeah, it is from 69. Okay, go back. Yes, 65, sorry. But can you see now Article 1? So there is the same designation of the property that is being leased. Would you agree?
Designation is the same.
But you said that they do not relate to the same premises.
If you note in our report, we said that we are instructed that land plots 49 and 50 were never part of Obnova's premises, and we were instructed that land plot 47 was significantly larger in the past and also covered the area outside of Obnova's present premises.
But if you disregard those instructions, and if you look description of the property that is being leased in the agreement from 62, and the description of the property that is being leased in the agreement from 65, would you say that these two agreements relate to same premises?
The designation is the same.
Thank you. Can we now look at the agreement from
Also just ask a clarificatory question. So your reference to "we were instructed" is in paragraph 134.
No, it's in the chart that I was directed by the council, by the respondent. On page 44, there is a table.
Yes, but I'm also drawing attention to your reference in paragraph 134, where you say, in addition, we were instructed that. I'm just wondering, and forgive me if I've missed it, in the last sentence of page 41, there were certain instructions that you were given. Did you see that?
Yes.
And I'm just wondering, and forgive me if I've missed it in your reports, but I looked through it. Do you have a statement anywhere in your reports where you say we were instructed as to the following and just listing them seriatim, or is it only individually as you go through various points?
It is only individual. We don't have the separate section.
Thank you. I'm just wondering whether it may be sort of useful at some point, we can direct this to council for the claimants. What you were instructed on is going to be very important for the tribunal's appreciation as to what you assumed, what you took for granted. So it's difficult to discover.
I understand. The instruction was there because we didn't conduct an inquiry ourselves of how big the plot was and whether the port area and where
I understand.
We didn't do it ourselves. I mean.
Well, I understand entirely, and it's entirely proper that you did draw attention to this. Often in reports like this, you see a statement right at the beginning of we were instructed or we assumed, and for the tribunal to pick up over the course of some very extensive reports, all of the items on which you were instructed is not so easy. So whether we request you to do so or whether we request council to do so, it may be helpful just to collect that. Thank you very much.
Thank you.
Thank you. Apologies. Apologies for interrupting.
No problem. Can we please now go back to your second report? Oh, sorry, we are in second report. And paragraph 81. So you stated that before 1997, it was not possible to issue temporary building permits in Serbia. And in the same paragraph, you state that thus permanent construction permits were issued for objects that were de facto temporary because of their physical characteristics. And then you further state that permanent construction permits were also issued for objects that were de facto temporary because of the existence of an obligation to demolish them at a certain time or at the request of a third party.
Yes.
Okay. So such demolition obligation that you mentioned in this paragraph, would it be included in the construction permit?
The demolition obligation stems from the title to the land. It could and need not be in the permit, as obviously we have it in the permit for obnova. And there are some other permits also on the case file that we saw that also contained this obligation.
So how would read the construction permit that is issued before 1997 for the construction of temporary objects? Would it possible that such construction permit for temporary objects does not contain the obligation, the demolition obligation?
Well, the real answer is I don't know, because I never saw all of the permits that were issued. Basically,
thank you. If you don't know, you don't know. Thank you.
Because you asked me whether there was a permit.
But
I never saw one. Okay, that's the good answer.
Have you saw some other construction permits that allow construction of temporary objects and containing demolition obligation that are also issued to other entities, not to Obnova, but in the relevant period?
In the case file, I saw.
Yes, you saw. Thank you. For the record, these are the construction permits are 156, 157, 58, and 59. And 50 and 58, yes. Oh, sorry, 59, sorry. And in the files, we also have some court decision where the court considered permits that contained demolition obligation and allowed construction of temporary objects. Did you had a chance to
which
see
which
those?
case? Are you referring to?
These are the court decisions that are also referred in Professor Jatanovic's report.
Can you, I don't know, what is the concrete decision?
Yes, sure. We can see one of them. For example, let's see decision R41. Page 1, and it says that it received approval to build a temporary commercial object, catering shop at location DD, with investor's obligation to remove the temporary object at its own expense and without the right to compensation. So this is also.
Yeah, I saw
yeah,
this
this one.
decision.
Okay, thank you.
That was the question.
So you are aware that there is court decisions that were discussing construction permits containing demolition obligation. Thank you.
Yes.
And before we continue, we should be reminded that 6 out of 7 construction permits issued to Obnova stipulate that Obnova is allowed to construct the object for temporary use and that Obnova shall undertake to demolish the object as soon as so requested by the competent authority. Do you recall that?
I recall.
And according to your understanding, the references in Obnova's construction permits to temporary use of the objects and the obligation to demolish them are in fact references to the corresponding provisions of the 1953 lease agreement. Is that correct?
For the ones issued after 1953, yes. I mean, there is I understand there is a building permit issued before 1953, which also has the same reference, but that is a reference to some other title. So
I don't remember that actually I saw that you mentioned that in your reports, but nevertheless, I think that is the first time that you are
there is
actually
a
clarifying
building
that.
permit that is prior to 53.
Yeah, there is. There is also a permit from 1949, sorry.
Yes.
So they
That
do not.
one is followed
They
by the one in
clearly do not
1954.
have reference to the demolish obligation from the 1953 lease agreement. That much we can agree.
Yes.
Thank you. Thank you. And according to your opinion, after termination of the 1953 lease agreement, the obligation to remove the buildings contained in the construction permit ceased to apply, and since of that date, Obnova's building could not be considered as temporary, but permanent. Is that what you argue?
It is. Actually, what I'm arguing is that from that day, you couldn't request the removal of the object. The object was temporary from the outset because it was constructed as temporary, but
Okay.
you had the obligation to demolish. That obligation ceased to exist after the contract which provided that obligation was terminated. This is what I think.
And the building themselves remained temporary.
The building themselves remained permanent. They were permanent from the beginning. They were never temporary. Temporary,
But
if you go to the Constitutional Court decision quoting the law later on, temporary objects are not brick and mortar. Temporary objects are kiosks, prefabricated objects, etc.
We will definitely come to that decision, but that decision relates to regulation enacted 50 years after issuance of construction permits that we discussed. So I'm not sure that there is any relation between the said regulation and the decision of the court related to regulation from 2003. But I'm again struggling to understand. So we have a permits issued for the objects for temporary use. with the obligation, with the demolition obligation. And you are saying that once the demolition obligation ceased to exist, these objects remained permanent as they were actually.
There was no more temporary use, there was permanent use. Temporary use has a consequence in demolition obligation. No demolition obligation, no temporary use. This is what I think.
Can I just ask a clarification, because I'm getting a bit confused. I thought you said a minute ago that they were always permanent.
I don't know whether they're permanent. To be honest, this is not my job to assess it. This is the nature of the object, and that's a construction expert can say whether it was permanent or not. But what I'm saying is that the nature of the object is decisive. That's you have it in the presentation. So basically, if they are by nature permanent, and I believe that they are, at least the ones that remained there for 70 or 80 years, then they were permanent from the outset. I don't know whether there were some other buildings, shacks, and the other permits that were submitted to us relate to sheds, temporary barracks, and
so that means that the original designation in the construction permit is meaningless then. For it says
No,
temporary use, it's meaningless.
it's not meaningless. You know, it just says that if I have a house and that house can stand for 100 years, it's a permanent object. I may have it for temporary use with the obligation to demolish it.
Okay.
It doesn't make the nature of the house temporary, just makes me burdened with the obligation to demolish it. Once that obligation is gone, I don't have the obligation for temporary. This is my point.
Okay.
This is what I think.
I think that's clear then. So your argument is that when the lease agreement expires, the temporary nature of the construction goes away because the lease agreement obligation to demolish goes away.
I wouldn't word it that way, but it's one way to word it, not to go into nuances. I would have worded it differently, but
Well, how would you word it then?
I would word it that it's not the temporary nature that would go away. It's the obligation to demolish that would go away.
Okay. So then my next question is and I think you say this in your report, you say that the lease obligation is a civil law obligation.
Yes.
The construction permit is an administrative act.
Yes.
So how does a change in the civil relationship amend an administrative act? That's what I'm struggling with a bit.
So basically, it's a good question. Administrative act, such as building permit, is based upon two different aspects, so to put. First is the title to land, which is a civil law title, which gives an investor the right to construct something. And the second one is the public law aspect, which has to do with the planning regulation, whether what is going to be erected is in accordance with planning documents. In the 1940s and 1950s, when these building permits were issued, basically, by logic of administrative law, the state could do and could order publicly as a bearer of imperium, as a bearer of a public authority, only what it is allowed by law to do. And it was not allowed by law to restrict the use to temporary. This is why I concluded that this is a reference to the civil law.
So it was ultra vires when they...
Yes, this is my point. You have it on a couple of places in the report, but basically under administrative law, the administrative authority can do only what law allows it to do. I have criticized Professor Jotanovic because he said, okay, they can have permanent building permits, but it's consumed. Then if they can have permanent building permits, then they can have a temporary building permits, it's consumed. But that's a logic of civil law. In administrative law, there is no place for such broadening of authority. You have the authority and you do it, you do what you can, what you're allowed to do by law. This is why I think that the permits themselves could not impose such a public law obligation to demolish. but only could reference civil obligation.
Okay, because the example I was going to give was that it just seemed a bit strange if I lease some land and I get a construction permit to build a building on that land, and then someone else leases that land, and they say, well, and the construction permit says it's 3 floors maximum, and then the new person leasing the land says, well, that doesn't bind me. I'm going to build another 2 floors because the other lease has expired. It would seem a bit strange if you could do that.
It is strange because when the lease agreements don't have to do with the leasehold of common law in Serbian law. Lease agreement is a contract, an obligation, and leasehold is a property interest. Right of use is the leasehold, and lease agreement is just the use of land in civil law. So basically, your example, if I have a lease and it allows me to build 3 floors, if I'm the lessor of the plot, I'm in the possession of the plot. If somebody else comes and get the lease, then my lease is terminated thereby. You cannot have 2 leases on the same plot. At least you couldn't.
I don't want to interrupt more, but it would be a bit strange if the new lessor decided to build another 2 stories because he said, well, the construction permit doesn't affect me because I'm a new lessor. So in other words, the administrative act changes because the civil relationship ends.
He would, in order to build 2 more floors, he would have to get his own permit for the extra 2 floors. And he would get it if he has a title and if the spatial and urban plan allows for 2 extra floors. If he doesn't, he can do it illegally. Unfortunately, in our country, it's possible. I'm
sorry for the interruption.
May I just ask one small point of clarification? I don't know whether it's relevant, but it's sparked by Professor Douglas's point. At the start of your cross-examination, Ms. Mihaj asked you, and this is at 152404 running through to 152433, and she said, would you agree that when it comes to the objects constructed after 1948, the material from which the objects were constructed and the duration are irrelevant for determining the status of the building as temporary or permanent? And you responded saying it's difficult to answer, it depends. The answer is actually no. It doesn't depend on the material, it depends on the way the material is used. And I'm a little confused as to what that means.
In the common law, you would use the term fixture in England and Wales. So basically, if there is something that is connected to the land and cannot be moved without being demolished, then it's permanent. If it is material, it can be concrete, but if you can move it, take it away, even though it's from the concrete, it's temporary, it's not permanent. So that is my idea.
So to be precise, depending on how the material is used is depending on whether it's fixed to the land.
True.
Thank you very much. That's
Thank you. And sorry for not being clear.
Ms. Mayor, just before you go on, we should at some point take a break. We've been going for a while. Do you want to take a break now? Or do you want to, no, if you're in the line of questions, you tell me when's convenient in the next couple of minutes or next few minutes, and then we'll stop for a break.
I'm sorry. I do have a few more questions.
Let's continue until you've come to the end of this topic and tell me when you have done, and then we'll take a break.
Thank you.
And it is going to be a shorter break. We've just got in the schedule just 15 minutes, and we'll restrict it to a 15-minute break. But you tell me when.
Thank you. And do you recall, Professor Živković, that only 2 out of 7 permits issued to Obnova refer to lease agreements, and these are C152 and 156, and only one of these two lease agreements, that is the later one, refers
Two lease agreements or two
Two le-
permits?
permits, sorry. I'm sorry. I repeat. So we have only 2 out of 7 construction permits issued to Obnova that refer to lease agreements. And only one of these 2 permits refers to the 1953 lease agreement in particular. However, you still go on to conclude that reference to the obligation to demolish the objects are references to the corresponding provision of the 1953 lease agreement in all Obnova's permits that provide for such obligation.
In my view, these 2 and the last one particularly are the only ones that explicitly mention the lease agreement, this concrete lease agreement or other lease agreement. But my point, the point that I'm trying to make is that you couldn't introduce this obligation through the permit itself. There must have been a title, and the title can be limited in time with the obligation to demolish. Once the title is terminated, then you don't have that obligation to demolish anymore. It is true, by the way, yes, there are only 2. In one, there is a mention of lease agreement, and in one, there is a mention of this particular lease agreement referenced by number.
You did not point though to any or practice, for example, that would confirm what you're saying. I'm just asking, you didn't point, you didn't refer to any core practice. in your report
We
that would-
referred to Supreme Court decision saying that when an object exists for 50 years, it's for the permanent use. And we referred to the Constitutional Court decision, which says temporary objects are only these objects, which are actually movable, which are not fixtures, as the honorable
We will come
president
back
would
to
say.
both of these decisions later
Sure.
on. But can we take a look to construction permits issued for the enterprise Koponic, for example, that is R156? That is just one of the examples that we have in the files. So that is also the construction permit issued for the construction of the temporary object that also contained
It's not for the
demolition
temporary
obligation.
objects, it's for the temporary use.
That's right.
And this is the installation of water supply and sewage. By the way, Obnova's building permit for installation of water supply and sewage don't have, it's one of the permits that don't have the reference to temporary use. And then Professor Jotanovic said that it is by nature so. Here we see that even water supply and sewage can be issued for temporary use, but I don't know.
Actually, I'm sorry, but that is actually construction permit for erecting a building for workers. Building, it says, yeah, so it's.
Mhm.
So it's.
A building for
relates-
workers' bathroom with
Yes, but still
canteen
it's building,
and perform installation of water
but still,
supply. So
it's building, and it says nothing about how that building will be built, what material will be used, and how material will be used. It just contains the obligation to demolish.
this is exactly my point. The obligation to demolish can go to the permanent object. I don't know really for this Koponic, whether it was a brick and mortar permanent building that would last for 70 years, or it was just a wooden shed. But I don't understand the question, to be honest.
Well, the question is, what do you think, whether all these other entities also had lease agreements with a demolition obligation,
It had some sort of title
which was
that
copied
was-
in the construction permits?
they, let me put it this way. The authorities couldn't issue the construction permit if this Koponic didn't have some sort of title to use the land. That title could be, and usually was, lease agreement when there was temporary reference to temporary use and obligation to demolish. But we have you have referred me to parts of my first report when I said that it was that it is 40s and 50s. it is difficult to evaluate them from today's point of view because not all paperwork was done fully proper. But Koponik must have had some sort of title to erect this building for its workers at this land plot. And this title was limited in time. It was given to them with limited time with the obligation to demolish, for temporary use with the obligation to demolish. The fact that I don't see that agreement right now doesn't mean that it doesn't exist. I mean, there must have been some sort of title. If there is no contract, then I don't
Then
know, the
which one?
party
Which other
commissioner
title,
called.
Professor Živković? Which other title that might be? If not lease agreement?
I really don't know. For this, I don't know. It could have been.
Not for these
there.
two, but in general, you don't know. Okay, thank you. We can.
No,
move
I
on.
don't know for this particularly. For the Obnova, it was the 1953 lease agreement for all permits after 1953.
May I ask just a follow-up question on this, please? I understood your testimony now in response to the questions from Ms. Miaj that you didn't know from the document whether this Kopanik, this workers' bathroom, was a bricks and mortar object or anything like that. But as one goes through this document, one gets a pretty good indication that it is in your formulation joined to the land, because so it talks about erecting a building, the installation of water supply and sewage. It then talks about must comply with the construction technical regulations and with its approval design, and is obliged to report the commencement of the works and the contractor to the construction inspection. And then under the rationale, the enclosed design for the building works, bathroom and canteen, and the installation of the water supply and sewage. This all suggests that it was not simply something on the back of a truck that was driven onto the land, put there, capable of being moved later. It suggests very directly that it was construction rooted in the land with sewage and water connections. I mean, do you want to just give a further explanation or clarify?
I agree with you.
Your microphone? No. Maybe the batteries run out. Let's use that one.
I agree with you. I would concur that it indicates really that it's a building that is permanent. But the question was, there is no reference to some sort of lease with the obligation to demolish. And I say, like, you know, if you imagine, like, let me be a professor just for a second. If you imagine football players and you don't see the ball and you see 11 guys running on the field, you know, you presume that there is a ball after a certain period of time because they're not just running randomly. So what I'm trying to say is that here I presume that there was a lease agreement and the counsel for the respondent asked me whether there was a lease agreement. I don't know because it's not referenced, but I presume that there was some sort of agreement giving the title to Koponik to build on that land, which was limited in time and which was with the obligation to demolish without compensation.
I am tempted to say that you're lapsing into being a professor for just a second, maybe rather different from the responsibility of a tribunal, because if we saw the players running around without a ball, we might reach the conclusion that we don't have evidence that there is a ball and that they're therefore just training.
True.
So, you know,
That's true.
Ms. Mihaj.
I know we have interrupted you a lot, and we're having, but it's related to this and something that you mentioned. So you mentioned must have been a lease agreement. So that's what I heard you said. So what I try to understand, this is let's say 1953, right? I understand that there was no right to private ownership over the land. And the municipality or the country has the right of use the land, right? So how a socially owned enterprise can use a land if it's not through a lease agreement? So my question is, what other forms in that time you as professor, expert in property law at that time. Because, and let me add that I'm perfectly clear, we have the same similar, I understand, right of use, right to use, we have the same. So
Don't take me to my word because I will have to double check. The textbook that I'm referring to was from 1955, and this is 1949, 53. So a couple of years before.
For example, this permit in 1953, for example, the one that we are just looking
1950, you could get the land also for permanent use. They could grant you right of use for construction. And that was from the outset, there was no limitation, no obligation to demolish. When you do it through lease, it was with the obligation to demolish and for temporary use. In my view, for as long as the lease exists. But you could get, there were construction in 1953 of buildings which still exist in Belgrade, which were constructed without the obligation to demolish. And then the state would convey the right of use directly to the investor, to the owner, to put it in the construction contracts terminology.
Okay. But I think, so just to clarify, I think you say in your report that you only can get a right to permanent use, as you describe it, once you've constructed the building. So prior to that construction, it had to be a lease, didn't it?
If you look at my report, and there is a reference to a textbook of Professor Simonetti, which was also referenced by my colleague, Professor Jotanovic. There were 4 different types of right of use. One of them was right of use for the purposes of construction, which I said is irrelevant for this case. There was a so-called temporary right of use, which was given to the expropriate. To save time, it is irrelevant for this case. There is right of use as an emanation of social ownership, and there was a permanent right of use which belonged to the owner of the permanent building. This last one is, in my view, important for obnova, because that is how it got its title on the land in Dunavska 17 to 19.
I understand, but at the point of time when you go to the authorities to get your first construction permit to build your first building, you have to demonstrate that you have some sort of title over the land. At that point in time, it can only be a lease, can't it? Because you only get the permanent right to use on your theory once that building has been constructed. You can't get it before.
No, you can get it before, but you don't get the so-called permanent right of use. This type of right of use was reserved for the owners of permanent buildings. There were, as I told you, other types of right of use. You can acquire very restrictively during socialism the right of use as an emanation of social ownership. It was a very restricted trade because it was very ideologically influenced, but you could also acquire the right of use for the purposes of construction. Then the municipality would grant you the right of use to construct the building, and you would construct the building without any obligation to demolish without compensation. Not all of the objects built in the late 40s and early 50s were with this obligation. We now deal with it, so we see a lot of such permits, but there were also, the government buildings for workers, residential areas.
Ms. Mayor, apologies from the tribunal for interrupting the flow of your cross-examination. We will attempt to rein ourselves in going forward. Your questions.
Not an issue at all. I have reserved all my day for this hearing, so. We can see now again R41, please. I think that it will help getting some answers. There is a Supreme Court decision, and it dealt also, we can see that is the part that is highlighted. So you will see that the plaintiff in that case received approval to build a temporary commercial object, catering shop at some location with the investor's obligation to remove the temporary object at its own expense and without the right to compensation when the land on which the object is located is brought to its purpose under the urban plan. And then at the end, the second page, we have para that is now highlighted, you see. Would you please read that paragraph also?
I'm sorry, I had an eye surgery. Could you make it a bit? Super.
Can you read it for us, please?
Pointing which one?
Yeah, that one.
Pointing out in the review request that the object in question was built on a concrete foundation, partly built from solid material and partly from wood, while firmly incorporated into the soil, so that this object cannot be moved from one place to another without damaging its essence, is unfounded, given that its construction as a temporary object was approved by the relevant administrative body, and of no influence is what material was used to build it or whether it's suitable for moving to another place.
So this court decision of the Supreme Court.
This court decision of the Supreme Court deals with the nullity of written agreement on sale of this particular object. And it is not about whether it's temporary or permanent, it's about whether the contract that was concluded for 50,000 Deutschmarks at the time was null and void because the subject matter of the sale was real property and it had to have the form of verified signatures. So the court actually decided here to give validity to that agreement, even though it was not formally correct for the real property. And in so deciding, he made these considerations in the rationale. But the rationale, as you know, is not an obligatory part of our court decisions.
But still, it shows the understanding of the Serbian courts when it comes to temporary objects and their legal nature. But thank you.
Okay.
Maybe we should now make the break.
Thank you. I think that's.
And thank you for that.
That's appropriate. Let's take a break until 22. A 15-minute break. 5 minutes. Okay, should we make a start? Ms. Mihaj, back to you.
Thank you, Mr. President. As I understood from our previous discussion, you agreed that before 1997, it was not possible to issue temporary construction permits. Is that correct?
Yes.
But is it known to you that construction permits issued in 50s, 60s, 70s of the last century that allowed construction of temporary objects with the obligation of the constructor to demolish it are usually informally called temporary permits? Did you notice that while reading all these court decisions that we have in our files? Because obviously these construction permits could not be temporary by the law because the law
In
did not allow
my
issuance.
opinion, first, the objects were not temporary, but with the obligation to demolish. And how the courts called it, it's, there is a couple of decisions I wouldn't comment on that. It surpasses my knowledge.
So you do not recall that in, for example, in RJ 58 and 59,
But here there is
construction
the orange
permits.
temporary permit.
Yeah, that's
It's-
right, for example.
So I don't deny
and-
that in
and-
this decision.
And the permits that is discussed, for example, that was the subject of this case is also issued before 1997. So that is how the courts called this kind of permits informally, like temporary permits, presumably because it is much shorter to say temporary construction permits than construction permit for construction of temporary objects.
Again, I don't think that the object is temporary.
I
I
understand
respect,
that, of
I
course.
understand
I'm not
how-
implying that you're saying that.
Okay.
I'm not implying at all. So is cadastre obliged to perform inspection of the building that is the subject matter of the inscription in the cadastre? To go to the location and inspect the building?
When?
Wherein it describes some rights over the buildings.
Today?
For today, 10 years ago, 20, 30, 50.
It's not the same.
For today, is it allowed to do so?
Today.
Is it requested, sorry? Today, is the cadastre requested to go to inspect the building before it registered the rights over the building?
Today, the registration of the building is made based
I said
upon-
registration of ownership over the buildings.
Aha, so that means that the building is already registered, so you register the owner.
Let's assume the building is not registered.
Okay, in order to register a building, you would have to go to a cadastral expert who would then record the building as such and make it in a proper way with this geodesy cadastral people make a project, record the building and submit it to the, and it needs to be an authorized organization for the cadastral activity, and then they submit it to the cadastre, and the cadastre registers the building. So it's not, if your question is whether an official of the cadastre goes to field inspection, that is not organized like that. That used to be like that until 2002, but after 2002, with the privatization of cadastral practice, there were authorized cadastral organizations who did it for the cadastre.
Thank you. I would like that we now move on to the court decisions related to Donavska 1719. And let us first see the first instance court decision, exhibited as C 168. So on 22nd September 2022, the Higher Court of Belgrade rejected Obnova's claim related to objects at Donavska 1719, constructed in accordance with the permits and the land under the objects. And we can see that decision now at the screen. And in your first report, you criticized this decision.
Yes.
So for example, in para 156 of your first report, you state that the court stated that Obnova allegedly based its claim on the so-called acquisitive prescription, which is a type of acquisition where a good faith possessor acquires ownership of certain assets if it has had an undisturbed good faith possession of such assets for a certain period. And then in para 158 of the first report, you say that Obnova actually did not argue in the court proceedings that it acquired ownership over the buildings at Dunavska 1719 through the acquisitive prescription, and that is the first reason why you criticize the first instance decision. However, if we can now see R86, and that is Obnova's submission, filed it to the court in February 2022. And there we can see that Obnova stated that it did acquire the right of ownership based on the acquisitive prescription. The translation here is not good. It says positive inscription, but of course, experts can also check the Serbian version of the document to confirm that this is actually acquisitive prescription ili održaj. So you see, that is Obnova's submission when it states that it did acquire the right of ownership based on positive prescription. Would you like to inspect the
Yes,
Serbian version,
because
please, just to see
I
that?
saw the action, the first.
Just go to Serbian version, please. Here you say, tužilac jeste stekao pravo svojine na osnovu održaja. So you confirm that. Can you please confirm that?
Yes. I
It is
confirm.
stated there. So would you now say that this critic is actually not founded?
Yes.
Thank you. And in para 157 of your first report, you criticize the court decision from September 2022 and disagree with the court's conclusion that Obnova did not acquire buildings at Dunavska 1719 through acquisitive prescription because it did not fulfill the good faith requirement and because its possession of buildings was not lawful. So, as you noted in this report, this is the first report, the court concluded that Obnova did not fulfill the good faith requirement and that its possession of buildings was not lawful because Obnova constructed its buildings and based its possession thereof on, I quote, buildings, permits, and decisions of the competent authorities that are of temporary character, i.e., he was aware of the fact that he was allowed to construct temporary facilities that have to be demolished at any time upon the request of the competent authority. So in paragraph 160 of your report, you disagree with this conclusion of the court and state that Obnova's permits and buildings are not temporary. That is also what you are stating here. However, as we already saw, this is not the only court decision that informally calls this kind of construction permits temporary. Would you agree with me on that?
We saw the decision a minute ago. I agree on these two decisions at least. You know, I don't know, there might be some more.
That are calling construction permits issued for construction of temporary objects as temporary construction as a temporary construction permits. That's right. Have you had a chance to analyze the court case that relates to Dunavska 1719?
No, actually, I read the decision and I read the motion. I didn't go through the whole case. I was not allowed to, you know, I was not acting.
And so then I have to inform
You said you were not allowed to, and then
I mean, I wouldn't have the right to do it. I wasn't acting in this case.
right, so you did not have
I
access to
I
the
did not
document.
have access.
Thank you.
then probably I should not ask the several follow-up questions. That actually concerns the fact that in that case, Obnova was not saying that demolition obligation was copied from the 1953 lease agreement.
Obviously, I didn't see the case because I missed the plea of acquisitive
But that is
prescription.
so that is actually refers to your critic to the court's conclusion that these objects are temporary because
My biggest
no one
critic-
explained to the court what you are trying to explain this. The demolition obligation was actually copied and ceased to exist when the 1953 lease agreement ceased to exist. But since you didn't read the documents,
But
that is
if
probably
you
not.
allow, my biggest problem with this decision is with the fact that, once they say it's a temporary building permit, it's a temporary object that is not really real property, it's movable, it's chattel, whatever. And then they say, and Belgrade is a registered holder of those buildings in the real estate cadastre. This is very difficult for me to put into any sort of comprehensive or logical. I understand that they didn't do it and it's a first instance court, but even the second instance court didn't do it. And this is my biggest problem with these two decisions, actually, because they have an obvious contradiction. On the one hand, they say it's a chattel. On the other hand, they say, but Belgrade is registered as the owner of those buildings as real property in the cadastre.
And assuming that the court is right, correct, that the conclusion of the court is correct and that these are temporary buildings, would you expect from the court to disregard what is already established stance at the court practice and to accept decision of the cadastre to inscribe ownership over temporary objects?
There is a statement in your question. I disagree fully with the contention that it's established practice of the court that it's temporary. The established practice of the court is when something is temporary, it cannot be registered in public books. It is not subject to registration. It's a movable object.
And it have to be removed and demolished if requested.
Removed and demolished is, it is not an established case law, nor is it unified case law. I have two cases saying differently. One from the Constitutional Court, and you told me that you're going to come to that,
I will.
and the other from the Supreme Court, which I presume we're also going to come to. So I simply don't see a uniform practice. And if there is a uniform practice, is that the temporary object cannot be registered. However, there is a possibility to register a temporary object under the cadastral registration, but there needs to be a note that the object is temporary. You have it in our first report, which note does not exist here, and you register a holder, not the owner. And Belgrade is registered as the owner, which not only indicates that it's a legal structure and object, but also it's a permanent structure.
Let's now look at the second instance decision related to NASCA 1719. The question, the subject matter of the question will remain the same because the explanation is pretty much simple.
Well, okay.
So in
asked,
paragraph,
I will say.
so this decision is exhibited as C503. So you also state that this decision is incorrect and you basically repeat your arguments related to the first instance decision. And in para 121 of your second expert report,
Yes,
you state, you state that the court should have determined ownership over the objects in question. But in para 173 of your first expert report, you stated that the real estate cadastre can register persons that constructed buildings with a temporary character only as holders, but not as owners of such buildings.
Yes, exactly.
So if the cadastre can only register holders of temporary objects, if cadastre cannot register that someone is the owner of the temporary object, how do you expect from the court to render a judgment which would serve as a basis for inscription of ownership? Wouldn't that be contradictory?
Well, it wouldn't, because there is already an owner which is registered in the city of Belgrade.
Let's assume that that registration is wrong.
That registration, by the way, is wrong. It's the wrong owner.
Okay, so the registration is wrong, and the city of Belgrade is not registered as the owner. As the owner of the buildings in question.
I don't,
The
excuse me,
registration.
I
is
don't
wrong.
understand fully your question. I'm going to try to
Let's
answer. I don't know
let's
what you
assume
expect.
let's assume that the city of Belgrade is not registered as the owner over the buildings in
So if we
Dunavska
assume that the
1790.
buildings are registered, then Belgrade is holder. Or what do we assume? That nobody is registered? That the buildings-
Nobody is registered.
And are the buildings as such?
Nobody is registered. And is
So no
all
buildings.
Nobody is registered. And is obnova in that case, would obnova in that case have the right to request from the court to determine that obnova is the owner of the
Yes.
temporary buildings?
Not the owner of the temporary buildings, as you're putting it to me, and I understand. But in my opinion, the buildings are not temporary, and you would have the possibility to go for the declaration of ownership. The registration,
But if buildings, Professor, let's assume that buildings are indeed temporary. Let's accept conclusion of the court. I know that you disagree with that conclusion, but let's assume it. So the buildings are temporary.
okay,
And in that case, is court's decision that rejects claim that would determine someone's ownership over temporary buildings would be correct decision to reject such.
it
such
depends,
claim?
of course, on the grounds of the ownership, but now I understand your question. It is wrong. The proposition that temporary objects, kiosks, ready-made concrete factories don't have the owner is, for me as a property lawyer, property law professor, incomprehensible, to be honest. I don't deny that there are some court decisions saying so, that it's not the subject, but Professor Jurtanovic has it in his report, that these temporary objects are not subject to ownership rights. But I really cannot agree to that, not now, not in front of the tribunal, not ever. I mean, what are then they? They are res nullius, nobody's. Especially if you can't buy or sell it or lease it, or, they are leasing out these buildings. They are leasing out kiosks, which are, in my view, temporary objects. How can you lease out something that is, this is beyond my comprehension.
Professor Živković, but you still agree with me. You have already agreed, but let me just remind you that you agreed with me that temporary objects are considered movable property.
Yes,
Thank you.
of course, in my perception of a temporary object, which is indeed movable, it's not the picture.
Let's now go to R40. And let's see articles 76 and 98 of the law on planning and construction from 2003. And from these articles, we can conclude that this law differs between prefabricated objects and temporary objects. And construction of temporary objects requires preparation of the main project and the project for its demolition, while for installation of such objects, there is no need to prepare any of the technical documentation in accordance with the law on planning and construction. Would you agree with me?
Yes.
And in the decision that you refers to several times of the Constitutional Court from 2010, it is C56. Constitutional Court refers to the said law from 2003, law on planning and construction, and states that, I quote, only smaller prefabricated buildings that are placed in public area, kiosk, gardens, mobile styles, etc., have a temporary character. But I suppose that you disagree with this conclusion of the Constitutional Court because you have just confirmed that the law on planning and construction from 2003 actually differs between prefabricated objects and temporary objects.
Actually, no, this decision of the Constitutional Court puts a connection between Art 76 of the law on planning and construction of 2003 and Art 98. It says, if you see the whole paragraph, that law on planning and construction, as well as the law on planning and construction in force, which is the 2009 law on planning and construction, which was passed in the meantime, did not contain provision defining the term of temporary facilities. Now, then it says under Article 76, you can lease an undeveloped public construction land for a certain period of time, whereby the facility is built on that temporary nature. Whereas under Article 98, only smaller prefabricated buildings that are placed in public areas had the temporary character. So connecting the two, what the Constitutional Court said is basically that only 98, only the objects from 98 can be erected in line with 76.
So you're basically saying that in fact, according to the law from 2003, only prefabricated objects were considered as temporary.
I didn't say that. That's what the Constitutional Court said.
And do you agree with that?
Yes.
You agree that according to the law from 2003, only prefabricated objects are considered as temporary objects. I think that my question is pretty much clear. And we
Yes,
have
I agree.
already established that prefabricated objects.
I mean,
and-
I'm thinking now about the objects that acquired temporary licenses under 1997 legalization legislation, because I
Professor,
don't know whether
maybe
you
you
are
should-
where you are aiming.
If you would like to read again Article 76 and 98 of the Law on Planning and Construction from 2003, once again, just to clarify, do you consider that according to that law, prefabricated objects and temporary objects are the same? Go ahead if you need to read it again. I would be surprised that you say that you agree that they are the same, but of course, whatever you say. It seems to me that this law indeed differs between prefabricated and temporary objects.
This is certainly one of the possible interpretation. The other is the interpretation by the Constitutional Court.
Okay, and let's see the subsequent regulation. And that is the Law on Planning and Construction from 2009, R201.
It's
And that is with the
147.
amendment, yes. And that is actually the version with the amendments from 2023.
Yes, yes,
Yeah.
it's 147.
And would you agree with me that that law differs between prefabricated objects and temporary objects, and actually explicitly provides for issuance of temporary construction permits for temporary
Yes.
objects? These are Article 146 and 147.
Yes, as you can see, 147
Yeah.
is the one.
So
with
can
the-
you confirm that in Article 147, the law stipulates that temporary construction permit is issued for construction of, for example, temporary roads?
Yes, yes.
Yeah.
Aggregate separation plants.
Yeah,
This
yeah,
is
lot of-
this is actually the article I quoted when
yeah.
I said that they trade with it, they buy it and sell it.
And would you say that the roads are not smaller prefabricated objects?
Yes, yes,
Such, yeah, we would agree with that.
agree. I mean, there are also prefabricated demountable objects
Yeah.
in
So would
147.
you, would you then agree with me that conclusion from the Constitutional Court's decision, C56, that only smaller prefabricated buildings have a temporary character, is actually not accepted in the law amendments that followed that decision. Because
Well,
that law-
this is the interpretation of the Constitutional Court
Yes,
of the
but that was
2003
not-
law.
The 2003 law, that's
Yeah.
right, but that actually.
I mean, this
that's-
simply doesn't apply to the 2009. law.
It was not accepted in the following amendment.
Well,
That's
if you see, if you can go to the other,
right. Mhm.
the Constitutional Court passed this decision in 2010, even though it took into consideration the 2003 law on planning and construction. In the meantime, this law was put out of force and the 2009 law on construction has been adopted. So if you would be so kind to go below the quoted part.
Thank you,
It is,
Professor Živković.
okay, thank you.
Thank you very much. I would like now that we spend some time on discussion related to Dunavska 23. So we are back again to your first report in para 201. You stated that you have not been provided with any documents confirming that Obnova had the right to construct its buildings at Dunavska 23. However, in the subsequent paragraph, you say that even assuming that the state's consent of Obnova's use of the land at Dunavska was never formalized in any agreement, Obnova still acquired the right to use the land at Dunavska 23 through acquisitive prescription. And then again, in the next paragraph, you state that according to acquisitive prescription, a good faith possessor acquired ownership of an immovable asset over 20 years of undisturbed possession. Is this interpretation of mine correct?
Yes.
Thank you. So would you agree that the law on basic ownership relation, which is C 179, in Article 72, paragraph 2, provides that good faith possession exists if the possessor is not or cannot be aware of the fact that the property in his possession is not his? Yeah.
I mean, the case law widened this provision for
But can-
acquisition of the right of use.
But can you please confirm that this is what?
Yes, I
Yes,
confirm.
okay, thank you. Then in your second report, in paragraph 163, you conclude that it is not possible to conclude that any of the agreements produced by Serbia, or Professor Jotanovic, relate to Dunavska 23. And for the sake of completeness and for the sake of the record, Serbia argued that the agreements from September 1959, April 1960, February 2000, November 2003, and March 2006, which are exhibited as R7, 8, 14, 17, and RJ11, refer to Dunavska 23. So additionally, in the same paragraph, you say that even if these agreements related to the land at Dunavska, that would not change the fact that Obnova acquired the right of use over such land. And then in paragraph 170 of your second report, you explain this and state that at least between 1961 and 2000, Obnova held the land at Dunavska 23 without paying any fees of any sort to any lesser. And the Obnova even constructed a number of objects at the premises. In your opinion, these facts clearly indicate that Obnova was of the belief that it had the right of use over the land, and that thus Obnova was bona fide possessor. And then you say, consequently, Obnova acquired the right of use of the land in Dunavska 23 by acquisitive prescription 20 years after it started to use the premises. As I understand, you base your conclusion on the assumption that the lease agreements, that no lease agreements were enforced after 1961, when the lease agreement with the Directorate for Danube River Bank was terminated, all the way until 2000. So that is
Actually, I
presumption.
believe it's from 68 until 2000.
In paragraph 117, your second report, you say at least between 1961 and
Okay,
2000.
true. I mean, but in 1961, I don't even know whether they had the possession.
Yeah.
The first evidence on the record of possession is the 68 construction of gate.
Okay.
It's in the
So
privatization.
the termination of the agreement in 1961 actually is important in your conclusion. And I would like to ask, would you generally say that the termination of lease agreement is justified reason for acquirer to start believing that he has property rights over certain property?
Listen, I have, and you quoted this paragraph said that I actually have no documents on
Thank
the
you.
title of Obnova to that land. What I have are only facts and assumptions. What is important under Serbian law is that there is a 20-year period in which you really thought that you had the right. After this, there is this Latin thing, mala fide superveniens non nocet. Even if you find out that you didn't have the right, you actually acquired it through acquisitive prescription. What I saw is that after the early 60s, and I don't even know when, I know that today Obnova has this 2023, okay. And it's, I was also instructed with that. I never went to the premises to see it. But if there is a 20-year period in which you have a good faith possession, then you acquire right of use by acquisitive prescription. And if you allow me just a minute of your time, if not, I'll stop.
Please, Professor, of course we allow.
Very shortly, there are two types of acquisitive prescription in Serbian law. One is regular, the other one is irregular. What we are speaking now is the irregular. Regular acquisitive prescription has to do with acquisition by contract. So you try to acquire by contract, there is something wrong either with the contract or with the title of your predecessor, you don't acquire, you need acquisitive prescription. Extraordinary acquisitive prescription is possible as a self-standing means of acquisition. So there is no need to have a contract which would then assure you that you thought that your possession was genuine. It's simply, it's enough that you think that it is yours and that 20 years pass when it comes to real property. And what we saw is that actually there is a 20 years period. And I don't know whether by chance or not, but the first record is that there was a gate constructed in 1968 that is from the privatization program. And the first building was constructed exactly in 1988, 20 years thereafter. Of course, I don't have the documents to substantiate that, and I don't deny it. There are no documents.
Can I now ask you about a different issue? Do you agree that inscription of another person's rights in the land books, the cadastre, would in general prevent a person from arguing that it was a good faith possessor?
No, it's a contra tabulare usucapio. It is like really a professor thing.
And it would be required for that person to prove that it had some document that was ground for him to believe that he and not the registered owner is the actual holder of the rights. Is that correct?
Not if it is a self-standing means of acquisition of right of use or ownership. Because these documents should make you believe that you're the owner. But if you do believe, even in the absence of such document, and you do believe for 20 years, and I don't know why, I don't want to speculate. then you get the ownership.
So you see no problem with someone else's being inscribed as the owner or the holder of the right of use over certain, for example, land. And there is some other entity who doesn't have any documents that would actually show that he has, you know, the right to believe, the reason to believe that he is the real holder of the right of use over that land. And you would still say that that possessor is a
Your
bona fide
question
possessor.
is whether I see a problem. For whom? Yes, I see a problem for the person acquiring through acquisitive prescription. It's easier to acquire and to be in good faith if there is nobody registered and if there is someone registered. So the problem is there. I just say that I cannot exclude the possibility that despite of somebody else being registered, you could be in good faith. This is my position.
Without having any document, which will actually give you the reason to believe that you are the owner. Without having any document, which will give you the reason to believe that you are real holder and not another person who is inscribed in the register.
There is no requirement for the extraordinary acquisitive prescription to have the document to rely on.
We are speaking about good faith criterion, not about whether the law requires the document, but we are speaking. What are you teaching your students? How would someone prove that in reality he is the owner? I will now use the owner instead of holder to shorten. How would someone prove that he is the owner of some property? The property for which he is not registered in the land in the cadastre, but someone else is registered as the owner, and that person, alleged good faith possessor, doesn't have any document which will actually present reason for him to believe that he is the real owner. Are you saying to me that you will teach your students that it is possible actually?
Yes, you go to court.
You go to court.
You sue the registered owner. Let's forget about the right of use for a certain time. You prove that you have 20 years of undisturbed possession.
And that you are
under
good faith.
the same article that you showed on the screen, good faith is presumed. So it's a rebuttable presumption, of course, and the other party can rebut it and say, no, you don't know.
So if I'm sorry, Professor, but if I'm registered owner, and for example, my colleague Jeric says, but I have possession of that property over 20 years, and I'm good faith possessor. I, as a registered owner, will have to prove that he is not good faith.
Yes, of course.
I will have to prove.
If you can
My
put the
registration in cadastre is
77
not
there,
enough.
it's-
My registration is in cadastre is not enough to rebut the presumption that in that case my colleague Jeric is a good faith possessor of the property.
Okay. It depends. It can rebut this good faith possession. Depends.
Thank you.
If this is just a point to ask a question to you, I'm just thinking about the planning of the rest of today and tomorrow and all the rest of it. The tribunal, of course, intruded into some of your time, and your time is your time. But could you give me an indication of whether you think we are likely to finish today, or we should be thinking about sequestering the witnesses overnight at some point, whether this is in half an hour, an hour?
Yes, I know. I think that I will speed up.
Thank you.
And
yeah, maybe it would be useful if Mr. Orjo could tell us how much time do we have left overall, if that's possible.
He will do so as we go on. It'll take him a while to calculate. But I'm, you know, we obviously have a little bit of time where we can go on still today. We do have a housekeeping matter at the end, which we need to address today. You know, if we go on through to 6:30, that's fine. If you are going to take us through to 7:30, that's not fine. I just don't have any idea of how long you've got to go, because it seems to me there are a number of big topics that you haven't even begun to get to.
Yes, you're right. I will try. I will do my best. That's all I can say. Sorry.
Well, I want you to do more than that if you can, because you can do your best in terms of the questions, but I want you to give me an indication of whether you.
I'm not sure about 6:30, but until 7, I will be done.
Well, I'm not sure that I'm going to allow that, because we're then going to have redirects and tribunals questions. So I think the tribunal secretary can tell you, you know, your overall balance of time
I will
left.
be quicker.
Respondent still has 3 hours, 56 minutes.
I will have
overall.
to be quicker.
You will have to, and that's overall because you've got tomorrow.
Yes, you are, we are right. I will have to. Yes. I will do it until 6:30.
And I make an observation, because obviously at the end of the day, you're going to have to draw the threads of this cross-examination together for the tribunal, without prejudice to where you're going, because we don't really know where you're going until you get there, until you tell us. We're not quite sure which of your questions and which of the answers are critical to your case, and which of them are taking issue with the expert report. So the more that you can focus it, the more it's going to assist us.
Of course, thank you.
Thank you.
Just, I have to ask another quick question related to acquisitive prescription and another condition for it, and that is undisturbed possession. So in your first report in paragraph 201, you state that you understand from council that Obnova has had undisturbed possession of both the buildings and the land at Dunavska 23 for several decades, at least from 1968. But this is again just only instruction. You have not seen any documents in that regard. You cannot tell us anything. Okay.
I mean,
move
the
on.
document I saw, excuse me.
What did
I
you
saw the 1968 is from the privatization program. There you have the gate.
Yes, I know.
yeah.
Can I speed up? But
Please.
I will
Okay,
refer
sorry.
to that. Sorry to interrupt you. Yes, I know. I'm aware that in your report you stated that you have seen in the privatization program that that in 1968 there was a gate constructed in that location, and then after between 1988 and 1992 some objects were constructed, but between that period, do you have any documents that you saw
No.
that prove that Obnova used
No.
the premises? No, thank you. Okay, we already done this, which is very good. I'm not sure whether I already asked you. That's why I will just repeat. And if I am, I'm sorry. But would you agree with me that all laws regulated in legalization proceeding require that the applicant provide proof of ownership?
Yes, I understand that you already asked me.
Yes, I already asked you. Sorry.
And I told you that it's not the proof of ownership, but the proof of right allowing the construction. And not a genuine proof of right, but some indication of right. If you remember, it was in the beginning of my testimony.
And do you came across any document that demonstrate that Obnova actually possessed that kind of documents related to the construction of illegal objects?
In 201, it's clearly said we have not been provided with any documents confirming that Obnova has the right. We have been very clear on that.
Thank you. And can we now go to, again, first report, paragraph 142? And there you stated that in March 2003, Obnova tried to remedy the lack of registration by submitting a request to the real estate cadastre asking for a formal registration of its rights to the buildings at Dunavska 17, 19, and 23. And you also state that you understood from council that Obnova never received any decision addressing its request.
Yes,
And does Serbia legal system recognize any legal remedy which could be used if the administrative authority indeed fails to issue a decision to the party within?
there is a remedy.
Yeah, there is. There is
Yes.
a remedy.
Yes,
And that would be,
a request for the silence of administration.
thank you. And do you maybe know, was Obnova able to, was Obnova filed such remedy?
I don't know.
You don't know.
This is 2003.
Okay. And do you consider that, so we are speaking about 2003 request to the cadastre. Do you consider that the construction permits that Obnova have represent a valid ground for inscription of Obnova over the object at parcel 47?
What the inscription of Obnova as the bearer
Inscription
of the
of
right of
Obnova.
use of land, or
Let's speak about inscription of any rights you can imagine. So Obnova requested in 2003
yes,
to be inscribed as the owner over the objects at Dunavska 1719, and Obnova also enclosed to the request construction permits.
on the
that we
18
have
March
also seen this.
2003, it should have been registered as the bearer of the right of use over the buildings. That's as a bare minimum, because it was before privatization, I presume.
So the construction permits that Obnova had were enough for Obnova to be inscribed as the holder of the right of use over the objects.
Yes, and before, because 18th March 2003, that was a socially owned Obnova pre.
And otherwise, it would have right to be inscribed as the owner, yeah?
After
After
privatization.
But you state that the real estate again, in your first report in para 173, that the real estate cadastre can register persons that constructed buildings with a temporary character only as holders, but not as owners of such buildings.
This is, there is a mountain of changes in registration legislation from 2003 to 2000 and now.
We are speaking about 2003.
Well, I'm not in 173 speaking of
So
2003.
back then it
The
was possible-
holders were introduced in, don't hold me to my word, but somewhere in the 2000s after.
So are you saying that in 2003, the rule that the real estate cadastre can register person that constructed buildings with a temporary character only as holders, but not as owners of such building didn't apply?
And you see that the footnote 210 refers to the law of 2009.
Professor, please.
I'm sorry,
When
maybe I'm
Obnova-
tired.
yes, yeah,
And I know that you're in
I
a
fully
hurry.
understand. I fully understand.
But
So we
this,
have Obnova's request from 2003, and Obnova had construction permits that we are all familiar with, that are saying that it can build the objects for temporary use that should be demolished. And Obnova encloses these permits and requests to be inscribed as the holder of the right of use. And my question to you is, would it be possible for the cadastre to inscribe Obnova as the holder of the
In
right of use
2003,
over the
yes.
objects over in 2003?
yes. As you see, this quoted part of my paragraph 173 refers to the law that was passed in 2009.
And in 2003, it was possible to be inscribed as the owner over temporary objects.
Well, Belgrade was registered as the owner of these Obnova's objects.
But do you consider that, I'm asking you.
I just consider that
I'm-
it's the wrong owner, but I'm not disputing that the ownership could be registered. This
So
is
you
my
consider
position.
that in 2003, the ownership could have been registered over the temporary objects, temporary buildings?
The buildings were not temporary. Let's not do the vicious circle. I mean, if the buildings were
Professor
temporary, then
Živković.
it would be kiosks.
Professor Živković, let me try once again. If you are the clerk working in the cadastre in 2003, and Obnova requests to be inscribed as the holder of the right of use over the objects in Dunavska 1719, and as a proof of its ownership, it encloses construction permits that we are all familiar with. Would you register in 2003 Obnova as the owner of the objects that are constructed based on the construction permits that says that Obnova is allowed to construct the objects for temporary use, which is obliged to demolish at the request of the competent authority?
Well, it's the question, would I?
What would you
register?
do? Do you think that it would be the right decision back then in 2003 to inscribe the Obnova as the owner or not?
As the bearer of the right of use, as I told several minutes ago, yes.
Can you explain? Why would you allow Obnova to be inscribed as the owner based on such kind of permits? Because that is,
You're not based, because the permit shows that Obnova constructed the objects
for temporary use.
in 50s and now it's 2003.
So
I
you,
have been working as a consultant for the cadastre in 2002. You don't want to know what was possible to be registered at that time.
I'm not, I know
I
that,
understand.
I'm
but
not asking what
you
is
are asking me
possible.
what
I'm
would be
asking what
proper.
do you, what would be,
I would register it as the bearer of the right of use. This socially owned company. Yes.
over such buildings?
Yes.
Thank you. So, and the cadastre should have just disregard the part of the permits saying that the objects are for temporary use and that they have to be removed.
Well, if they have to be removed, they have to be removed. I don't know how should I put it. I understand that there is a different line of thinking. I'm struggling with the ministries in Belgrade. There are 2 million non-registered illegal objects. It's a bigger story. My answer to you is clear. Yes. Why? Because even though with these two, temporary use and the second one, obligation to demolish, the construction permits allow and clearly demonstrate that Obnova constructed these buildings. If the obligation to demolish is there, they won't be saved by the registration. It doesn't mean that if you register, the obligation is gone.
Okay, thank
If
you.
the obligation is there, it's there. If it's not, it's not.
Now we're going to turn to privatization program of Obnova. So in para 143 of your first expert report, you state that the privatization programs contain important financial information about the subject of privatization, in particular information summarizing the assets and obligation of the subject. And let's look at Obnova's privatization program from July 2003, that is R46. On pages 6 and 7 of PDF that we can now, can you see it on the screen, please? And so we see charts that were included in Obnova's privatization program, and in the chart that should list the construction land over which Obnova has the right of use, it is stated that Obnova actually has no land, it is zero. Do you agree with that? Yeah?
Yes.
Yeah, okay. Can we then agree that in privatization program, Obnova made it clear that it had no construction land in its ownership, or nor the right of use of any construction land, to be precise? Yes.
in privatization program, this was stated because of this note. The Republic Geodetic Authority report indicated that there were no registered right of use.
And apparently Obnova accepted that because Obnova didn't oppose to that. Can we now go to privatization program as well, but these are pages, page 3 of PDF. And it is stated that Obnova was the user of 15 objects on land on parcel 47, located at Dunavska 1719, and 8 objects on land, plot 39, located at Dunavska 23. However,
Yes, that's where the years are. 68.
Yeah, I know. However, on page 5 of PDF, we can see that, that is it. That's it. We can see that Obnova noted that these objects were in some cases of temporary nature or constructed without planning, construction, and use permits.
Well, this is also a report from the Republic Geodetic, from the land registry. Republic Geodetic Authority was the competent.
But still, would you agree with me that it was important for Obnova to make such an annotation in its privatization program? You would agree on that, yes, as we can see.
Well, they did make.
Yeah.
That's for sure. I mean, they were informed by the Republic Geodetic Authority that their subjects submitted and not to read it. You know. But this is a report from the Geodetic Authority, which was presented by Obnova.
Which was important if not enough for Obnova to mention it in the privatization program. I have only one more question related to privatization, just to make sure that we are on the same page about this. Would you agree with me that the privatization of shares of the subject to privatization cannot per se create any property rights on part of the subject of privatization, but that privatization can only transform some of the already existing property rights of the subject of privatization into the ownership right?
Yes.
Yeah, thank you.
I mean, if you had the right of use,
Yes,
apart from the construction land, you become
land,
the
then you
owner
can-
of everything that you had the
that
right
was my
of
point.
use.
Thank you for clarifying. In paragraph 178 of your first expert report, you say that Obnova's rights of use over the land and had priority over the right that was, as you say, supposedly held by Luka Beograd between 1961 and 1975.
Yes, that is.
Okay, and Luka was inscribed in the Kandastar, while Obnova was not.
Yes.
Right? Yeah, you agree. Okay. But have you seen any documents that would actually prove that Obnova has initiated a court proceeding against Luka Beograd to prove its alleged unregistered right?
No.
Now we can go to conversion. In paragraph 149 of your second expert report. I'm sorry, Professor, I will move you to second report. You state that the fact that Obnova's rights of use was not registered in the cadastre did not preclude the existence of Obnova's right to convert its rights of use into ownership. It only required that Obnova undertake certain formalities. First, register its ownership over the buildings and the right of use over the land, and then second, complete the conversion procedure by registering its ownership right over the land. But would you still agree with me that in Obnova's case, the situation is not that straightforward, because before this formality, as you tend to describe registration in the cadastre, Obnova would have to obtain court decision to prove it's a registered right. Is that correct?
I stand by this paragraph fully. So, sorry, to be short, if Obnova had the right of use of the land, it had the right to conversion. Everything else was just the requirement of procedural steps. Of course, first they would have to obtain the decision,
Court decision.
Ownership over the buildings, and then registration of right of use over the land, and then go and initiate conversion procedure. But my point is,
thank you. I'm in a little bit hurry, sorry. Can we now move on to expropriation? I have only a few questions about that. Sorry. Okay. Now you will have some time for yourself. So.
And Ms. Mia, just in case it's helpful to you on your calculation of timing, as I understand it, from tomorrow, in terms of the reservations of time that the parties have given, you are going to require something like 3 hours, 25 minutes for your experts to make their presentations and for the time that you reserve for redirect. I may be wrong, the registrar can correct me, but I think about 3 hours, 25 minutes. I think that from the point at which Mr. Oja told you that you had 3 hours and 56 minutes left, that was 17:24. So you used another 20 minutes. On my rough and ready calculation, if you want to preserve your time for tomorrow, you've got about 10 minutes to deal with expropriation. Now, you of course can use your time tomorrow as you see fit, so you can shrink it and whatever, but the experts have got their 20-minute presentation. So I'm just giving this to you now because I think you are bumping up against the time that's allocated to you. You're going to have to be quite judicious in how you use your time.
Thank you.
If I may briefly, we have calculated that we are going to make tomorrow's cross-examination much shorter. And so I think that we can, not tomorrow's, the Friday's cross-examination, much shorter. So I think that we can still fit.
Well, as I say, your time is your own. I just don't want you to find that you're going to get to the cross-examination of Professor Arizanovic, which you've got down here for 85 minutes, and that you find that you've only got 10 minutes.
Of course, we are aware of that.
Yeah.
Thank you.
Thank you.
Would you please tell me, Mr. Milošević, can movable property be expropriated?
If you are talking about the law on expropriation, only immovable property is regulated by that law.
Thank you. And from your reports, I understand that you're alleging that in the event of de facto expropriation, entities whose rights were expropriated can approach the relevant authority and request compensation. And only if the responsible authorities refuse to provide the compensation due, they have to pursue the claim for compensation through Serbian court. Is my understanding correct?
Can you find me that paragraph? I know what are you implying at, but just show me which one are you citing, please.
I think that it is first report 251. Yeah, 251.
Yes, that's correct.
And that this also applies to de facto expropriation. Your conclusion from 251 also applies to de facto expropriation, that you can go directly.
Yes, it applies to de facto expropriation, yes.
Also applies.
Also, yes.
So the land directorate in this case could have in itself decide that unregistered owner is in fact the lawful owner of the rights which were expropriated.
The LDA was the authority who was entitled to decide on compensation, yes. And not,
To decide about the existence of de facto expropriation, not only about compensation, but to decide whether in particular case there is de facto expropriation.
well, if it admits to pay the compensation, then it accepts that there is de facto expropriation. So that's just preliminary issue upon which it has to decide in order to negotiate positively and settle.
And so the land directorate can itself decide that unregistered owner is in fact the lawful owner of the rights.
Sorry, I didn't hear you.
For in our case, we have Obnova, who is not registered in the cadastre, and Obnova requested compensation. So you are saying that land directorate can itself decide that unregistered owner, which is Obnova, is in fact the lawful owner of the rights, and not that the lawful owner of the rights is the one who is registered in the cadastre.
As I explained, and that was also part of my presentation, the LDA was not acting as the administrative body. It was not deciding upon expropriation. It was just participating in negotiations upon the request of compensation. So as sorry.
I think that I can understand from what you said, what your answer to my question actually is. Thank you. And was it possible for Obnova to address the court and ask the court to determine that there was a de facto expropriation?
Just to be precise, you mean by that question to claim declaration that there exists de facto expropriation, or what would be the claim? What would be the claim?
To seek compensation, to go before the court and seek compensation.
Yes, it would be
And
entitled to.
what is the deadline for that claim?
It is not time barred according to Serbian case law, which was provided in the case law.
Thank you. I have a good news, unless my colleagues have any further questions. I don't.
Thank you very much. That was remarkably speedy. Let me turn to redirect. And could you tell me, is it 6 hours of redirect or just 5 minutes of redirect?
I'm tempted to say somewhere in between, but that means
There we
more
are.
like 10 minutes.
Over to you.
I always direct the question to the person who responded to on the point that my question would relate to. One question for you, Dr. Milošević. With respect to the question which was put to you, whether the land directorate could have decided who was the owner. I'm not sure you had a chance to really finish your answer. So could you, I just want to give you an opportunity to explain the issue, whether such a decision was needed and in what context, etc.
Well, the LDA did not and would not decide who is the owner. The LDA would just accept a request, claim for compensation, and in the process, it would let's say, as a preliminary issue, it doesn't rule upon ownership. It just assess whether there are conditions to pay the compensation. That's all.
And on the behalf of what entity does the Land Directorate act in the case at hand?
Sorry, I did not understand the question
Yeah,
quite.
no,
If you
no.
can reform it.
Yeah, my point is, what is the Land Directorate is not, so first of all, what is the Land Directorate?
Okay, the Land Directorate is acting on behalf of City of Belgrade, and it is managing the property which is public property.
And what entity was the registered owner of the property in question at the time when the Land Directorate decided not to pay compensation?
City of Belgrade.
Yes. Yeah. Thank you. Now I have some questions for you, Professor Živković. So first, at 1743, you were discussing with council the conversion right. And if you remember, at the end, you stated, my point is, and then you were interrupted. Could you please state what you wanted to state at that time, if you still remember it, if you don't?
Okay, I do remember. I believe, because I don't have, I suppose to you, the transcript in front of me. But the point with the conversion is that if you have the right of use, then you have of land, then you have the right of conversion. In order to acquire that right, you don't need to have it registered to have it. In order to realize that right, in order to actually get the conversion, you need to follow certain steps. I mean, the legislation is like that because the registration of the right of use was very untidy on the level of the Republic of Serbia. Not all of the socially owned entities had their right of use registered. So therefore, the legislator, when they passed the legislation in 2009, simply decided to say even unregistered right of use gives you the right to conversion, but you need to register first. That I believe that was my point at the time. If I'm wrong, I apologize to all of you.
Thank you. Then immediately thereafter, you went to document R40 and you were asked to look at Article 76 and Article 98 of the Law on Planning and Construction from 2003, which is the document.
I remember.
Could I please ask that this be put on the screen? Okay, so let's look first at Article 76, which states that undeveloped public construction land can be leased by the municipality for a fixed term until it is brought to the intended use through public auction or collection of bids. The procedure, conditions, method, as well as the program for leasing of undeveloped public construction land for a fixed term shall be regulated by the municipality. The person to whom undeveloped public construction land is leased for a fixed term is obliged to submit the main project for the construction of a temporary object. So here I want to focus on the expression temporary object. And if we go to Article 98, it states that the installation of small prefabricated objects onto public spaces is provided and arranged by the municipality, i.e. the city of Belgrade. And so on. And then you were brought to a constitutional court decision that I believe you remember well, which interprets the two provisions. Could you just please repeat again what is your understanding of the constitutional court's holding?
My understanding of the constitutional court's decision is that only these small prefabricated objects mentioned and other objects mentioned in Article 98 could be temporary objects in the sense of Article 76. Because the Constitutional Court said, I don't have the definition of a temporary object. I have Article 76, which speaks about temporary objects. And I think that Article 98 defines the temporary objects. Because temporary means that it's not fixed.
So would it, so this is law from 2003, correct?
Yes.
Yeah. So is there any other definition of temporary object under this or another law which applied in 2003? And by that, I don't mean the law from 2009. I will come to it.
Not that I'm aware of right now. I cannot exclude that there is some reference. I don't know all of the legislation.
But would we refer, well, all legislation, you mean also like building legislation or?
Generally, you ask me generally whether there is a reference. I really don't
No,
know.
I meant a definition, not
No,
reference.
the definition didn't exist, not as far as I know, especially in construction legislation.
And now, if we look at the law from 2009, which I mentioned, that's R201.
That's the 147.
Yes, Articles 146 and 147. We will look at both of them. So we see this law from 2009. What is its relationship to the law from 2003?
It was the successor law. It's basically, it was the law that replaced the 2003.
Yeah.
The main reason for the replacement was the possibility of privatization of land, construction land.
Okay, but let's focus now on these provisions. So if I look at, could you please comment on Article 146 and, to what provision of the law from 2003 is it a successor?
Well, apparently 298.
Yeah. Do obnova's buildings fit into any of the types of buildings described?
No.
Here? No.
Not that applies to 147 as well.
Well, we will come to 147 as well. That's a provision which defines the buildings for which it is possible to issue temporary construction permits, correct?
147.
Yes. Was there a predecessor to 147 in the law from 2003?
I don't think so.
And if we look at 147, I think you stated already, but just to be clear, do obnova's buildings fall into any of the categories?
As far as
which
I know,
are
no.
Put here. Yeah. So, so your testimony is that obnova's buildings do not fit under 146. They do not fit under 147. Are you aware of another definition of a temporary object which would apply under this law from 2009?
In legislation,
no. Is it then, in your opinion, appropriate for a court which decides when this law is valid and enforceable to label obnova's objects as temporary?
No.
Thank you. That concludes my cross-examination.
You mean your yes, your redirect. I think it's a long day for everyone. So that comes to some tribunal questions, and we are going to keep ourselves brief in view of the time. And I will start us off. And I just have two questions which really arise from your opening presentation, but they are potentially quite important. If we could have the presentation on the screen, please, whoever's got control of the screen. You have control, who has control of the screen?
Respondent.
While that is warming up, I can ask you the question because you probably don't need to reference that. But when you were addressing the various court decisions in respect of both tranches, you said, and I'm paraphrasing obviously, the judgment got it wrong. In another case, you said that there was a grave procedural error. And I think that this is, you find this addressed inter alia at your page 25 of your slides, and then again at page 40 of your slides talking about contradictory conclusions. And I would be grateful if you could elaborate briefly on why you consider that they got it wrong. I understand that with respect to one of the judgments or one set of judgments, you spoke about a grave procedural error, but I can hypothesize about a number of different reasons why they may get it wrong. It may just have been a poor decision. There may have been a bending to the will of the city. There may have been a denial of rights. There may have been prejudice. There may have been information that was not put before the court, and insufficiency of information. I think that with respect to the decisions of 2024, you indicated on the slide that the courts concluded that Obnova failed to provide evidence. The appellate court rejected the appeal as unfounded, holding that it was sufficient that the defendant contested the claim in general terms. Now, the tribunal is invited to take a view on the decisions of the Serbian courts, and we, as I've said time and again in these proceedings, these are matters of fact for us, and so we are going to be assisted by the evidence before us. But I'd like you just to develop a little bit further why you considered that the courts got it wrong in those cases where you consider the courts got it wrong. What was the reason behind it? Not the incorrectness, but the reason behind it.
I could answer for the first two decisions. But it's a speculation. Okay. So the one
I will be free to
2024
address you,
okay.
Mr. President. I will speak about the newest two decisions. Yes, and I qualify that as grave procedural error.
Yes.
And now I have, of course, I have to be honest and to say that I didn't assess all the case file. I do not have that under my assessment, but I saw the minutes from the preparatory hearing and I saw the judgments, and the minutes from the preparatory hearing demonstrated the court did not establish all the relevant facts which it ruled upon as disputed. The impact.
And this, just to stop you, this is the new exhibit C740, which is now in the record, but which hasn't been the subject of detailed testimony, but you're now addressing it and it's on the slide there. Yeah.
Yes, the significance of that exhibit is that it shows that the court did not establish these facts because in the preparatory hearing, the court is due to establish which facts are disputed, contested. The reason for that is because we're talking about strictly adversary proceeding. Upon that, the court will see which facts as admitted or deemed uncontested will be established immediately as the established facts, and which one will be the subject of taking of the evidence. only these which are contested in time, which means until the conclusion of the preparatory hearing, not after that, will be the subject of the proceeding of taking of the evidence. And if not proven, then the burden of proof rule will apply. If the facts are not contested, the court is not allowed to go into application of the burden of proof. If the court would act differently, then we have the following situation. We are in dispute, and I didn't contest the main facts upon which you are grounds your claim. And of course, you do not suggest any evidence because your facts are deemed undisputed. And later, during the hearing, I start disputing, and then the court applies the burden of proof. Why grave error? Because this is not just factual issue, issue on taking of the evidence. This goes, by my opinion, to basic controversy principle, because if something is not disputed, I will not offer the proof because I do not have to do that. But if a court allows that in the phase when I am not in situation to provide the proof in the main hearing phase, then I'm not allowed to properly to effectively discuss the case.
So, do I understand correctly that your testimony is that the grave procedural error, as you characterize it, was a grave procedural error of the Higher Court of Belgrade, which the appellate court then failed to correct?
Yes, in first place, it was the error of the first instance court, because I read that, and you can see in the reasoning of the first instance court, you can see detailed reasons for disputing the claim. And that is not what is corresponding with the minutes, which implies that the court probably, I do not know whether it happened or not, but probably included some submissions which was provided after the conclusion of preliminary hearing.
Right, I understand all of that, but the issue of the asserted grave procedural error, or however the appellant would have wished to have dealt with it, was then before the appellate court, and the appellate court rejected the argument which you are now asserting was a grave procedural error.
Yes.
So it's been to two layers of courts, and both of them have rejected it. This appellate court decision was of July last year. I'm assuming that a grave procedural error appeal may be available to a constitutional court, or would it go to a Supreme Court? Is there an appellate structure beyond the appellate court?
Well, yes, it is. It would be Supreme Court revision. And this is when it is considered as a procedural error, which was under the first instance court, which was appealed, and which second instance court did not remedy.
Are you aware as to whether there is an appeal pending in these cases?
No, I don't know. I do not know. I think I do not know.
Don't look to counsel. I want to know whether you know. Counsel on both sides will be able to address us on that, but you're not aware as to whether there is an appeal pending?
No, I am not.
So that's with regards to these two recent decisions of last year. But with regards to the other decisions, where I think the observation was, and I apologies because I'm not sure who it was who testified to this, it was you. When you said the judgment was wrong, I would like to be a little bit clearer in my understanding of why you say the judgment was wrong.
I'm not a judge like Mr. Milosevic, so I'm a law professor, so I have different
standards for saying that courts are wrong.
perception of the court decision. So when I see a 17-pager first instance decision, which has 3 paragraphs on the 16th page of genuine justification, I have a problem with that. I understand that our courts operate that way, and this is something that we need to accept as lawyers in Serbia. In my view, the grave mistake is that both of the reasoning of the first instance, September 2022 decision, and the second instance, appellate decision in December of 2023, is that they have an inherent, antinomy in the very decision. On the one hand, they say, I dismiss your claim. It is temporary. It is not, you cannot own it. It's temporary. I dismiss it. And then they say, and Belgrade is registered, and therefore you're not in good faith. So either Belgrade is registered. The fact of registration should not apply only to the good faith argument on the adverse possession claim, which I admit I got wrong and was claimed. But basically, they simply never considered the fact that it was registered with their own position that you cannot register temporary objects. So it's like, unbearable lightness of justification.
Well, Professor Zivkovic, that's just a fact of life, isn't it, with these national courts decisions? I mean, not in investment cases, but I occasionally act as counsel before the English courts. If I lose, they definitely got it wrong, and there is going to be an inconsistency in the appellate and the first instance. But that decision of the appellate decision of 2023 was not then appealed to the Supreme Court, or
no, this one I believe was.
It wasn't. Do we have that? Because you've just addressed the two, the first instance and the appellate decision. Did it go further?
It was appealed to. This revision was filed against it to the Supreme Court.
And is your evidence to us that the Supreme Court got it wrong as well?
Well, I'm not aware whether as far as I know, the Supreme Court did not yet decide on this.
Right. Okay. Well, that's something then counsel can come back to. But you are not, with respect to those court decisions, asserting in the same way as Mr. Milosevic is asserting, as he characterized it, a grave procedural error. You are saying they got it wrong because there are inconsistencies in the decision.
And the inconsistency is the reason for annulling the decision. One of the spelled out explicitly. But basically, sorry.
Right, but this tribunal is not a tribunal to annul a decision of a Serbian court. I'm trying to establish whether there is a level of gravity in the claimed irregularities that you are asserting, which would engage us. And counsel for both sides will address us on this because we've asked them to specifically. But we will presumptively be engaged if there is a level of irregularity which is significant. We are presumptively going to be cautious if there is inconsistency, dissatisfaction, or whatever. I'm just not inviting your comment, but just to guide counsel a little further. A last aspect, just following from this, and then I have one other question. Unless and until a first instance decision is reversed on appeal or annulled or whatever the right terminology might be, it constitutes, I presume, but I invite your correction, it constitutes a dispositive or authoritative finding of Serbian law. Or is that correct?
When speaking about second instance decision, it is final decision.
I'm not talking about finality. Assuming that it does not go on appeal, a first instance decision, and the higher court, the first instance court, makes the decision and it stays there. That decision is the end of the matter, and it becomes authoritative as a matter of Serbian law you can't have people going around saying, sorry, the court got it wrong. It's the statement of the law or the application of the law to the facts.
Yes, of course. It becomes final. We say pravnosnažna, and it cannot be contested after that by.
Thank you. That's exactly what I was trying to establish. This is my last question, Professor Zivkovic. I don't have the record in the transcript, but I think that you will recall your response to this question from Respondents' Council when there was a discussion about a removal of temporary structures. I think she put to you the question more or less in these terms: if the structure is temporary, is there an obligation to remove? And your response, and at least part of it, I've got the language accurate because I made a note of it. You said, well, yes, there is a normative obligation, but with 2 million temporary structures, hang on, but with 2 million temporary structures, and here I'm interpolating, there's a kind of space between the normative obligation and the reality. Do you recall that exchange?
I do recall.
Okay. So my question to you on the basis of that exchange is, so it's apparent from your evidence, and it's perhaps not so surprising, that there is a difference between the normative obligation, what the law says, and what happens in practice. And that may be for lots of reasons. It may be because the law is only pressed into action because of an objection or a complaint. It may be that the system is overwhelmed. There may be all sorts of reasons. What I would like to know from you is this space between the normative obligation and what's happening in practice with regard to the millions of temporary structures. Is that practice arbitrary, discriminatory, capricious, just uneven, unequal? What is the reason for the space between the normative statutory requirement and the practice?
But first, respectfully, I need to correct you because the question was about the illegal structures, not the temporary structures.
Apologies.
So
thank you for the
illegal structures mean that there are no permits whatsoever. The reasons for this situation, if you want to, it of course ended up in discrimination. We even had the Constitutional Court annul the rules on legalization because they said, listen, now you are enabling these guys to legalize their objects in a procedure which is simpler and cheaper than the regular procedure, by which you are discriminating the ones who went through the regular procedure that happened in 2013. So there are elements of discrimination, of course, and arbitrariness and everything else. But the problem is much deeper than that. Basically, it originated in the 90s, which were not very good years in our parts. And on the one hand, you had the legislation, which was like a Swiss legislation. And on the other hand, you had people and the factual situation with hundreds of thousands of refugees, internally displaced persons who needed to find a home. And, you know, this is the context that I'm making. And most of these 2 million objects are these objects. Of course, you know, then you have somebody who would take advantage of it and make a building and earn some back money on that. But to answer your question and to save time, yes, this discrepancy between normative and practice did create discrimination and gave rise to arbitrariness. But I believe that the state, to be honest, towards it, it's trying to remedy it. It's still a problem. It's been dealt with, and they're trying to deal with it without the discrimination, but it's really difficult.
But let me then just ask a last question on this, and forgive me for not recalling this, but in the sort of 190 or so pages of your two reports, do you at any point advise, conclude that there was discrimination or arbitrariness with regards to the properties that you are that fall within the remit of your expert reports?
No, in the reports, no.
Okay, thank you very much. Those are all of my questions. I have one other observation, and I will. It may also be warranted to direct this to council, but you will recall that I asked you by reference to a couple of the paragraphs in your report to assist us with identifying the circumstances in which you proceeded on the basis of assumptions. Now, I just did a quick search through the documents, and just on the basis of phrases such as "we understand from council" or "on the assumption" or "instructed," I found multiple references, many of them buried away in footnotes. And this does make it rather difficult for the tribunal to understand what it was that you were given by council and you didn't explore yourself. It would assist us. And the question that I raise is whether this should be for you to do or whether this should be for claimants to do through council, but obviously you will assist them. And I think it's more likely the latter. You will assist, but it will come from claimants because we do not want a supplement to your expert reports. I think we would like a statement with references to paragraphs and footnotes indicating what it was that you were instructed on, where you proceeded on the basis of understandings from council or assumptions. In circumstances in which obviously you cannot yourself confirm, but those instructions formed a predicate basis or a foundation for what your report says, because we need to know what is your expert opinion and what is the leitmotif of the case of the claimants. So I'm going to leave that to council to submit with a strict caveat that there are no argumentation. This is simply a reference to. And then one last point arising from all of this, and again, this is to both parties. And again, apologies because this may be somewhere in the record. I don't think it's a terribly complex issue, but just so that the tribunal is clear in its mind, it would be helpful to know what the appellate hierarchy is of the Serbian courts. I understand there's a High Court, Appellate Court, Supreme Court, Constitutional Court. At the heart of this case, because that's obviously going to be material to us. So now let me pass to Professor Douglas.
Professor, I just have one topic, which may have a few little questions attached to it, but the topic is, and I just want to understand the logic of acquiring a property right to land by constructing a building. That's the topic. And this is the problem I have, or the difficulty I have in understanding things. We have an entity with a right of use, and that's a property right, and that's held by the municipality. And at some point, I think we all agree, Obnova had a lease over that land that was granted by the municipality. And in terms of the hierarchy, the right of use obviously is a more powerful right than the lease because one's a property right, one's a contract right. Okay, so Obnova as the lessee asked for a construction permit to build a permanent fixture on the land, okay? And what you say is that once that that construction has been built, once that fixture has been built, then Obnova acquires a permanent right of use over the land under the building.
Generally, yes, but there are details.
Okay, forget that. I'm just trying to understand the logic.
Yes,
Yeah,
that's
okay,
it's
so
a reverse from normal. I concede.
This is the problem I have with the logic, which is that in doing so, Obnova has now acquired a right which is more powerful than the right of the municipality over the same land, without having to consult the municipality. And that's what I find a bit difficult to fathom, because that would essentially mean that Obnova could construct sheds, permanent fixtures in different points of a very large parcel of land without consulting the municipality, and automatically it gets a right over the land which trumps the right of the municipality.
Many of the fortunes in Serbia have been made like that. You have a small shed on a big plot of land. You get.
Okay. The way I could understand it, and I don't think you'll agree with this, but there's one way I could understand this, which is that if I'm the lessee and I apply for a construction permit, I build the fixture. From the municipality's point of view, if I know that a lessee who presents the lease agreement as the right that I have to the land at that point in time, if I know as the municipality that, well, it doesn't really matter that I'm not being consulted, because the only thing that they can do is build a temporary fixture that has to be demolished if required. So in that way, the municipality's right of use is protected, because the only thing that a lessee can do is build temporary objects. So you can see the logic. That makes sense to me. The municipality doesn't need to be consulted, but that doesn't matter, because at the end of the day, the lessee can only build temporary fixtures. But you're saying, I think, that that's not correct, that you can, as the lessee, you can build something, and by virtue of building that thing, you get a right that is higher than the municipality.
Which I consider it is strange, but it is a socialist property law with the immovables. Unfortunately, you need first of all to bear in mind that it was all socially owned. And at the time, basically, there was just nominal for one or the other company. The whole ideology was, we are now assessing it, me also, from today's point of view of a market economy. But it was simply different at the time. It doesn't mean that the law didn't apply, but the law was strange. The municipality, just to finish, excuse me, the municipality could request Obnova to demolish their buildings. They didn't do it. They conveyed the right of use, which they had, to Pristaništa Luka Beograd. And Luka Beograd then made a lease agreement with Obnova without the obligation to demolish. That's the catch, in my view, of course. You will hear other experts claiming something differently, and it's your decision.
Okay. Last part then. If we could go to paragraph 42 of your first report. And this is where you talk about in case there's a conflict between the right of the permanent right of use and the normal right of use, if I can call it. Just wait for it to come up.
Someone calling it up.
Someone calling it up, or am I just?
Do you have it? First report, paragraph 42, page 16.
You have it in hardcover.
No, you now have it. Yeah, you.
I don't think much is happening. I'll just read it out. It says, in case of a conflict between the permanent right of use, and I'll skip a bit, and the right of use of the construction land. Here we are. There we are. So you're saying here the permanent right of use prevailed. The difficulty I have again with this, I've looked carefully and I've probably missed it, but I couldn't find any court decision or other commentary or anything else that talks about this conflict between a permanent right of use and the normal right of use, and what happens in case there is a conflict.
It's not in the report. So there is no case law. There is legal writings, but they're not in the report, unfortunately, so they don't exist as far as you're concerned. But there is a argumentation why. The right of this permanent right of use that belongs to the owner of the building, and since 1965 also to the bearer of the right of use of the building, is a statutory right. It's a right that you get directly ipso iure. It overrides any other rights on the land.
Hasn't there been a single case where someone with a permanent right of use is in conflict with someone with just the normal right of use? And there's never been a case where
no,
this conflict
during
arisen?
socialism, no. And afterwards, in the 2000s, I really can't say, but it was a mess. Honestly, I mean, not because somebody was corrupted or whatever, but it simply was extremely a complicated system that was not changed, and the economy changed to market economy.
Last little question. I assume from reading the materials you referred to that when you build your building and you get the permanent right of use, it's not over the entire parcel of land, it's over the land underneath the building.
It's the land underneath the building and land required for its regular use. This permanent right of use was introduced in 1958 with the law on nationalization of city construction land. They took all the land to the state. They basically nationalized the land. They didn't take all of the flats and the buildings, and they had to recognize, because they then cut the building from the land, and they had to establish some sort of relation between the two, and that is that permanent right of use.
Because it wouldn't make sense if you could build a shed on a 100-acre property and you get the whole.
Listen, I know from personal experience that you have a shed, that a property that is an exclusive location, and you manage somehow to get the right of use.
But in relation to Dunavska 17 and 19, you're assuming, I think, that because you say there was a right of permanent use of the land under the buildings and to give access to those buildings, you're assuming that's the entire.
It's not the
plot of
access,
land.
it's the regular use, but this is not up to me to opine. You know, I'm really not an expert in that. I can tell you the definitions of what's the land for regular use. There is an article on that in the current law, and it was changed in the course of changes of the 2009 law. But basically, it's for somebody else to tell you how many square meters exactly. But my assumption is that it includes the whole land on that plot, which is in possession of.
Thanks very much.
Thank you.
I have also a question for you, Professor, and my first question was very similar to that of Professor Douglas. I have the same type of inquiry into how this works. I understand then, just to complement what he asked you, that independently on how you get the right to use or use of that land, if you build a building with your resources, or it's your building, and it's your building, you have the right. I'm trying to make a distinction between the building and the land, because I understand that you make that distinction in your document, and it seems to me that some of the issues here has to do with when the things get mixed up. And I do recognize that this is property rights within socialist, which makes a bit difficult. So, but I understand that you own the building. Sorry, you build the building. It's not that you have ownership. And correct me if I'm wrong. You have the right
of use.
Of use, right? Of use of
physical person. If I.
No, but let's speak about the case of Nova. So Nova, right, it gets the permit and builds a building, which is brick and mortar, so we avoid any discussion. Offices. So they have, before 2003, right? And correct me if that's before the privatization, that's what I mean.
Yes.
They have the right of use that building.
Yes.
And because, if I understood from the question by Professor Douglas, because they have the right of use that building, they also have the right of use of the land.
Let me try to explain and to simplify.
That's what I'm trying to do. So that would
In
be
my
clear.
opinion, when you construct the building, you get the right of use of the building if you're socially owned, or the ownership of the building, in order to be simple, by the fact of construction.
But it's called right of use, right?
It's called right of use when you were a socially owned entity, a socialist company, such as Obnova was prior to 2003. This is why, whether it's temporary, whether it's illegal, it just depends on whether you'll have to remove it. But in my view, you get the ownership based on Article 22 of the Property Code, of the Socialistic Property Code from 1980, because you created a new object with your own work and your own resources. Whether the object is temporary or not is important for the right to the land, because only permanent structures give you the right to permanent right of use to the land. Of course, the courts, as President noted, dismissed it altogether, and they said when it's a permanent building, then when it's a temporary building, you cannot own it, which is for me incomprehensible. But the whole issue of temporary or permanent is actually important for the land and the rights to the land.
Okay.
Because only permanent objects gives you the right of use of the land, and are deemed, then the land is deemed developed construction land.
Okay. So
And
now,
this land on 47 is deemed as such.
so now is the privatization, okay? And your submission, your evidence is that once the privatization is done, this right of use over the building becomes ownership.
Yes.
As ownership, you know, in terms of private
Private
property.
ownership.
But you have ownership only over the building. I'm right?
Yes, because the Constitution forbade private ownership over the land.
So that is possible in the Serbian legal regime at the time. It's possible to have ownership so over an immovable asset, which is a building,
And not have
and
the
not
ownership.
have the
Yes.
ownership.
From 1958, it was so.
No, I understand, but after the privatization, I
Yes.
mean, so you
Yes.
have ownership, private ownership, but the land still,
True.
but you have a right of use, the land.
You have permanent right of use of land.
And then there is the issue of conversion. I don't want to get
Yes.
into that. I just want to understand that it's possible to have these separate rights of ownership over buildings and still, you know, that land. Good. I have two very brief last things. One is that different legal systems have different role for registration. And some of them is constitutive, some of them is simply informative. What is the situation in Serbia as of, you know, 2003 at least, and how what is the role of the cadastre or the registration?
We have a Austrian tradition of Grundbuch, the land books. That means that the registration when you acquire by contract is constitutive, and when you acquire by adverse possession or ipso iure, then it's declarative. So that means when you buy a real estate, then you need to register in order to be the owner. But when you construct, you get it unregistered, and when you register it, it's only declaratory. That decision on registration is not constitutive, but it's a declaration that you have acquired by construction.
So when you mean declarative, is what? Is informative?
Informative, like in which I don't know to which legal system to refer you of the ones that I know of, but it's the Austrian system is like that, and
no, I know.
In this case of ipso iure acquisition, like inheritance, adverse possession, construction of a new object, and etc., you acquire prior to registration. Registration is simply informative. So
for example, in these 2 million properties that are not registered, if someone wants to buy one of these properties, will have to register in order to get. But
no, but it's a good question, you know. But you can buy illegal objects which are constructed before November 2015 currently, because that's a cutoff date in the last legislation on legalization. In practice, some of the notary publics allow it and verify the sales agreements, but in these cases, you have it in my first report in the first part when I discussed the general issues of law. In these cases, when the real property as such is not registered, the building is simply not there in the registry, the courts and the legislation also, the law on enforcement, also recognizes the unregistered ownership because you don't have a registered house and it exists and you need to protect the owner. I mean, otherwise somebody else could come and, you know, and he wouldn't sell it.
You will not need registration to.
So you
become
don't
an
need registration.
I have one very simple question. I think you were asked about this the privatization program, and you were so it's very late, so I don't want to put more documents, but about the land. But in the line of there is a long list of buildings, right? And it is a word in English, the translation again it says user in one of that. That has it's a very loose term. Has any meaning in your
Well, it's not the owner, it's the user. That's as much as I can answer now from the top of my head.
But if you want, we can put the document. It's better. I mean, it's C15. No, it's in 2.1. 2.1? About 2.1. There, you see?
I'm going to make that bigger, enlarge that for the.
Yeah.
Could you enlarge that? Could you enlarge that for this?
My
ownership
understanding,
status,
my understanding would be, and correct me if I'm wrong, that I'm following your previous question, that considering what was the law at the time, that's what it would be expected, right?
Yes.
That has the right of use over building. Is that correct, or I'm making a wrong assumption?
Could I see the Serbian version? I'm sorry.
Better.
I'm not sure that this attaches to this meaning, but I need to check. Well, it's inconclusive. I wouldn't say that it means definitely that it's a better of a right of use. It can be interpreted in that way, but if you want me to have 100% answer, I cannot
I just
give
wonder
it to you
if we can
to
make
the best of my knowledge, because this can mean that he has a right of use, but then again, it doesn't need to be. It can be something else, and this is something that is prepared by the Obnova itself in 2002 and 2003.
Okay.
Okay. Thank you.
What's the minimum is that it should indicate the possession of.
Okay.
It may mean that it has the right of use, but not necessarily. I cannot say that categorically.
Thank you. Ms. Mihaj, any redirect on the basis of the tribunal's questions within the scope of the tribunal's questions?
No, Mr. President, thank you.
Thank you. Ms. Becker.
Yeah, sorry. So you were just asked to opine on the word user, and you looked into the Serbian original. We will show you a footnote. So we can see that what we, here we have a more fuller description of what was, and we will now show you the Serbian original.
Please.
Well, actually, were the three options. So just for the record, it was ownership, right of use, and the third one, which disappeared before I could read it, but it's not relevant here. And so if we now look at the Serbian version of it, so here we have the table 2.2, and yeah, you'll make it readable. Yeah, so can you?
The footnote 1.
Yes, footnote 1. So it says, it gives the
Bearer
three
of the right of use in the brackets user of real.
Yeah. So having refreshed your memory with that, your answer to the.
Okay, I couldn't because user was used here. Now it's clear, but I didn't know that. But I didn't say that it cannot mean the bearer of the right of use.
No,
I
no,
just,
no.
you know.
Okay, so just this is also a follow-up to a question of Dr. Hanna, but just to make this point clear, because you were discussing the informative versus constitutive level effect of registration. So in the event of acquisition of property rights over buildings as a consequence of privatization, then was the registration of such property rights informative or
acquisition?
And therefore was it informative or constitutive? Now going back to the somewhat thorny subject of whether we can use I would say current economic analysis with respect to what did or did not make sense for the city to do in the 1960s. That follows up on the questions that you got from Professor Douglas. So first of all, this permanent right of use with respect to a company like Obnova, a socially owned enterprise, when was it created?
46. And the permanent right of use was created in 65.
Yeah, and that was done by way of what?
There was a change in the legislation which allowed this permanent right of use not only to the private owner of the building, but also to the bearer of the right of use. This is quite understandable because when they did the nationalization, most of the buildings remained private. And then moving on, they started constructed new buildings and socially owned company constructed buildings. And they also needed this permanent right to use the land because.
So do I understand correctly that in 1958, this right was, what happened is that formerly privately owned land under, let's say, residential buildings in Belgrade was nationalized?
Sorry, I will have to object. First, I think that these are leading questions, and I'm not sure that they are directly related to what was asked by the tribunal.
No, I think they are related to Professor Douglas's inquiry and his expression of curiosity as to how this system works. So I think that can go ahead.
So this is what happened in 58, but the state thought, and I'm just paraphrasing what you said, we need to give the permanent right of use to the owners of the buildings.
Yes, because otherwise either the owner of the land would go with actio negatoria and say demolish the building, or the owner of the building would claim the land.
And then, according to your testimony, the purpose of what happened in 1965 was to extend this existing legal instrument, permanent right of use, also with respect to land needed for regular use of buildings over which socially owned enterprises had the right of use.
Yes.
So, and that was in 1965, that was created by whom? By the
law. I mean, that was a change in, you have it in the.
So it was not created by the city?
No. It was a change, it was a legislative change.
By a ministry, parliament?
By then, I believe, federation. in 1965,
like-
Yugoslavia.
You mean the Federal Parliament of Yugoslavia?
Yes.
Then, okay, so then on Mr. President's questions, he asked you about illegal buildings, the fact that there's 2 million buildings and whether there's any question of discrimination in connection with that. But how many demolitions of illegal buildings are there in Serbia?
Extremely few. And they happened in the early 2000s. Now they actually very, very rarely happen. To the best of my knowledge, I have to make the caveat.
Are you aware of demolitions of buildings which lack some permits but had been standing for 70 years?
No. When they demolish buildings that are newly built.
Thank you. That concludes my.
Thank you very much. I think that brings your testimony to an end. Sigh of relief to you, I imagine. We are much assisted, so much appreciated that you've spent this time, and we have reviewed your reports and the attachments closely, and will continue to do so in the light of your evidence. So much appreciation, and you are excused from your testimony responsibilities.
Thank you very much.
Thank you.
Thank you very much.
Thank you. We have housekeeping, and we're going to be brief on the housekeeping. Who is speaking for respondents on this? Okay. Sorry, is it Mr. Keller? Yes. Okay. What agreement have you reached about Friday afternoon?
So the parties, first of all, I think I speak for both parties when I say, and I really mean it, we are grateful for the tribunal's questions because it helps us focus on the areas of the case that the tribunal is most interested in hearing. Therefore, we agreed to have an afternoon session where each party would have as much time as the tribunal considers appropriate, because also in light of the tribunal's question and so on, we would welcome some directions, which would focus on answering the tribunal's questions. There is one caveat to it, which is that with the tribunal's indulgence, it seems to us that the number of questions we have got is very high. Especially,
I will give you some guidance.
Yeah, exactly. So we were going to actually ask the tribunal for some guidance with respect to maybe some priorities. And we also thought that it could be maybe more efficient to focus on the tribunal's specific questions more than on the first three questions saying, please address the opposing party's case.
You're going to be disappointed because I think it'd be better if it was the other way around. Let me give you some guidance. Sorry, I'm just trying to find a document. Could you just the Okay. Now, I'm going to give you some provisional guidance because the tribunal hasn't had an opportunity to reflect on this together. But I think you ought to have some guidance as you go away from these proceedings. And if the tribunal, once we have had a chance to deliberate on it, want to vary that, we will come back to you quickly by email. So first of all, thank you for revisiting this issue of the Friday afternoon. We are going to have to reserve more than just 15, 20 minutes at the end of the hearing in order to address post-hearing issues. And we also are going to have to work on an assumption that we start the Friday afternoon session as per the schedule at 2 o'clock, at 1400. But I want to allow a little bit of fallow time. So on that basis, what I propose is that each party is allocated 90 minutes, an hour and a half on the Friday afternoon, with the claimants starting off at 2 o'clock for 90 minutes, then we'll have a half an hour break, and the respondent going for 90 minutes. And we will then go into the closing housekeepings, and I've reserved an hour for that. So first question, does that 90 minutes per party seem about right? If we find that we're starting on time, we may be able to push that up a little bit, but I don't think we're going to be able to get away with anything less.
From our perspective, this is more than enough. Our idea also was that we would agree on extensive post-hearing briefs. From my perspective, 1 hour would have been sufficient, but we haven't discussed that with.
Yeah, I think the timing sounds right, but I think I'm not entirely clear what we're supposed to do in the 90 minutes.
Well,
so it's a difficult question to confirm time if we don't know what I'm going to be doing in the time.
Well, I'm really just trying to ascertain whether you would both push for a considerable amount of greater time. But I think 90 minutes is what the schedule will take. It's not going to take much more. So on the basis of that, and again, subject to any variation that we may come back to on, and this is also on the basis of the appreciation which we addressed in the pre-hearing call, and that the parties agreed that there will be post-hearing submissions. We invite you to reflect on the length of those post-hearing submissions, because we are going to give you a word limit, but we will be influenced by what you have to say. So it won't be a word limit of 3,000 words, but it's not going to allow you 100,000 words. So you can reflect between the two sides on that, and also what kind of timing you would like to put to the tribunal. But we will allow you sufficient time in order to produce solid post-hearing submissions. And we would expect, as would be usual, that the post-hearing submissions will be able to you'll be able to address the issues that you think that are most important, that are drawing the threads together, but also points of clarification and small points of detail. Now, on that basis, as we look at the questions that we've put to you, my initial inclination, and the tribunal will reflect further, is that to use that hour and a half to go through small points of technical detail. For example, question 8, the parties are invited to address the meaning of fixed assets in Article 1 of the 1963 lease agreement, is not going to be the most productive use of time. We are the whole, and I think you've got the tenor of some of our questions, we are trying to lift ourselves out of the weeds and look at some of the big picture sort of issues. And on that basis, but it's a matter for each side then to determine what the issues that are that you would like to address. I think it would be appropriate for the two sides to identify key issues in the opposing opening submissions, because this is when they're fresh in our minds, or key issues arising from the witness testimony, because this is when they are fresh in our minds. Going through the list, I would have said, reflect on questions 1 to 3. I would instinctively suggest to you that you defer question 4 to post-hearing submissions. I think question 5 on sort of Eli Lilly is actually quite important because there have been a number of questions about the role of the tribunal vis-a-vis domestic court decisions. So I think you should address that. 6 and the Berkowitz claim, I think we are still struggling a little bit with the time bar issue. This is something that you're going to have to come back to in post-hearing submissions in any event. If there are any observations that you wish to make on Friday, that would be helpful. I think you can address the overlap with the RAND investments in post-hearing. Question 8, I suggest you leave to post-hearing. Question 9, question 10, question 11, question 12, because we've heard more on that, post-hearing. I think question 13, Philip Morris against Australia, that's a bigger issue. You can come back to that. Question 14, post-hearing. Question 15, post-hearing. Question 16, post-hearing. Question 17, post-hearing. I think question 18 would merit a comment on Friday because that goes to what we understand is a central plank of the claimant's case, that the 2013 DRP went beyond the scope of the 2003 RP. So it goes to the whole question of expropriation and what you expected. So I think some comment on that would be helpful. I think you can defer questions 19, 20, 21, and 22 to post-hearing. I think it would be helpful to have a response to question 23, which was Mr. Rand's response to the question that the tribunal put to him about if there was a conversation between Mr. Rand and Mr. Broshko, it would have been, I'm not bothered by the details, you run it, come back to me. I think it would be helpful to have some observation on that. Then there were some additional questions that we added. I think we would find it helpful to hear on Friday some observations about this period between the 23rd, 26th of March and the 26th of April and the issue of the trust, and what turns on that time period. And then the Barcelona traction case you can defer to post-hearing. There may be others that have arisen in the course of today, but this is to give you guidance that what we would like to hear from you on Friday is something that will leave us with a sense of the bigger aspects of the case, leaving the points of detail and clarification or technical aspects to be addressed in slower time in post-hearing submissions. Does that make sense? Is it clear? Yes?
Yes, it is.
For the respondent?
I think it's reasonably clear, but you're also saying it's essentially up to us to pick the points, is that right?
Well, we are saying it's essentially up to you, but I'm also giving you a pretty clear steer from the tribunal, as we've done from the post-hearing submissions, that we would like the concluding session on Friday to at least attempt to draw the threads together of what we've heard over the course of 6 days, because I suspect that you're going to come back to us and say post-hearing submissions in 6 months' time, or whatever, and that it's going to be, whatever, 30,000 words or 50,000 words, and so on. And we don't want to find that we've lost the sense of the hearing. So that's the direction. Okay? Clear. Any other housekeeping before we close?
No, I will just foreshadow that tonight we will make an application for admission into the record of certain documents, both those which were mentioned during the hearing and also some other new documents.
And I'm assuming that if we get an application from you, it's been on the basis that you have tried to reach agreement with a respondent and have failed to reach agreement.
Okay, I thought I think that things which were requested by the tribunal would not need to go through.
No, things that have been requested by the tribunal, you don't need to make an application. You had the issue of the privilege log. I don't know whether you're going to come back to that. On any issue which goes beyond what the tribunal has requested, please first of all try and reach agreement between the two parties. If you can't, submit your application in writing. Let me straight away give the opposing party a direction or an opportunity to respond. If it comes this evening, then a response, let's say, by end of lunchtime tomorrow, and then the tribunal will rule on that.
Understood. Thank you.
Respond.
Thank you.
Okay. I'm looking to my colleagues. Anything else? No? Thank you very much. Have a good evening. We have covered a lot of ground. I think these last days of hearings have been sort of 9 hours, 10 hours, so much appreciated. Have a good evening.